ಅದೇನಪ್ಪ ನಿನ್ನೆ 7 ಇವತ್ತು 32
ಅಲ್ಲ ತಲೆ ಕಟ್ಟಂಗ ಬರ್ಬೇಕು ಸರ್ ಬಂದ್ಮೇಲೆ ಕೊಡಿ. ನಾನು ಸರಿ ಇಲ್ಲ, ನಾನು ಕಿರಿಕ್ ಅಂತ ಹೋಗಿ ಹೇಳಿದಾಳಂತಲ್ಲ ಎಲ್ಲರ ಹತ್ರ. ಯಾರು ಹೇಳಿದ್ರು ರಿಜಿಸ್ಟ್ರಾರ್ ಹತ್ರ ಹೋಗಿ ಹೇಳಿದಾರೆ ನಿಮ್ಮ ಮೇಲೆ ಕಂಪ್ಲೇಂಟು ಅಂತ. ನನ್ನ ಮೇಲೆ ಕಂಪ್ಲೇಂಟಾ? ನನ್ನ ಮಾತೇ ಆಡಿಲ್ಲ, ಏನು ಮಾತಾಡಲ್ಲ. ಸದ್ಯ ಅದೇನೋ ಹೇಳಿದ್ದಕ್ಕೆ ಒಂದಿನ ಜೋರಾಗಿ ಅಲಕ್ಷ ಮತ್ತೆ ಇಲ್ಲಿ ಹೋಗುತ್ತಾ? ಈಗ ಈ ಡಿಸ್ಕ್ಲೇಮರ್ನ ಆಫ್ ಮಾಡಬೇಕಾ?
ಸ್ಟಾಪ್ ಶೇರ್ ಸಾಹೇಬ್ರು ಬಂದಲ್ಲಿ ಮಾಡಿ. ಈಗ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಬರೋವರೆಗೂ ಮತ್ತೆ ಮಾತಾಡೋದನ್ನ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಆಗುತ್ತೆ. ಸೊ ಆಡಿಯೋ ವಿಡಿಯೋ ಸಾಹೇಬ್ರು ಬರೋವರೆಗೂ court. He also doesn't know where about.
But then
That is our best effort. It is the state's duty to.
what court can do, madam, unless the victim is served with notice?
It is the state's responsibility, my lord. We have mentioned the same address as given in the FIR. Beyond that, we are not in a position to take any other action.
You have to ascertain where the victim is staying.
My lord, we have no idea about the whereabouts.
Then what we can do?
Amicus Curiae.
Unless notice is served on the victim.
My lord, Amicus Curiae may be appointed because the appellants have.
Amicus Curiae. Why Amicus Curiae? Amicus Curiae will be appointed only if the advocate on record is not coming and assisting the court. Under that section, court can assist.
Facts of the situation.
No, madam.
My lord, the onus is not on the appellant.
Let the matter come on, say 19th, we'll see. Yes, Henry.
He's in judicial custody, my lord, more than 11 years.
11 years.
11 years, my lord.
Code in final hearing beka. Aayt kodi. Fresh hearing. Give memo. Give memo.
Lord, to recall the NBW, Lord, filing the memo.
Call the NBW.
Please, Lord.
Give memo. Matter will come.
Tomorrow, Lord.
Don't fix the date to the court. You give memo in our court within 2 or 3 days. Each and every memos are posted. You need not go to the court, concerned court also with the file. Yaudar report hakilla antandre I will take severe action against them. Post maddi memo ella.
From page number 8, 31 to 37.
CL number 36, my lord. For the appellant. State court record apply ಮಾಡಿ. Kindly have it next week. 36, my lord.
ಏನ್ ಅಪ್ಲೈ ಮಾಡಿದ್ರಿ?
Depositions apply ಮಾಡಿ.
Suspension of sentence. ಆಯ್ತು. Appellant counsel seeks time. List this matter. State ಬೇರೆ ಇದೆಯಲ್ಲ ಇದರಲ್ಲಿ. State ಏನ ಪಾರ್ಟಿ ಮಾಡಿರಿ? State of Karnataka and others ಅಂತಿದೆ. ಬಟ್ ಇವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರಾ ಇಲ್ಲ? ಆಮೇಲೆ ನೋಡೋಣ. ಅವಾಗ ನೋಡಿದ್ರೆ ಏನಾರು ಆರ್ಡರ್ಸ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡೋಣ. 376 ಇದೆ, 12 years ಇದೆ, 10,000 ಇದೆ, 450 ಅಫೆನ್ಸ್ ಇದೆ. ನೋಡೋಣ. ನೋಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಆಮೇಲೆ ನೋಡೋಣ. 33. ಹೇಳಿ ಏನಾಗಬೇಕು? 33.
Seeking withdrawal of appeal.
Withdrawal of appeal.
ಹೌದು ಸರ್.
ತೊಗೊಳ್ಳಿ. Appellant counsel seeks permission of this court to withdraw the petition with liberty to fresh appeal. ಮತ್ತೇನು ಕಂಗೆ? ಏನ್ ಬೆಂಚ್ ಹಂಟಿಂಗ?
ಇಲ್ಲ ಅಂತ.
Then why you are seeking such liberty?
ಬೇಡ.
ನೋಡಿ ಇಲ್ಲಿ ಬರ್ದಿರೋದು ನೀವು. Withdrawn with liberty to file fresh appeal. ಈಗ appeal ತನಕ ಹಾಕಿರೋದು ನೀವು.
ಅಪೀಲ್.
Argue on merits.
ಅಲ್ಲ,
No.
ಲಿಬರ್ಟಿ ಬೇಡ ಸರ್.
I will not give such liberty.
ಪ್ಲೀಸ್. ನೋ ಲಿಬರ್ಟಿ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನಿದೆ ಹೇಳಿ ನೋಡೋಣ. ಇವೆಲ್ಲ ಬಿಡ್ಬೇಕು ಫಸ್ಟ್. ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ಎಲ್ಲ ಹಾಳು ಮಾಡ್ತಾ ಇದೀರಿ ನೀವೆಲ್ಲ ಸೇರ್ಕೊಂಡು. ಕೇಸ್ ಇದ್ರೆ ಸಿಗುತ್ತೆ ರಿಲೀಫ್, ಇಲ್ದವ್ರು ಇಲ್ಲ. ಈ ಬೆಂಚ್ ಹಂಟಿಂಗು ಇವೆಲ್ಲ ಕೋರ್ಟ್ ಹೋಗೋದು ಮುಖ ನೋಡ್ಕೊಂಡು ಹೋಗೋದು ಇವೆಲ್ಲ ಬಿಡ್ಬೇಕು. ಮುಖ ಹಾಕೋದು ನೋಡ್ಕೊಂಡು ಮಣೆ ಹಾಕೋದು ಫಸ್ಟ್ ಬಿಡ್ಬೇಕು. ಸಾಕಾಗಿಲ್ಲ ಇನ್ನು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮರ್ಯಾದೆ ಹೋಗ್ತಾ ಇರೋದು.
38 to 42, 43 to 45, 46 to 52, 53 to 59.
59.
50? 53. ಹೇಳಿ ಏನಾಗ್ಬೇಕು? ಇದೆಯಾ ಚಾನ್ಸಸ್ ಇದೆಯಾ? ರೆಫರ್ ಮಾಡೋಣ ಲೋಕ ಅದಾಲತ್ಗೆ. Both parties submits that there is a element of settlement and also request to refer the matter to the ಲೋಕ ಅದಾಲತ್ and hence refer to ಲೋಕ ಅದಾಲತ್. ಅಲ್ಲಿಂದ ಬರುತ್ತೆ ನೋಟಿಸ್, ಅವಾಗ ಹೋಗಿ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
59, my lord.
59 ಹೇಳಿ ಏನಾಗಬೇಕು?
2 weeks, my lord. Matter is posted for the first time. State appeal. One is for enhancement, one is for reversal. First appeal was in favor of the accused. 2 weeks. 2017 matter.
Criminal RP.
RP
ನಮ್ಮ ಮುಂದೆ ಬಂದಿದೆ.
ಅದು RP ಮತ್ತು appeal ಎರಡು ಕನೆಕ್ಟ್ ಆಗಿದೆ. appeal first appellate court
senior judge. ಆಯ್ತು ಹೇಳಿ. Why you are seeking time?
2 weeks, my matter was
other side are
SPP.
ಪವನ್ ಕುಮಾರ್ ಇದಾರಲ್ರಿ.
I appear for respondent.
ಪವನ್ ಕುಮಾರ್.
2 weeks first time post ಆಗಿದೆ. I will do it in
First time ಆದ್ರೇನು 2017
17 matter.
ಹಾ,
I will,
no adjournment. Next. Hmm. Hmm.
Excuse me, Jay. Similarly, 22/25/2024, and Dr. Bellu G. Prasad against 13 police staff. That by Mr. Lokesh Kumar.
Whether your matter is listed today?
Yes. It is.
What do you want now?
Pardon?
What do you want now?
I want the case to be heard.
Matter will be heard. Wait.
Okay.
Your matter cannot be taken at 10:30. You wait.
Okay.
Wait. That's all.
Fine. Okay.
Wait. Ah. Huh? List 2 ಹೇಳಿ. ಯಾವ್ದಾದ್ರು ಇದೆಯಾ ಸ್ಟೇಟ್ ಅಪೀಲ್ಸ್? ಮತ್ತೆ ವಿಡ್ರಾಯಲ್ ಮೆಮೋ ಕೊಟ್ಟಿದಾರಾ? ವಿಡ್ರಾಯಲ್ ಅಪೀಲ್ ಅನ್ನ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಪಲೆಂಟ್ ನೋಡಿ, ದ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಫೈಲ್ಸ್ ಮೆಮೋ ಸೀಕಿಂಗ್ ದಿಸ್ ಕೋರ್ಟ್ ಟು permit the appellant to withdraw the appeal along with affidavit. And hence permitted to withdraw in terms of the memo. ಅಷ್ಟೇನಾ? ಬಾಕಿದೆಲ್ಲ refer to ಲೋಕ್ ಅದಾಲತ್.
List 1.
Fresh matter ಕೊಡಿ, ಮೆಮೋ ಕೊಡಿ.
List 1, first time non-compliant, serial number 1, Girish R.
Girish R. ಇಲ್ಲ, complaint counsel is absent, appellant counsel is absent, 2 weeks time granted.
Second time non-compliant, serial number 2, Sham Sundar.
Maintainability, second time, appellant counsel absent, even though matter listed for second time, not made any submission regarding maintainability. However, final opportunity is given if counsel doesn't appear in the next date of hearing, appeal will be dismissed. Is this matter on date kodi?
16/4.
16/4.
3.
Appear for the
Ganesha.
apparent, my lord. The office has raised an objection stating that I have not made the original complaint as a party.
Original?
Complainant as a party.
Ah.
The BEO who lodged the complaint, I made him a party. Now
BEO.
the BEO lodged the complaint, my lord. Now the office is saying I have to made the victim as a party.
Victim, okay? Offense ಏನು?
354D and
Victim party ಮಾಡಿಲ್ಲ ಅಂತ, not the original.
ಅಲ್ಲ ಫಸ್ಟ್ ಇದ್ದಿದ್ದು ಹಂಗೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದ್ದಂಗೆ ಮಾಡಿದೆ.
Guardian of the victim, ಯಾಕೆ victim minor?
ವಿಕ್ಟಿಮ್ ಮೈನರ್ ಸ್ವಾಮಿ.
victim minor ಆರ್ guardian ಮಾಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ. Court cannot issue against a minor.
ಅಲ್ಲ ಅದು ಗೊತ್ತಾಯ್ತು, ಬಟ್ ಒರಿಜಿನಲ್ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಹಾಕಿದ್ರು, ನಾನು ಅದಕ್ಕೆ BEO ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು ಅವ್ರನ್ನ ಮಾಡಿದ್ದೀನಿ.
Victim ಯಾರೋ ಇದಾರಲ್ರಿ?
ಇದ್ದಾರೆ.
ಮತ್ತೆ victim
During the course of the
guardian
day,
party ಮಾಡಿ.
during the course of the day I will do it. During the course of the day I will do it.
Course of the day ನಾ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀರಾ?
ಅಲ್ಲ ಚೇಂಜ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಚೇಂಜ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಚೇಂಜ್?
ಅಲ್ಲ B1 ಮಾಡಿದ್ದೆ, ಮುಂಚೆ ಮಾಡಿರ್ಲಿಲ್ಲ, ಈಗ R2 ಆಗಿ
ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು. ಡ್ಯೂರಿಂಗ್ ದಿ ಕೋರ್ಸ್ ಆಫ್ ದ ಡೇ ಹೆಂಗ್ ಮಾಡ್ತೀರಿ? ನೌ ಯು ಕೆನಾಟ್ be permitted to amend the cast title once it becomes a court records, unless you makes an application. It become court record, part of court record. Now you seek an order to implead ಅಷ್ಟೇ. ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಹಂಗೆ ಮಾಡಿದರೆ ಹಾಕಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ. ಯಾವಾಗ ಬೇಕು?
ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ ಅಥವಾ ಸೋಮವಾರ.
Counsel seeks time to file necessary application to bring the guardian of the minor victim and hence list this matter. Next Monday ಕೊಡಿ.
7/4.
ಹಾಕೊಳ್ಳಿ ಅವರು.
7/4.
7/4.
For dismissal 4.
Dismissal.
Ramprasad BS.
So this matter was listed earlier and also made an observation that office objections are not complied when the matter was listed for 6th time. However, in the ends of justice on cost of rupees 1,500, finally given 2 weeks time and also made it clear that if the cost is not paid and the office objections are not complied within 2 weeks, list the matter for dismissal, and in spite of it not complied and also not paid the cost and hence appeal is dismissed.
Parted in orders 5. Priya Koshi.
Priya Koshi.
Hearing for appellant, my lord. My lord, it is NI Act matter, my lord. On the previous date, my lord, I was directed to procure the medical records of the counsel on record of the appellant in trial court, my lord.
Hmm.
My lord, we have made our attempts to procure the documents, my lord. We have intimated the family, my lord. We have not received the proper response. We are awaiting response, my lord. And at the moment, my lord, all we have is this document, my lord. I'm filing a memo, my lord. This is a copy of Karnataka Bar Council members list of
Produce
dates.
the medical records of the learned counsel on record.
Yes, my lord.
Since he submit that counsel on record was suffering from serious health issues.
Yes, my lord. The late council is based in the rural side of the
ಏನ್ ಮಾಡ್ಬೇಕು
Karnataka.
ಹೇಳಿ
my lord.
ಮೇಡಮ್ ಮತ್ತು ಬೇಕಾ
Yadgiri,
ಏನ್ ಬಾರ್
my
ಕೌನ್ಸಿಲ್
lord, my lord. All we have
ಡೆತ್
received.
ಆಫ್ ದಿ ಕೌನ್ಸಿಲ್
Yes, council, late
counsel
council.
who referred the matter to you.
No, my lord.
ಮತ್ತೆ
The prosecution. We
before the
have,
trial court.
yes, my lord.
ಹಾ.
And we have intimated the family members for producing the
For
documents.
last
my lord.
occasion regarding delay is concerned.
Yes, my lord. Yes, my lord. The late council is from Yadgiri, my lord, Kalburgi, my lord, the rural side of Karnataka, my lord. It is very difficult for us to be there in person and collect the documents, my lord. And we have no assistance as well, my lord. So as present, all we have is the copy of the Karnataka Bar Council, my
That
lord.
is only with regard to the death of the counsel is
Yes, my
concerned.
lord. The
Then
death took place
death on what date?
in the month of August, my lord. She was battling
August which year?
with 2023, my lord.
23.
Yes, my lord. And
ಏನ್ ಲಿಮಿಟೇಷನ್ ಇದೆ ಮೇಡಮ್ ಇದ್ರಲ್ಲಿ ಎಷ್ಟು ದಿವಸ ಇದೆ ಕೊಡಿ 387 days. The counsel for the appellant files a memo along with the endorsement issued by the Karnataka State Bar Council regarding death of counsel on record before the trial court, and the same is taken on record. Issue notice against respondent. Notice overly. ನೋಡಿ ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ.
please, my lord.
ಆಗಿಲ್ಲಲ್ಲ. Issue notice to the respondent. You have not paid the PF to
My
the
lord, on the previous date, I had filed a memo to dispense the notice to the accused respondent, my lord. I was.
respondent.
Yes,
Why?
I had filed a memo to dispense the notice, my lord.
Why, madam?
Because, my lord, they have.
In the absence of respondent, how can you get an order before this court?
My lord, the matter was dismissed soon after
Matter
it
was
was
dismissed.
for non-prosecution. Soon after it was converted to CC, my lord, and the accused had not appeared before the court, my lord.
Trial court, no notice was ordered. Summons was ordered against
No,
the
my lord.
respondent.
No, my lord.
Ah.
And their rights had not been violated in any manner, my lord. Hence, I had filed a memo to dispense the
Have
notice.
you produced the order sheet of the trial court?
Yes, my lord. It is produced along with the appeal petition, my lord.
Along with?
Along with the appeal only, my lord. It is there. My lord, starting from page number 22nd.
23, 13/4/23. No representation for complainant. Peruse the records. There are more than 4 dates of hearing running around for more than 8 months for steps and also for service of summons and the execution of NBW and to furnish the process fee. NBW ಎಲ್ಲ ಆರ್ಡರ್ ಆಗಿದೆ, ನೀವು PF ಕೊಟ್ಟಿಲ್ಲ.
My lord,
But the complainant continuously remained absent in spite of sufficient opportunity were given. The complainant continuously remained absent and failed to take steps. In spite of order process also not paid continuously for several dates of hearing. No doubt it is true that case should not be dismissed either for default or for non-prosecution. But on the other hand, the case has to be decided on merits and appeal controversy between the parties has to be adjudicated finally and effectively. But in this case, the complainant continuously remained absent. This shows that complainant is not interested in prosecuting the matter in nature is summarily is nature in 143, which is required to be concluded in respect of case, but complainant continuously remained absent. Hence, this court has no option but to dismiss the complainant for non-prosecution.
My lord, the late counsel was battling with severe health issues, my lord, and due to which
On
she
what date he passed away, advocate?
passed away in the month of August, my lord. However, she
The
was
month of?
August, my lord.
It was dismissed on 12/7/23
Yes, my lord.
itself.
She was suffering from various severe health issues, my lord, and she was hospitalized as well, my lord. Therefore, she was not in a position to update either the
So
appellant.
what prevented you to appear before the court when the summons was issued long back on 13/9/22 itself? What prevented the complainant to go to the advocate?
My lord, the complainant, the appellant was under the
You
impression.
cannot blame on an advocate, madam.
Yes, my lord, indeed, my lord.
Huh?
I agree with it, my lord. The
Huh.
appellant was of
When the
as-
complainant did not go to the counsel
my lord, the appellant was under the
from
impression, my
22,
lord. The matter,
39/22,
the matter,
dismissal was on 12/7/23, almost up to 10 months.
my lord, the appellant was under the impression, my lord, the matter was taken care of by the late counsel, my
How
lord,
a
regularly, my lord.
advocate can take care unless you assist.
My lord, recently
The
when we
advocate.
came to know about the dismissal, my lord, the appellant approached this honorable court, my lord, within a very short span, my lord. We collected the copies and,
Not short span, madam.
my lord,
For 8 months time was given to take
there
steps.
was another matter, my lord, between the same parties, my lord. That's when the appellant came to know about the dismissal, my lord. And
Heard the matter in part earlier, and this court, when the submission was made, that because of the health issues of counsel could not appear before the trial court and directed to produce the medical records of the learned counsel on record. And now today the counsel has produced copy of the memo along with
Karnataka,
reply given by the Karnataka Bar Council that advocate was no more. And having perused the order impugned, it discloses that for a period of 10 months, steps was not taken, even though NBW was issued against the accused respondent, and PF was not paid, and without any alternative, the trial court dismissed the complaint. However, taking into note of the fact that counsel who was on record before the trial court passed away in the month of August 2023, and this complaint was dismissed on 12/7/23, and due to death of the advocate on record on behalf of the complainant, as well as he was suffering from health issues, and considering the reason assigned in the order and also the submission of the counsel, it is appropriate to set aside the order passed by the trial court and direct the trial court to proceed in accordance with the law against the respondent, since already cognizance was taken and process was issued, and respondent accused was not secured before the trial court, and hence issuance of notice against the respondent accused is dispensed, and directed the complainant to pursue the matter diligently, and accordingly appeal is allowed, and direction is given to the trial court to consider the same in accordance with law.
please, my lord. Priya A.
Still number 6. Orders matter. 5,000 balance ಇದೆ my lord. ಇವಾಗ
Non
ಪೇ
finding
ಮಾಡ್ತೀನಿ.
of proceed for having paid balance amount
ಇವಾಗ
25,000.
ಪೇ ಮಾಡ್ತೀನಿ ಸರ್.
Pass over.
7.
Steps to be
Yes.
taken for making the complainant as R2 by the counsel for appellant.
ವೈ ಎಸ್ ಶಿವಪ್ರಸಾದ್.
ಯಾರು? Y.S. Shivaprasad. You are
ನಿಮ್ದಲ್ಲ,
Shivaprasad.
ನಿಮ್ದಲ್ಲ. ಸೀರಿಯಲ್ ನಂಬರ್ 7. ವೈ ಎಸ್ ಶಿವಪ್ರಸಾದ್.
Y.S. Shivaprasad. Steps to be taken for making the complainant is absent in spite of time was granted on 11/3/23 till date not taken any steps to make the complainant respond. Thoroughly. This court earlier also noted that appellant was absent on 11/3/25. Also, office has raised the new objection to make the complainant as respond number 2, and hence directed to take steps to bring the respond number 2 complainant as party to the proceedings, and adjourn the matter to list the same on 23/25. On 23/25 also counsel was absent and made an observation that in spite of time was granted on 11/3/25 till date not taken any steps, and again finally given 2 weeks time to do this needful, and today also counsel is absent and not pursuing the matter diligently, and hence no grounds to adjourn the matter again, and hence appeal is dismissed.
8. B.M. Mohan Kumar.
Memo for reporting the death of respondent, that is Sri M.G. Shantaraju,
And the respondent is the
on
accused before-
24/7/23.
respondent is the accused before the trial court, my lord.
Hmm.
It's a case against the order of acquittal passed by the trial court.
ಈಗ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಹಾಕಿದ್ದಾರೆ. ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
My lord, the evidence of the parties has been concluded before the trial court. The legality of the order has to be decided by
ಈ
this court. in
ಕೇಸಲ್ಲಿ
the-
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ರಿ?
My
ಡಿಸೈಡ್.
lord, a 2 weeks time may be granted because the complaint
ನಾನು
is,
ಕೇಳಿದ್ದೆ. Counsel for the appellant seeks 2 weeks time to take necessary steps, and hence 2 weeks time granted as sought.
deeply opposed.
9.
Kulkarni Abdul
Sir,
Rashid
appellant,
Sikandar Saab.
kindly pass out.
Huh?
Pass out.
Okay,
A senior.
PF ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ? Issue notice to the respondent.
P.F.
20ನೇ ಇಸ್ವಿ ಮ್ಯಾಟ್ರು, ಇನ್ನು PF ಕೊಟ್ಟಿಲ್ಲ. Notice not served against the respondent.
Pass out ಮಾಡಿ madam.
ಏನ್ ನೋಟಿಸ್ ಆಗಿರೋದು 23 ನಲ್ಲಿ. 23 ನಲ್ಲೇ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. Learned counsel for the appellant submit that similar matter was considered by this court and the matter may be listed on in admission ಅಂತ ಕೇಳಿದ್ರಿ. ಯಾಕೆ ಸ್ಟೆಪ್ಸ್ ಯಾಕೆ ನೋಡಿಲ್ಲ? ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ವಲ್ಲ ಇನ್ನುವೆ. 23 ಆರ್ಡರ್ ಆಗಿರೋದು. ನೋಟಿಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಆನ್ IA number 1 of 2019 and IA number 2 of 19 to the respondent ಅಂತ. Why you have not paid the PF? Notice not issued to respondent for want of PF. ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. ಏನಕ್ಕೆ ಇಟ್ಕೋಬೇಕು ಹೇಳಿ?
Kindly pass out madam.
ಏನಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್?
Senior pass.
2 ವರ್ಷ ಆದ್ರೂ ನೀವು PF ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಆಯ್ತು, ಪಾಸ್ ಓವರ್. Mahantesh Hiremat furnishing of PF along with copy of appeal papers to issue notice to R2.
What's I 6 weeks time, my lord.
Filing of amended appeal memo as per order dated 23/25. Amendment not carried out by the counsel for the appellant as order dated 23/25.
6 weeks time, my lord. So I'll carry out the, I 6 weeks time, my lords. To
Weeks
take-
time,
to take out
ಏನಕ್ಕೆ?
to take out the,
ಅಲ್ಲ ರೀ, why you have not amended?
ಇಲ್ಲ madam,
As
I'll
per the
carry out
order
my-
dated 23/25 and also not filed appeal memo and even not paid the PF also.
ಇಲ್ಲ, ಇವತ್ತು
Why you have
ಮಾಡ್ತೀನಿ.
to keep the matter pending?
ಇಲ್ಲ ಇವತ್ತು ಮಾಡ್ತೀನಿ ಮಾಸ್.
In the connected matter, PF is paid. Amendment will carry it out now. Kindly
Hmm.
pass over.
Hmm.
Carry out the amendment.
But police report not received in respect of proposed R2 in second connected matter also. ನೋಡ್ರಿ ಅದು ವೆರಿಫೈ ಮಾಡಿ ಮೇಡಮ್, ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಏನಾಗಿದೆ ಅಂತ ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಇನ್ ದ ಮೀನ್ ವೆಲ್ ಅಮೆಂಡ್ ಮಾಡಿ,
Please,
ಪಾಸ್ ಓವರ್.
please.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ ನೋಡಿ. 11 police report not received with regard to execution of bailable warrant issued against respondent. ಯಾವಾಗ ಹಾಕ್ತಾ ಇದ್ದೀರಾ? ಕೊಡಿ. Bail bond, bailable ಏನು? Bailable warrant executed and counsel undertakes to file wakalat for respondent. Mr. ಹೆಸರು ಹೇಳಿ. MT Jagan Mohan. And if wakalat is filed for respondent, show the name of the counsel in the cause list for our respondent ಅಲ್ಲ? Respondent list this matter on ಯಾವಾಗಬೇಕು? ಎಷ್ಟು ದಿವಸ ಆಗ್ತಿಲ್ಲ ವಕಾಲತ್? ಇವತ್ತೇ ಹಾಕ್ತೀರಾ? ಹಾಕಿ ಕೊಡಿ, ಡೇಟ್ ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ 17/4.
Seal number 12.
12 maintainability of this criminal appeal, non-compliance of other office objections.
Vellore G. Shivaprasad.
Party in person. ಹೇಳ್ರಿ.
Judge, actually, the party names them itself is wrong. Unfortunately, the staff here in the court, they have not entered all the documents I submitted. The case is actually.
First answer to the court question. The office has raised the objection that this appeal is not maintainable. What is your submission?
It is maintainable because there are facts and law both support my case. And unfortunately, the the lower courts, starting with the city magistrate court in PCR 3055 and then criminal appeal, they have not considered the dismissal of Sarasamba and Prabhakar. See, they have, and even here, they have not listed the party names. So Lokesh Kumar is the number 1 accused. And in fact, Mirg House reported dead about 2.5 years ago. And Mr. Dayananda is not giving me the death certificate. And Sanjeev Reddy is listed as not present or something. The police have not come to the court since nearly 7 years, about more than 6.5 years of
The appellant
filing the
has
case.
submitted a
This
petition.
is a
in
Foreign Corrupt Practice Act case, Judge.
ಕೊಡಿ ಇದು ಪೇಪರ್ಸ್ ಕೊಡಿ ಮೇಡಮ್. ಅಪೀಲ್ ಡಿಸ್ಮಿಸಲ್ ಆಫ್ ಅಪೀಲ್ ಮೇಲೆ ಬಂದಿರೋದು ಇದು. You have already filed an appeal before the sessions court.
Yeah, in fact, I filed 2 appeals, but unfortunately.
Hear me first.
Yeah, please go ahead.
Don't test the patience of the court.
Judge.
You have already filed an appeal before the trial court.
Yes.
That's why
Yeah.
the office has raised the objection that once again,
Yeah.
appeal is not maintainable.
Yeah, it is
Appeal
maintained
against appeal
because
is,
the lower
like-
court has committed an error, serious error in judgment. I've argued all those things.
first you understand.
Yeah.
Don't make submission, yeah. You are.
Judge,
you are.
I'm a
before-
US
you are
citizen. I'm a
before
US
the-
citizen.
You are.
My
before-
language.
First you understand, you are before the court.
Okay.
Already you filed an appeal before
Yes.
the sessions court.
Yes.
That's why the office has raised the objection. Appeal against appeal is not maintainable. That's why you have to comply with office objection. Appeal is not maintainable as against the appeal. First, you have to comply that office objection. Not only that office objection, other office objections are also there. You comply with the same.
I have already complied with all of them. In fact, if I see the internet, they say office objections cleared. Yes, they have put a mark on yes.
ಬಿಡ್ರಿ ನಿಮ್ಮೆಲ್ಲ ಬೀಳ್ತಾನ ಅವ್ನು ಸುಮ್ನಿರ್ರಿ. ಅದೇ
Huh?
ನೀವ್
What is
ಯಾಕೆ
the problem?
ಬೈಸ್ಕೋತೀರಿ ಸುಮ್ನೆ ಎದ್ಬಿಡಿ ನೀವು. ಅದಕ್ಕೆ ನಾನು ವಿತ್ ಪೇಷನ್ಸ್ ಇಂದ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಪೇಷನ್ಸ್ ಅಲ್ಲಿ ಕೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ಏನ್ ಮಾಡ್ಬೇಕು
Judge, this is a matter involving life and death.
Whatever it may be.
We are all US citizens.
14%, Mr. Shiva Prasad, you first understand.
I have understood. What is wrong with that? See, I have appealed here because the lower court judge have made serious error in their judgment.
Whatever it may be, this court will consider whether the trial court committed an error or not.
Yes, that is what I want this court to consider.
First you comply with office objection. Appeal against appeal is not maintainable. If you are not having legal knowledge, then you seek the legal assistance and comply with the office objection. That I can say. If you want to argue more, then this court is helpless.
No.
Or otherwise.
No. What is required? I have gone to the judge. Please hear. I have gone to the your security, your criminal scrutiny department.
No need to go
I am trying to reach Mr. Bharat Kumar, Registrar Judicial. What they are not clear. This is what happened in the district court also. See, office objections. If the registrars they raise, some staff raises an office objection, then I give an answer. And see, who has to? The registrar has to approve it.
Regarding maintainability,
Yeah.
you first comply with the office objection. That's
Yes, I have complied with all the office
all. No
objections.
such a compliance.
Huh?
Appeal against appeal is not maintainable.
Why it is not made? Because the appeal, the previous appeal, where? No, why it is not maintainable is my question.
Once again, I am telling you,
Yeah.
there are legal complications.
Yeah.
You take the assistance of the person who is having legal knowledge, because you are not able to understand what the court is suggesting you. Then
Judge, let me tell you, I have gone to about 70, 80 lawyers
maybe
to take up this case, and they don't want to take up this case. Why? Because the Foreign Corrupt Practices Act case, and even your lower courts have refused to. See, I filed a case against GE and GE.
don't make any submission with regard to the merits of the case now. Now only case is listed for non-compliance. Appeal is not maintainable. You take the legal assistance and correct it. Appeal against appeal is not maintainable. That is the office subjection. You comply it. You comply it, then
Comply it with the office. If they say it is cleared, then it is cleared, is it?
you
I will present my,
you peruse the proviso.
who should I argue with, Judge? Should I go and argue with your criminal
I
scrutiny
cannot give
department?
legal assistance to you. I can consider the matter on merits.
Yeah, please
you
consider
take-
it and
you
merit.
take-
I mean,
you
the
take
opposite party has not appeared. Where are the lawyers? See, they were represented by Mr. Patel, A.N. Patel, if I am not wrong, in 2000, the criminal revision petition 396 of 2022. Where is Mr.
Don't-
Patel? He is absconding
don't-
after that.
don't-
And
Don't make such submission before this court. Here no notice is issued against the respondent. Question of appearance
I
doesn't
mean,
arise.
why it is not issued is by.
The court has to issue notice because now matter is pending for consideration of compliance of office subjection. You first comply. The
Okay, I
office-
will go to the.
You first comply the office subjection, then court will issue the notice to the other side.
Yeah, okay.
Unless you comply,
Yeah.
this court cannot pass any order. You
Okay.
comply it.
Please,
That's
please,
all.
post it for Monday. I will request you to post it because I am stuck up here in India and my family are all have got destroyed. They are actually trying to kill me. This is a Foreign Corrupt Practices Act case. You can see all my arguments from PCR 30.
Comply within 1 week. List this matter on 1 week kodri. Next Thursday kodi. 9/4.
Huh?
9/4.
9/4. Okay, 9/4.
30.
Police report not received in respect of R2. Service ಆಗಿದೆಯಾ? Report received that notice has been served against R2 and hence held sufficient. ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಜಾರಿ ಆಗಿರೋದು?
My lord, I am taking undertaking to file a wakalat, my lord.
ಮಾಡ್ತೀರಾ? ಯಾರು ಕೌನ್ಸಿಲ್?
Rudrappa P, my lord.
ಶ್ರೀ
Rudrappa P, my lord.
ಗುಜ್ರಪ್ಪ.
Rudrappa P.
Rudrappa P.
Yes, ma'am.
Undertakes to file wakalat for R2. Copies ಎಲ್ಲ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಕೊಟ್ಟಿದ್ದೀರೇನ್ರಿ? ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಹೋಗಿದೆಯಾ? And list this matter on next Wednesday ಕೊಡಿ. Wednesday ಬೇಡ, Wednesday ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಲ್ಲ 9/4 ಆಯ್ತು.
9/4.
ಹೇಳಿ 9/4.
16.
ಹಾ?
16.
ಯಾವಾಗ?
16.
16/4 ಆಯ್ತು.
14. ಸರಿ,
Police report.
ಆಗಿದೆಯಾ?
My lord, R2 is present here. ವಕಾಲತ್ ಫೈಲ್ ಮಾಡ್ತೀವಿ.
ವಕಾಲತ್ ಹಾಕ್ತೀರಾ?
Suspension of
ನಿಮ್ಮ
sentence.
ಹೆಸರು?
MN ನಿಂಗರಾಜು.
MN
ನಿಂಗರಾಜು.
ನಿಂಗರಾಜು. Counsel MN Ningaraju undertakes to file wakalat for R2. List this matter.
Suspension of sentence is pending. Any closer?
ಆಯ್ತು ರೀ, ಅದಕ್ಕೆ next Wednesday
Good.
9/4.
15.
SC Bhagwan. Letter seeking extension of time to dispose of OS pending on the file of Sessions Court Bangalore received from so-and-so Bangalore. CRP is dismissed on 4/8/23.
My lord, one submission in this.
ಹೇಳಿ ಏನು?
There is your lordship's order which has attained Supreme Court status. Only complaints of this, the whole suit will come to an end. Lordship's order is very vital, my lord. This is the order.
ಏನ್ರಿ ಲೆಟರ್ ಏನು? praying for extension of time to dispose of.
If this order is complained, my lord, the whole thing will come to an end, my lord. After 20 years of struggle, your lord.
For production of copy of orders and plaintiff evidence in OS number so and so and further to bring LRs of different number 6 so and so. Further, I would like to submit that I have been promoted as district and session judge and I am resumed the charge on 27/5/24. Whereas as per the direction in civil revision petition, this court was directed to dispose of the suit in accordance with law within 6 months. But as I had taken charge on promotion on 27/5/24 and also was posted for training for 2 weeks, July, and now the said completion of the direction period has come to my notice and further in view of clubbing of so and so dated so and so criminal revision as per order dated 11/7, time has been granted for a period of 18 months to dispose of both the matters and obeying the orders of Honorable Court, both matters will be disposed of expeditiously. I have already submitted my explanation on 21/25, but in view of information received from Honorable Karnataka, I have corrected the reference number so and so to civil revision petition number 21 along with my present extension letter, and the same may kindly be considered and accepted. Suit of the year
2003, my lord.
2003.
Madam.
Now case is set down for plaintiff's evidence. Why it is still in pending for plaintiff evidence? And also some of the defendant past events, defendant number 6A to D were brought on record.
Yes,
Bring
madam.
to bring the
This-
LRs
Yes,
on record.
Lordship's order puts an end to everything.
Hmm.
This order which I have produced.
What is the order?
On 22/1/2025, this honorable court orders has passed, my lord.
Transfer of the suit also on court has to take note of such conduct and the appellant is collecting the rent and enjoying the fruits of the property without giving any share to the respondents and having taken note of all these factors into consideration, the trial court passed an order not to collect the rent as well as whatever rent he has collected has to be deposited before the court within the time frame. When such orders are passed, I do not find any error committed by the trial court in passing such an order. Now, this is affirming the order of the trial court.
Yes, my lord. Now, since it is not challenged in the Honorable Supreme Court,
But no
this
such
has
efforts
attained
are
final.
made. From the year 2003 till 2025, no grounds are made out. And what happened then?
Now,
Supreme Court,
2.83 crores. If he doesn't pay, his
whether
defense
this
is
order
stuck
is,
off.
whether this order is challenged before the Supreme Court?
No, my lord. That's why this has attained the Supreme Court status now. Therefore, unless he complies with this order, nothing survives in that suit.
Yes, counsel, why
Nothing
matter is
survives.
still pending?
I have no role to play so far as the trial court is concerned. I appeared for him only in the High Court in this petition. Nothing more to say.
Good. This court has received the letter from the PO on 26/3/2025. Letter dated 17/3/2025, sent through the proper channel, letter dated 26/3/2025. And having perused the order of the PO, it appears that PO took the charge immediately as soon as promoted as principal district judge on 27/5/2024. And this court also granted 18 months time to dispose of the matter earlier. And now the status of the case also, still case is posted for production of the copy of the orders and plaintiff evidence in OS number 15734 of 2003. And further to bring the LRs of defendant number 6A to D in OS number 626520 of 2012. Who appears for defendant number 6A to D? Who appears for defendant number 6A to D before the trial court?
No, I'm for both. Dependent.
6A to D.
No.
Let them come on record voluntarily.
No, my lord. They are not on that, my lord. This order should not become infectious. It is a lifetime order, my lord. Lordship's
It is
order
lifetime order.
means,
Matter has to be considered on merits.
yes, my lord, yes, my lord, but he has to comply with this, otherwise his defense should be struck off, my lord. If a person is not complying with the orders of this honorable court,
Can you seek the proper order before the trial court? For striking of the defense also, if he has not complied the order,
yes, my
you
lord.
file necessary application.
Yes, my lord.
Why you are making such submission before this court?
No, we
Now
are
matter
already-
is listed only for extension of time.
Yes, my lord.
If you have any grievances with regard to the non-compliance of the order is concerned, you file necessary application before the trial court and get an order. Why you are poking your nose here? When the matter is listed for only for the extension of time. Don't make hue and cry before this court. You seek proper order before the trial court. ಏನಾಯ್ತು ಮೇಡಮ್? Bring the LRs of different number 6A to D in OS number 26520 of 2022. Having perused the order also, having perused the letter also, when the order was passed, to consider the matter as early as possible, that is within a period of 18 months from the date of receipt of the said order. And matter was taken up in the month of September. And the LRs of D2 were brought on record. And notice was issued to the LRs. And D2, LRs of D2 being reported to be dead also. And notice was also sent, and hence the trial court issued the notice to the LRs of D2 also. And so also defendant number 6. And in this process could not be able to proceed with the matter. And hence it is left to the defendants to make their own application before the trial court to come on record voluntarily instead of following the procedure, since the suit of the year 2003 and one more suit is of the year 2012. And hence the trial court is directed to dispose of the matter within a time bound period of 6 months from today, taking up the matter day to day basis, since more than 2 decades has been elapsed after approaching the court seeking the relief. The registry is directed to communicate this order forthwith to the trial court.
Ajitesh Shetty.
Non-furnishing of PF issue notice to R12.
Appear for the petitioner. We'll do the needful in the meantime. Week's
Again
time.
needful madadri yak kottilla PF.
Illa, my colleague has done that, my lords. 1 week time kodi, my lords. We'll do the need.
ಯಾರ ಇದಾರಲ್ಲ BL ತೇಜಸ್ ಅಂಡ್ ಸೂರ್ಯ ಎಸ್ ಫಾರ್ R12 ಅಂತ ಇದೆ.
Yes, ma'am.
ಮತ್ತೆ R2 ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಇಲ್ಲಿ. ಯಾರ ಇದಾರಲ್ಲ ಮೇಡಮ್ ಅಡ್ವೊಕೇಟ್?
ಅವ್ರು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, my lords, but they have not appeared before the court.
ಅಪಿಯರ್ ಆಗದವ್ರು ನಮಗೇನು ಸರ್ವಿಸ್ ಆಗಿದೆಯಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರಲ್ರಿ.
My lords.
BL ತೇಜಸ್ ಅಂಡ್ ಸೂರ್ಯ ಎಸ್ ಫಾರ್ R12 ಅಂತ ಇದೆ. Files a memo stating that he could not serve the copy on the respond number 1 since door was locked. The learned counsel submitted that respond number 3 is the managing director. Sufficient. In view of the submission of the learned counsel for the petition, managing so and so, so and so. Learned counsel submit that learned counsel for respond number 2 is served. Submit that learned counsel for respond number 12 is served but not represented. Hence issue notice to respond number 12 ಅಂತ ಆಗಿದೆ. ಬಟ್ ಇಲ್ಲಿ ವಕಾಲತಿಗೆ ಹಾಕಿದಾರಲ್ರಿ, BL ತೇಜಸ್ ಅಂಡ್ ಸೂರ್ಯ ಎಸ್ ಫಾರ್ R12 ಅಂತ ಇದೆಯಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ, ಅವರು ವಕಾಲತ್
Order dated 2/12/2024. Service of notice to R2 dealt with risk of the petitioners. ವಕಾಲತ್ ಇದೆಯಾ? ಅಡ್ವೊಕೇಟ್ ವಕಾಲತ್ ಅಲ್ಲಿ ಇದ್ರೆ ಮತ್ತೆ ಯಾಕೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು R12ಗೆ? ಬರೀ ಹೆಸರು ತೋರಿಸಿದ್ಯಾ? ಅಡ್ವೊಕೇಟ್ R12ಗೆ ಸರ್ವಿಸ್ ಮಾಡಿದ್ದಾರೆ, ಅಡ್ವೊಕೇಟಿಗೆ ಸರ್ವಿಸ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಇವ್ರು ವಕಾಲತ್ ಹಾಕಿದಾರ ನೋಡಿ R12ಗೆ ಇದೆಯಾ? R12 ಇದ್ರೆ ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. R12 is represented through counsel by filing a wakalat and hence no need of issuance of notice against R12. List this matter for admission. Ella service ella complete agideyalla?
Yes, ma'am.
List the admission matter for admission on 17/4.
Grateful, ma'am.
70.
Awaiting service of notice to the R1.
No, my lord.
Respondent number 1, my lord,
ಯಾವಾಗ issue ಆಗಿದೆ?
served yesterday at around 3:30.
ಸರ್ವಿಸ್ ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ದಾರೆ.
ಪಾರ್ಟಿಗೆ ಮಾಡಿದಿರಾ? ಅಡ್ವೊಕೇಟಿಗೆ ಮಾಡಿದಿರಾ?
ಅಡ್ವೊಕೇಟ್ ಸುಪ್ರೀತ್ ಎಸ್ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಸುಪ್ರೀತ್ ಅವ್ರಿಗೆ ಮಾಡಿದ್ದಾರೆ.
The counsel for the ನೀವ್ಯಾರಿಗೆ?
ಐ ಆಮ್ ಅಪಿಯರಿಂಗ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಮಿಸ್ಟರ್ ಸುಪ್ರೀತ್.
ಸುಪ್ರೀತ್ ಕಾ?
ಹೌದು.
ಏನು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, ಅವರ ಸರ್ವ್ ಆಗಿದೆ. ಸೊ ಮಿಸ್ಟರ್ ಸುಪ್ರೀತ್ ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಆನ್ ಬಿಹಾಫ್
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು.
ಪ್ಲೀಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1.
ಏನೋ ಸುಪ್ರೀತ್?
ಎಸ್ ಸುಪ್ರೀತ್.
ಎಸ್ ಸುಪ್ರೀತ್ ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಫಾರ್ R1. R1. Bearer again, madam.
My lord, kindly I am filing a memo
Notice to
for
R2 to R10.
No, my
unable-
lord, I am filing a memo for dispensation, my lord, because they are not
Dispensation.
contesting
Avru?
parties, my lord. Respondent number 1 is the contesting party, my lord.
ಈಗ ಅವ್ರು ಯಾರು contest ಮಾಡಿಲ್ವಾ?
I know, my lord, I'll expert
ಆಯ್ತು ತೊಗೊಳ್ಳಿ. The counsel for the review petitioner files memo, not pressing the review petition against the respond number 2 to
10, my lord.
10 na?
Ah.
2 to 10 and hence dispensed.
Yes.
Notice is dispensed at the risk of the review petitioner
Please.
against R2 to 10.
Yes,
My instructions are that there is a delay. I am permitted to file my objections.
ಹಾಕಿ.
Please.
Delay ಆಗಿದ್ರೆ objections ಹಾಕಿ.
Please.
And ತೊಗೊಳ್ಳಿ. If the counsel as Suprit files wakalat for R1, show the name of the counsel in the cause list. And also counsel seeks time to file objections to review petition. Objections to the IA.
Please.
Delay and hence 2 weeks time granted. List this matter on 17/4.
Please.
Please.
Hearing on IA 18.
For direction, IA 2/25 for permission.
I am appear for appellant in this case.
Yogesh M. Desai, fresh wakalat filed. They are appointed as MSQ. Is direction entry?
NOC ವಕಾಲತ್ ಹಾಕಿದ್ರು ಅದರಲ್ಲಿ previous date of hearing.
ಏನ್ ಐಎಗಳೇನು ಅಂತ ಕೇಳಿದ. IA 1/25 ಏನ್ what is the direction you have sought?
One application filed by appellant permission filing an NOC ವಕಾಲತ್.
Please to ಇದೇನ್ ಮೇಡಮ್ IA 1/25 Davanagere and so and so be offense punishment section Indian Penal Code and section 6 of POCSO Act pending disposal of the top noted.
Suspension of sentence and bail.
Then suspension of sentence.
ಒಂದು suspension of sentence ಒಂದು permission.
ಏನಮ್ಮ ಡೈರೆಕ್ಷನ್ ಅಂತ ಇದೆ?
ಇಲ್ಲ suspension of sentence and bail under section.
So operation of ಏನ್ರಿ ಮೇಡಮ್ ಇದು ಏನು ವರ್ಡ್ ಸರಿ ಇಲ್ಲ. It means that this court be placed to operation of be stayed ಏನು ಇಲ್ಲ. ಏನ್ರಿ ವರ್ಡ್ ಇಲ್ಲ.
Kindly see my IA my lord.
ಆಫೀಸ್ ನವರು ಇದಕ್ಕೆಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ವೈಸ್ ಮಾಡಲ್ವಾ? ಏನು ಸ್ಟೇ ಅಂತ ಕೇಳಿಲ್ಲ, ಡೈರೆಕ್ಷನ್ ಅಂತ ಹಾಕ್ತಾರೆ. ಏನ್ ಡೈರೆಕ್ಷನ್ ಇರಲಿಲ್ಲ, ಇಲ್ಲ ಯಾವ ಡೈರೆಕ್ಷನ್ ಅಂತ ಇಲ್ವಲ್ಲ. IA 1 ಅಲ್ಲಿ IA 2 ಏನ್ ಮತ್ತೆ ಪರ್ಮಿಷನ್ IA 2 ಒಂದಿದೆಯಾ?
IA 2 for permission filing and ವಕಾಲತ್.
ಫಸ್ಟ್ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಆಯ್ತು.
ಅಮಿಕಸ್ ಆದ್ಮೇಲೆ ಸುಬ್ರಹ್ಮಣ್ಯ ಅಂತ ಹೇಳಿ ಅಡ್ವೊಕೇಟ್ ಹಾಕಿದ್ರು.
ಎಲ್ಲಿದೆ ಪರ್ಮಿಷನ್? IA ಯಾವ್ದು? IA 1 ಕೊಟ್ರಿ ನೀವು. IA 2 ಎಲ್ಲಿದೆ? IA 1 ಕೊಟ್ರಿ. IA 2 ಎಲ್ಲಿದೆ? IA 2 ಅದ. ಕೌನ್ಸಿಲ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಮೊದಲು ನೀವಿರ್ಲಿಲ್ವಾ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ?
ಇಲ್ಲ NOC ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ.
ಆರ್ಡರ್ ಏನಿದೆ ಕೊಡಿ. N. Subramanian, learned counsel has filed fresh wakalat on behalf of the appellant. This court has already appointed Amicus Curiae on behalf of the appellant, and unless the order appointing Amicus Curiae on behalf of the appellant is recalled, the counsel cannot be permitted to come on record. ಹೇಳಿ. Earlier Amicus Curiae ಯಾಕೆ ಅಪಾಯಿಂಟ್ ಆಯ್ತು? ಮೊದಲು ಅಡ್ವೊಕೇಟ್ ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ನಾನೇ ಇದ್ದೆ ಪ್ರೀವಿಯಸ್ ಅಲ್ಲಿ.
ಪ್ರೀವಿಯಸ್ ನೀವೇ ಇದ್ರಿ?
ಹೌದು. ನನ್ನ ಹೆಲ್ತ್ ಇಶ್ಯೂಸ್ ಆದ್ಮೇಲೆ ಅಮಿಯಾಕುರಿಸಿನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು. NOC ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದೆ. ಅದಾದ್ಮೇಲೆ ಅಮಿಯಾಕುರಿಸ್ ಆದ್ಮೇಲೆ ಸುಬ್ರಹ್ಮಣ್ಯ ಅನ್ನೋರು ಆನ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಬಂದ್ರು. In the year of 2022 ಅಲ್ಲಿ.
ಈಗ ಇವರು ಸುಬ್ರಹ್ಮಣ್ಯನ್ ಅಲ್ವಾ ಈಗ ಬೇರೆಯವರ? ನಿಮ್ಮ ಹೆಸರು?
ಯೋಗೀಶ್ ಮನೋಹರ್ ದೇಸಾಯಿ.
ಮೊದ್ಲು ವಕಾಲತ್ ಹಾಕ್ದವ್ರು ಯಾರು? ಸುಬ್ರಹ್ಮಣ್ಯ ಅಪೇರ್ ಆದಾಗ ನೀವು ಮಾಡಕ್ ಬರಲ್ಲ, ಅರ್ಲಿಯರ್ ಆಗಿದೆ ಆರ್ಡರ್ ಅಂತ ಅಂದ್ವಿ.
ಹೌದು.
ನೀವ್ ಯಾವಾಗ ವಕಾಲತ್ ಹಾಕಿದ್ರಿ?
ಅವ್ರು NOC ಕೊಟ್ರು.
ಯಾರು? ಸುಬ್ರಹ್ಮಣ್ಯ ನಿಮಗ್ ಕೊಟ್ರಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಈಗ ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ರಿ?
ಹೌದು ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ
ಏನು ಹೇಳೋದೇ ಇಲ್ವಲ್ರಿ? ನಾವೇ ಹೇಳ್ಬೇಕಲ್ಲ, ನಾವೇ ಎಲ್ಲ ಪೇಪರ್ ಓದ್ಕೊಂಡು ಆಮೇಲೆ ಏನು ಅಂತ ತಿಳ್ಕೊಬೇಕಾ?
ಅಪಲೆಂಟ್ ಇಸ್ ಇನ್ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ.
ಹೇಳಕ್ಕಾಗಲ್ವಾ ಅದನ್ನ? ನೋಡಿ Order on IA number 2 of 25 for permission. And earlier counsel on record. ಏನ್ ಜಯಪ್ರಕಾಶ ಮೊದ್ಲಿದ್ದರ್ ನೀವಲ್ಲ?
ಫಸ್ಟ್ ಜಯಪ್ರಕಾಶ್, ಸೆಕೆಂಡ್ ನಾನ್ ಬಂದಿರೋದು.
ಸೆಕೆಂಡ್
ನಾನ್ ಬಂದಿರೋದು.
ಸುಬ್ರಹ್ಮಣ್ಯ
ಅಮಿಯಾ ಕುರಿಸ್ ಆದ್ಮೇಲೆ ಸುಬ್ರಹ್ಮಣ್ಯ ಬಂದಿರೋದು. ಅಮಿಯಾ ಕುರಿಸ್ ಆದ್ಮೇಲೆ ಸುಬ್ರಹ್ಮಣ್ಯ ಬಂದಿರೋದು.
ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಆದ್ಮೇಲೆ ಈಗ ನೀವು ಈಗ ಮತ್ ನೀವೇನೆ ಅಲ್ಲಿಗೆ 3 ಜನ ಆಯ್ತು. ಈಗ ಜಯಪ್ರಕಾಶ್, ಆಮೇಲೆ ನೀವು, ಆಮೇಲೆ ಮತ್ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಆದ್ಮೇಲೆ ಮತ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಆದ್ಮೇಲೆ ಮತ್ ನೀವೇನೆ. ಹೌದಾ? ತೋಳಿ on record did not appear before this court and hence this court appointed the amicus curiae to assist the court on behalf of the appellant, and later on counsel H.V. Subramanya filed wakalat, and this court directed unless the appointment of amicus curiae order is recalled, question of permitting the H.V. Subramanya advocate to appear on behalf of the appellant doesn't arise. Now again, the very same Subramanya gave no objection to the earlier advocate, and earlier advocate now files an application for recalling the order. Amicus curiae ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿರೋದ್ರಿ ಇದು? ರಿಕಾಲ್ ಕೇಳ್ಬೇಕ್ರಿ ಆ ಆರ್ಡರ್ನ, ಬರೀ ಪರ್ಮಿಷನ್ ಕೇಳೋದಲ್ಲ. ಅಮಿಕಸ್ ಕ್ಯೂರಿಗೆ ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ? ನಿಮ್ಮನ್ನೆಲ್ಲ ದೇವ್ರೇ ಕಾಪಾಡ್ಬೇಕು, ನಿಮ್ಮನ್ನು ದೇವ್ರು ಕಾಪಾಡ್ಬೇಕು, ಹಂಗೆ ನಿಮ್ ಕ್ಲೈಂಟ್ಗಳನ್ನು ದೇವ್ರು ಕಾಪಾಡ್ಬೇಕು. ಅಂದ್ರೆ ನೀವೇ ನೋಡ್ಕೊಂಡು ಆರ್ಡರ್ ಬರೀರಿ ಅಂತ. ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿದೆ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅದನ್ನು ನೀವೇ ಓದ್ಕೊಳ್ಳಿ, ನೀವೇ ಆರ್ಡರ್ ಬರೀರಿ, ನಾವು ಬಂದು ನಿಂತ್ಕೊತೀವಿ, ಫೀಸ್ ಇಸ್ಕೊಂಡು ನಿಂತ್ಕೊತೀವಿ ಕೋರ್ಟ್ ಮುಂದೆ ಅಂತ. 14/12/23. And this court wide order dated 14/12/23, having taken note of the fact that appellant has been in custody since 12/9/2018 for more than 5 years, as against the sentence of 10 years rigorous imprisonment, and counsel for the appellant did not appear. Illa madam, idರಲ್ಲಿ ಎಲ್ಲಿದೆ ಅಮಿಕಸ್ ಇದರಲ್ಲಿ having taken the said fact into consideration, directed Sri Narayana Swami HR, learned counsel appointed as amicus curiae. ಇಲ್ಲ ರೀ, ಇದು ಆಬ್ಸೆಂಟ್ ಅಂತಿದೆ. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಬೇರೆ ಆರ್ಡರ್ ಇದೆ ನೋಡಿ, ಅದು ಆಬ್ಸೆಂಟ್ ಅಂತ ಬರ್ದಿರೋದು. ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಆಗಿರೋದು ಯಾವಾಗ ಕೊಡಿ. ನೀವೆಲ್ಲ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕ್ರಿ ಯಾವಾಗ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಆಯ್ತು, ಆಮೇಲೆ ಯಾಕೆ ಇವು ಕುಡ್ ನಾಟ್ ಅಪಿಯರ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ಹೋಗ್ಲಿ, ಏನಾರು ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಏನಾರು ಹೇಳವ್ರ ಇವರು ಪರ್ಮಿಷನ್ ಅಲ್ಲಿ?
ಕೇಳಿದ್ದೀನಿ.
4/2/22 ನಲ್ಲ ರಿಜಿಸ್ಟ್ರಿ ನ ಏನು ಬರ್ದಿಲ್ಲ ಇವ್ರು ನೋಡಿ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಬಂದ್ರು ಪರ್ಮಿಷನ್ ಅಂತ. ಕೌನ್ಸಿಲ್ ಹೋಗಿ ಕೌನ್ಸಿಲ್ ಅಂತ ಮಾಡ್ಕೊ ಬರ್ತೀರಿ, ಒಂದ್ ಕರೆಕ್ಷನ್ ಮಾಡಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ. ಅವ್ನ ಯಾವನೋ ಟೈಪಿಸ್ಟ್ ಕೇಳ್ತೀರಿ, ಅವನೇನೋ ಹೊಡಿತಾನೆ, ನೀವು ಅದನ್ನ ನೋಡೋದಿಲ್ಲ. ಯಾಕಂಗ ಆಗೋಗ್ಬಿಡ್ತೀರಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್? ಕೊಡಿ ಮೇಡಮ್ ಡೇಟ್, ಹೋಗ್ಲಿ ನಾವೇ ನೋಡ್ಕೊಂಡು ಬರೆಯೋಣ ಆರ್ಡರ್. And this court appointed the counsel Sri Narayana Swami HR as amicus curiae wide order dated 18/1/22. And now the regular counsel files the application and affidavit, and having taken note of the reasons assigned in the application, permitted to file wakalat and directed to our assistance quota or amicus curiae ಯಾವ ತರ ಅಪಿಯರ್ ಆಗಿದಾರ ನೋಡಿ. ಅದ್ರ ಮೇಲಾದ್ರು 2,000 ಫೀಸ್ ಕೊಡೋಣ ಅವ್ರಿಗೆ ಅಪಿಯರ್ ಆಗಿದ್ದಕ್ಕೆ. ಬಂದವರ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗ್ಲಿ ಅಮಿಕಸ್ ಕ್ಯೂರಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಆಬ್ಸೆಂಟ್ ಅಂತ ಬಂದಿದೆ, ಯಾವಾಗ್ಲೂ ಬಂದಂಗಿಲ್ಲ ಅವ್ರನ್ನು. ಆಯ್ತು, ಆಮೇಲೆ ಆಯ್ತು, ಆಮೇಲೆ ಬಂದ್ರ ಕೋರ್ಟ್ಗೆ. ಇದ್ದಂಗಿಲ್ಲ. Absent ಅಂತಲೇ ಇದೆ. And even Amicus Curiae also not assisted this court, and hence question of payment of fee of Amicus Curiae also not necessary, and hence permitted to assist the court, permitted to file ವಕಾಲತ್. ಯಾವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ?
ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಬೇಲ್ ಹಾಕಿದೀನಿ ಸರ್.
ಅದ ಆಮೇಲೆ ನೋಡೋಣ.
ಕನ್ಸಿಡರ್ 6 years 6 months.
List this matter on 17. ಈಗ ಜ್ಞಾನೋದಯ ಆಯ್ತಾ? 22ರಿಂದ ಏನು ಜ್ಞಾನೋದಯ ಆಗ್ಲಿಲ್ಲ ನಿಮ್ಗೆ?
6 years 6 months 22 days.
17/4.
19.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಷ್ಟೇ. 19.
Praveen C.
Condone the delay of 28 days in filing. Notice ಇದು ಬರೀ ಸ್ಟೇಟ್ ಮಾತ್ರನ ಪಾರ್ಟಿ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ we had to make a statement. ಇದು SC/ST ಆಕ್ಟ್ ಇದೆ.
ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀನಿ ಆಲ್ರೆಡಿ.
ಹಾಕಿದಿರಿ ಈಗ?
ಹಾಕಿದೀನಿ. To pay the process, there should be an order from this.
Process ಈಗ ಬೇಡ, ಆಮೇಲೆ ಅಲೋ ಮಾಡಿದ್ಮೇಲೆ. Statute itself says they have to be made as party. Heard the counsel appearing for the appellant on IA number 3 of 25, wherein prayer is sought to implead the respond number 2, and very statute itself says that an opportunity has to be given to the victim or complainant before hearing the matter in view of the special enactment, and hence IA is allowed. Appellant counsel is permitted to amend the cast title, issue notice against respond number 2
Through SP,
on main and also on IS.
Through SP Tumkur anta.
And also directed to furnish one more copy to the additional SPP to serve the copy of this appeal memo on R2 through SP of
Tumkur.
SP of Tumkur. ಕೊಟ್ಬಿಡಿ ಈಗಲೇ ಅವ್ರು ಕಳಿಸ್ತಾರೆ.
ಎಲ್ಲ ಕೊಟ್ಟಿ.
List this matter on 21/4.
20. P. Swaroop.
Special leave granted. Issue notice against respondent and issue notice against respondent. And meanwhile, registry is directed to get the records and list this matter immediately as soon as records are received.
21. Karunakara P.
Suspension of sentence.
ಹೇಳ್ರಿ.
ಸರ್ವಿಸ್ ಆಗಿದೆ. ಶ್ರೀಕಾಂತ್ FR R2. ನೀವು ಇದ್ದೀರಾ? ಹೇಳಿ ಏನು? ನೀವ್ ಹೇಳಿ ಫಸ್ಟ್.
ಶಾರ್ಟ್ ಟೈಮ್
ಏಕೆ?
ಸೀನಿಯರ್ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್.
ಸೀನಿಯರ್ ಇಲ್ಲಿ ಯಾವ ವಕಾಲತ್ ಹಾಕಿರೋದು ಹೇಳಿ? ಬೇಲ್ ಮ್ಯಾಟರ್ ಇದಲ್ವಾ? ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್. ಸೀನಿಯರ್
ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇದೆ.
ವಕಾಲತ್ ಹಾಕಿರೋದು ಯಾವಾಗ್ರಿ ನೀವು? ಕೇಸ್ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಬಂದಿದೆ.
ಫೈಲ್ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ.
ಫೈಲು ಇಲ್ಲ ನಿಮ್ಮ ಹತ್ರ ಈಗ? ವಕಾಲತ್ ಹಾಕಿರೋದೇ ಈಗ ಮೊನ್ನೆ ಆಗ್ಲೇ ಮಿಸ್ಪ್ಲೇಸ್. ಕನ್ರಿ ಯಾವತ್ ಬೇಕು ಹೇಳಿ?
ನೆಕ್ಸ್ಟ್
ತಗೊಳ್ಳಿ. R2 counsel seeks time on the ground that file is misplaced and finally given an opportunity list this matter on 9/4. 9/4 ಮತ್ತೆ ಫೈಲ್ ಇಲ್ಲ ಅಂತ ಹೇಳಂಗಿಲ್ಲ. ಪಾಂಡುರಂಗ ನಾಯಕ್.
20.
Recalling the order dated 14/2/25 above dismissed for non-compliance of office objection on 14/2/25. Counsel ಇಲ್ವಾ? ತಗೊಳ್ಳಿ. This matter is listed for consideration of IA number 1 of 25. First time ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್. After application ಹಾಕಿದ್ಮೇಲೆ. And even in spite of application is filed for recalling of the dismissal order, counsel is not pursuing the matter diligently. However, in the ends of justice, one more opportunity is given. List this matter on 9/4. Even if counsel doesn't appear on the next date of hearing, the IA will be rejected. List this matter on 9/4.
23.
Mahesh Chaudhary.
This is an application for stay of conviction, Madam. I am
They are?
stay of conviction.
Conviction.
ಏನಾಗಿದೆ ಸ್ವಾಮಿ, the sentence has been suspended, Madam. Sentence has been suspended.
ಏನು offense ಏನು? Objections ಆಗ್ತಾ
Under
ಇದೆ. ತಗೊಳ್ಳಿ. Counsel for respondent has filed a statement of objections and copy serve ಮಾಡಿದಾರಾ?
ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
Copy served on the other side. Ready ಇದರಾ ಏನು?
Yes, ready, Madam.
ಹೇಳಿ.
It's a very short point, Madam. It is a case, Madam, where a prosecution was initiated against the employee of who was working as superintendent of customs, Madam, under the Department of Revenue and Finance, Madam. In short, he was a customs officer. Madam, the allegation is that, Madam, there was disproportionate asset when a search was conducted. Initially, Madam, they quantified it to be at they quantified it to be some 109%.
109%.
And then, Madam, initially, I'm sorry, Madam, it was quantified at 61.94%. The trial, my lords, after conclusion of the trial, it was held that, my lords, he's holding 56.66% only. That, my lords, would get at internal page number 67 in the judgment, my lords. My lords, the crucial part is that, my lords, number one, in statement A, B, C, D, ಯಾವ್ದನ್ನ ತಗೋಬಾರ್ದು ಅದನ್ನ ತಗೊಂಡು ಅಥವಾ ಆಡ್ ಮಾಡಿ ಅಥವಾ ಯಾವ್ದು ಬಿಡ್ಬೇಕೋ ಅದನ್ನ ಆಡ್ ಮಾಡಿ they've come to the conclusion, especially in the income statement.
ಮೆರಿಟ್ ಮೇಲೆ ಏರ್ ಮಾಡೋಣ ಬಿಡಿ, ಯಾವಾಗ ರೆಡಿ ಇರ್ತೀರಿ? Why you want?
That's why I'm seeking. ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ, I am a retired employee.
ಆಯ್ತು.
Pursuant to the order, my lords, because the conviction is not stayed, it has ended up, my lords, being my pensionary benefits are taken away. That's the reason I'm seeking for conviction.
Conviction stay adre, and then you are entitled for the pension also.
See, sir.
Then
ಏನಾಗಿದೆ ನನ್ನ financial condition.
If appeal is dismissed, again recovery proceedings has to be initiated.
That's ಇದು ಅಂತ ಇಲ್ಲ. ಒಂದೇ ಒಂದು ಚಿಕ್ಕ submission.
You argue on merits. Consider it instead of considering this application and objections. ಇದಕ್ಕೊಂದು 15 ದಿವಸ ಸ್ಪೆಂಡ್ ಮಾಡೋ ಬದಲು 15 ನಿಮಿಷ ಒಂದು 3/4 ಗಂಟೆ ಸ್ಪೇರ್ ಮಾಡೋಣ. ರೆಡಿ ಇದ್ರೆ ಇವತ್ತೇ ಏರ್ ಮಾಡ್ತೀನಿ ಹೇಳಿ.
ನಾನು ಒಂದೇ ಒಂದು ಮೇನ್ ಮೇಲೆ ಹೋಗಬಹುದು, ಬಟ್ ಐ ಟೆಲ್ ಯು ವೈ ಐ ಹ್ಯಾಡ್ ಟು ಇನ್ಸಿಸ್ಟ್.
Already sentence is suspended. Now you are seeking for staying of conviction order. Merits ಮೇಲೆ argument
ಮಾಡಿ. I have a 35-year-old son who is suffering from his autistic, and I do not have money to even
you
take
argue
care
on
of
merits. Records ಬಂದಿದೆ ಮೇಡಮ್?
ನೋಡಿ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಸ್ವಾಮಿ.
ರೆಕಾರ್ಡ್ಸ್ ಇದೆ, ಇನ್ನೇನು ಪೇಪರ್ ಬುಕ್ ರೆಡಿ ಇದೆ, ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ರೆಡಿ.
Let's have it any time after.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ, ನಿಮ್ ಡೇಟಾ ಕೊಡೋಣ.
15 minutes.
Instead of considering IA number 1 of 25, 1 of 25 matter can be considered on merits. ಹೇಳಿ.
If this can be considered, that's
no
because of
counsel
his financial.
ಹೇಳಿದ್ನಲ್ಲ, ಆಪ್ಷನ್ ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ, ನೀವು ಹೇಳಿದಾಗ ಕೇಳ್ತೀವಿ ನಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ನ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅಕ್ವಿಟ್ ಮಾಡೋಣ, ಕೇಸ್ ಇದೆ ಅಂತಂದ್ರೆ ಕನ್ಫರ್ಮ್ ಮಾಡೋಣ ಆರ್ಡರ್ ಅಷ್ಟೇ.
That's a very
You are not ready to take the orders on merits. Now you want only the stay of conviction.
I was only seeking to take care of my son. That's the accusers only looking out take care.
Merits ಮೇಲೆ ಡಿಸೈಡ್ ಆದ್ರೂ ಮಾಡಬಹುದು.
ಹೌದೌದು
ಮಾಡಬಹುದು. You can take care of your son also.
That's may have it.
21st 22nd ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
That's 22nd.
22nd 22/4.
ಏನಾದ್ರು ಫೈಲ್ ಮಾಡಂಗಿದ್ರೆ ಮುಂಚೆನೆ ಕೊಟ್ರೆ.
ಏನ್ ಫೈಲ್ ಮಾಡಕ್ ಮುಂಚೆ?
ಫೈಲ್ ನಿ objection
ಅಲ್ಲ ರೀ, ನೀವು ಮುಂಚೆ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಶುರು ಮಾಡಬೇಕು ಅವರಿಗೆ.
ಈಗ ತಂದು ಕೊಟ್ಟೆ, ಇವಾಗ ಮಾರ್ನಿಂಗ್ ಏನಾನು ಕೊಟ್ಟಿರಬಹುದು. That's because it may help us to.
They should also go through what objections you have raised anta alwa. Principles of natural justice.
Correct. Not saying ಈಗ ತಂದು ಕೊಟ್ರು, CBI ಇಂದ ಬಂದಿದೆ, IO signature.
Right.
Grateful.
Next party in person Ravi Kumar Rajendra Prasad, CD of 93 days. Deepak Bhaskar for R5 and R6, Sanjay Krishna for R3, Ashok B Patil for R4.
Those IA copies are not served on this. R3 ಗೆ IA copies serve ಆಗಿಲ್ಲ.
R5 ಮತ್ತು R6
copies I served.
IA copies.
I have it as additional copies. I have served it along with the note.
No, it has not come. It has not come. Only
main appeal they have given.
Main appeal.
Counsel for respondent submits that IA copies are not served, and hence the party in person is directed to serve the copy of IA number 2 of 24 and IA 1 of 2024 forthwith. ಈಗಲೇ ಕೊಡ್ರಿ ಅತ್ಲಿಗೆ ಆಯ್ತಲ್ಲ?
ಕೊಟ್ಟಿದೆ.
ಆಯ್ತಾ? ಇಬ್ಬರಿಗೆ ಬಂತಾ? ಯಾರ್ಯಾರಿಗೆ ಬಂದಿಲ್ಲ? ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗೋದು?
5 and 6 for Deepak Bhaskar.
Furnish the copies to the counsel for R5
6.
R6. You are appearing for whom? Counsel? R3 and also to R3 and R4. ನಿಮಗೆ ಕೊಟ್ರ ಕಾಪಿ?
One more IA copy, that is
ಯಾವುದು?
condonation of delay.
Condonation of delay 93 days ಇದೆ.
2 we have not received IA number 1.
Stay ಕೊಟ್ಟಿಲ್ಲ, ಬರೀ condonation of delay.
Stay application ಕೊಟ್ಟಿಲ್ವಾ?
What ಅಂತ ಗೊತ್ತಿಲ್ಲ.
What of the note?
No, this is IA 2.
IA 1.
Lordship, I will serve it.
ಈಗ ನಿಮಗೆ ಬರೀ ಡಿಲೇದ್ ಮಾತ್ರ ಕೊಟ್ರಾ?
ಡಿಲೇ
ಇಬ್ಬರಿಗೂ 3 ಜನಕ್ಕೂ ನಿಮಗೆ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಬಂದಿದೆ ಇಲ್ಲ? ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ whom? R4 and also the ತೋಳಿ And all the respondent counsel submits that they have received only copy of IA number 2 of 24, but not furnished the copy of IA number 1 of 2024. And hence directed to serve the copy,
Will serve.
all the advocates forthwith. List this
Yes, my
matter
lord.
on.
Your lordship, with the leave of the court, can I file IA3?
What is, you file it in the registry.
I will do it.
List this matter on 9/4. You furnish copy today itself, stay application.
Yes, yes.
Or otherwise I will list this matter on 16th.
17th.
17th, right, 17/4. Whatever now you are going to file another IA, you serve the copy on the other side. You take the acknowledgement. They may say in the next date of hearing, copy is not served.
Yes, your lordship.
Right. Next, 25, T Prakash, KV Prakash, 350 days delay. Delay again. Appeal.
It's a 439.
Bail matter delay 350 days.
Bail matter.
Okay. ಏನ್ರಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದೀರಾ ಅಥವಾ ಹಾಕ್ತೀರಾ ಏನು ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಗೆ?
1 week time.
1 week time. Counsel for R2 seeks 1 week time to file objections to IA 1 of 25. State ಹಾಕ್ತೀರಾ only oral objections? And additional SPP submits that going to raise the oral objections at the time of hearing IA number 1 of 25, and hence this matter on 16th 17th ಯಾವಾಗ ಬೇಕು? 17/4.
26 Deepak Bhaskar.
IA 1 of 25 CD is not pressed and hence IA is dismissed. Delay ilva?
ಇಲ್ಲ madam.
ಆಯ್ತು ತಗೊಳ್ಳಿ. Heard on IA number 2 of 25 for seeking special leave and on perusal of grounds urged in the application as well as the appeal is filed against the order of acquittal, and hence the leave is granted as sought. Issue notice against the respondent. In the meanwhile, registry is directed to get the records of trial court and list the matter for admission as soon as records are received.
Grateful.
27
Next,
Prithviraj PM.
For the appellant.
delay ಇದೆ ಇದರಲ್ಲಿ
43 days.
ಏನು 138
138.
ಆಯ್ತು. ಡಿಲೇ ಇದು ಸ್ಪೆಷಲ್ ಲೀವ್ ಗ್ರಾಂಟೆಡ್ ಮೇಡಮ್, ಅದೇ ಸೇಮ್. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆನ್ IA number 1 of 25 and also on main against the respondent, and in the meanwhile registry is directed to get the records of the trial court and list this matter as soon as records are received.
28 Srinivas NC.
Srinivas NC, ಹೇಳ್ರಿ ಏನಿದೆ special leave?
Appellant my lord.
Special leave granted as sought for the reason stated in the accompanying application and affidavit. ಹೇಳಿ ಏನು IA 2 ಏನು?
IA2 is seeking an order of stay of the impugned order.
Punishment ಆಗಿದೆಯಾ?
Punishment ಆಗಿಲ್ಲ, acquit ಆಗಿದೆ my lord. This is victim's appeal.
Victim's appeal.
The learned trial judge has ordered to recover the compensation amount awarded by the state government. So because the SC/ST Atrocities Act is also there, the compensation is awarded under that act.
ಆಯ್ತು. Whether you have supported the case before the trial court or not?
Yes, my lord.
You have supported?
Yes, not hostile, my lord.
Not hostile.
We have fully supported, my lord.
But only benefit of doubt given to the accused at the time of
for the
acquitting.
discrepancies of in the evidence, the accused has been acquitted, my lord.
Only on discrepancy.
Discrepancies.
Support.
The learned trial judge has relied upon two decisions to arrive at this conclusion, my lord. One is reported one is Triple X versus member secretary reported.
Support ಮಾಡಿದಿರಿ ಅನ್ನೋದಕ್ಕೆ ಏನಾದ್ರು ಡಿಸ್ಕಷನ್ ಇದೆಯಾ ಇಲ್ಲಿ? ಯಾವ್ದಾದ್ರು
Support
ಪ್ಯಾರಾಗ್ರಾಫ್
in deposition ಅಲ್ಲಿ ಇದೆ, madam.
Now you are seeking for stay of
the
ordering to
recovery proceedings.
refund of money.
Yes, madam.
Application ಎಲ್ಲಿದೆ ಮೇಡಮ್ ಸ್ಟೇ?
ಅವರು ರಿಲೇ ಆಗಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ದಿ ವಿಕ್ಟಿಮ್ ಹ್ಯಾಸ್ ಟರ್ನ್ಡ್ ಹಾಸ್ಟೈಲ್, my lord. But in this case,
ಅದಕ್ಕೆ ನಾನು
victim has supported the case.
ಹಾಸ್ಟೈಲ್ ಆಗಿದಾರಾ ಅಥವಾ ಬೆನಿಫಿಟ್ ಆಫ್ ಡೌಟ್ ಕೊಟ್ಟಿದಾರಾ ಅಂತ?
ಬೆನಿಫಿಟ್ ಆಫ್ ಡೌಟ್ ಇಲ್ಲಿ ಸಪೋರ್ಟ್ ಮಾಡಿದ, ಫುಲ್ಲಿ ಸಪೋರ್ಟೆಡ್. ಆಮೇಲೆ ಇನ್ನಿಬ್ರು ಇಂಜೂರ್ಡ್.
ಆರ್ಡರ್ ಕಾಂಪನ್ಸೇಷನ್ ಮೇಡ್ ಇನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಸೋ ಆಲ್ಸೋ. ಬಟ್ ನೀವು ಆ ಪೋರ್ಷನ್ ಮಾತ್ರ ಸ್ಟೇ ಕೇಳಿಲ್ಲ, ಜಡ್ಜ್ಮೆಂಟ್ ನೇ ಸ್ಟೇ ಕೇಳಿದಿರಿ.
ಓನ್ಲಿ ಟು ದಿ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್
ಇಲ್ಲ ಆಗಂತ ಇಲ್ಲಿ. ಅದೇ ನಿಮ್ ಪ್ರೇಯರ್ ನೋಡಿ.
ಅಲ್ಲ,
ಸ್ಟೇ ದಿ ಆಪರೇಷನ್ ಅಂಡ್ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಆಫ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ರಿಕವರಿ. ಇಲ್ಲಿದೆ ಕರೆಕ್ಟ್, ರಿಕವರಿ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್.
ಅಲ್ಲ, ಬಿಕಾಸ್ by this appeal we are challenging the entire judgment.
This appeal is filed by the victim challenging the order of recovery ನೀವು ಅಕ್ವಿಟಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಿ ಜೊತೆಗೆ
Challenge
ಎರಡು ಕೇಳಿದಿರಾ?
ಮಾಡಿದೀವಿ.
ಹಾ. Challenging the order of acquittal and also filed an application for stay of the order, stay the operation and implementation of the order for recovery of compensation made in judgment dated
Yes.
24/1/25. And counsel would submit that the victim supported the case of prosecution. Only benefit of doubt extended in favor of the accused and not the question of the turning the witness as hostile. And the judgments which have been relied upon by the trial court are not applicable to the case on hand, since those judgments in a case of victim turning hostile. And having considered the submission urged
ಒಂದು
in
ಕೇಸಲ್ಲಿ ಹಾಸ್ಟೈಲ್ ಆಗಿದ್ದಾರೆ, ಅವ್ರು ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ರಿಲೇ ಆಗಿದ್ದಾರೆ ಮೇಲೆ, ಒಂದರಲ್ಲಿ ಹಾಸ್ಟೈಲ್ ಆಗಿದ್ದಾರೆ, ಇನ್ನೊಂದರಲ್ಲಿ ಹ್ಯಾಬಿಚುವಲ್ ಕಂಪ್ಲೇಂಟ್ ಅವರು. He has filed a number of complaints before
hostile
several.
And also in another judgment habitual complainant, and the same is not the case before this court. And having considered the grounds urged in the application and affidavit filed in support of the application, the operation and implementation of recovery of compensation amount is stayed. Next enough to issue notice against the respond number 2 na. Additional SVP takes notice for R state R1, issue notice against R2. In the meanwhile, registry is directed to get the records of trial court. This matter immediately after the summer vacation.
29.
Much obliged.
KS Bhimaya.
CDF 527 days. RP na idu.
One submission. Let's undertake to appear for respond number. PH Virupakshaya.
Enta Virupakshaya?
PH Virupakshaya.
PH Virupakshaya undertakes to appear on behalf of
respond number 1 to 4.
1 to
4.
1 to 4 ಅಷ್ಟೇ ಇರೋದಾ?
5 ಇದಾರೆ. 5 ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್.
1 to 4 ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್. ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಅಂದ್ರೆ ಸ್ಟೇಟ್.
Respond number 5 is SLA.
HCGP is directed to take notice for madam ನೋಡಿ R5 ಗೆ ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಅಂತ ನೋಡಿ for R5 and posted for filing of objections to A number 1 of 25.
That's
This matter on 17/4 ಅಥವಾ 21st?
21st. I'll file
21st or 22nd.
20 ಆಯ್ತು 22/4.
Copy to be served on the state.
Copy?
I'll serve.
Appellant
Please, I'll serve.
review petition of counsel is directed to serve the copy of appeal memo on the review petition on the HCGP.
Parted in
Forthwith.
Parted in admission.
Parted in admission.
PV Kalpana.
ಹೇಳ್ರಿ ಏನದು?
This is a case, my lord, where the appellant is the de facto complainant, my lord.
De facto complainant.
The case has resulted in acquittal.
Acquittal.
Acquittal. The complainant
offense ಏನು?
498 A and B and 306.
498
A and B.
A and B.
Then 306, my lord.
306. Records ಎಲ್ಲ ಇದೆಯಲ್ಲ ಮೇಡಮ್?
The lower court has acquitted both the accused, my lord. Accused number 1 is the husband.
One husband and
2 is the mother-in-law.
Mother-in-law.
My lord, the complainant is the mother of the deceased.
ಮದುವೆ ಆಗಿ ಎಷ್ಟು ವರ್ಷ ಆಗಿತ್ತು? ಯಾವಾಗ? ಡೇಟ್ ಆಫ್ ಮ್ಯಾರೇಜ್?
Date of marriage is 12/11/2001.
12/11/2001.
She committed suicide on 16/8/2005.
2005.
Along with the child.
Along with the child.
Child was 2 years old. She jumped into river, my lord.
Jumped into the river.
The child body was recovered on the same day, but the deceased body was recovered on 22/8.
recovered on
22/8, my lord. 22/8, 2005.
almost after 1 week.
My lord, initially FIR was filed on 16/8/2005.
Initially
The FIR was filed on 16/8/2005, my lord.
16/8/2005.
There the complainant was deceased father. Deceased father.
Father had gone complaint.
Father registers a complaint. It is at exhibit P15, my lord.
Exhibit P15.
They, he says that ನನ್ನ ಮಗಳು ಹೊಳೆಗೆ ಹಾರಿ ಆತ್ಮಹತ್ಯೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾಳೆ, ಏನು ಯಾತಕ್ಕೆ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ ಅನ್ನೋ ರೀತಿನಲ್ಲಿ ಹೇಳ್ತಾಳೆ.
ಅವಾಗ ಫಸ್ಟ್ ಟೈಮ್ ರೀಸನ್ ಗೊತ್ತಿಲ್ಲ ಅಂತ. ಫಾದರ್.
ಹೌದು.
ಎಕ್ಸಿಬಿಟ್ P20
ಅಲ್ಲಿ 15.
ಎಕ್ಸಿಬಿಟ್ P15.
ಹೌದು.
15.
ಹೌದು 15.
ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇಲ್ಲಲ್ಲ 15.
ಇದೆ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 8.
ಇಲ್ಲಿದೆ ಎಕ್ಸಿಬಿಟ್ P15.
ಪೇಜ್ ನಂಬರ್ 8.
ಪೇಜ್ ನಂಬರ್ 5 ಇದ್ದಂಗಿದೆ.
5 ಇಂದ 8 ಗೆ. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ
5 FIR.
ಹೌದು.
ಕಂಪ್ಲೇಂಟ್ ಪ್ರಾಬಬಲಿ ಸ್ವೀಕರಿಸಿ, ಅದೇ ಪೇಜ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಇದೆ.
8 ರಿಂದ ಶುರು ಆಗುತ್ತೆ ಕಂಪ್ಲೇಂಟ್.
ಎಕ್ಸಿಬಿಟ್ P1 ಅಂತ ಇದೆಯಲ್ಲ ಇದು.
ಅಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 8 ತಗೊಳ್ಳಿ.
8 ಅಲ್ಲಿ. ಎಕ್ಸಿಬಿಟ್ P15.
ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಫೋನ್ ಮೂಲಕ ನನ್ನ ಗಳಿಯ ತಿಳಿಸಿದ ಮೊಮ್ಮಗನಿಗೆ ಮನೆಯಿಂದ ಕಾಣೆಯಾದ ಬಗ್ಗೆ
ಫೋನ್
ಮಾಡಿ ತಿಳಿಸಿ, ನಾನು ಸುಳ್ಯಕ್ಕೆ ಬಂದಾಗ ಮಗಳು ಮೊಮ್ಮಗನೊಂದಿಗೆ ಪಕ್ಕದ ಪಯಸ್ವಿನಿ ನದಿಗೆ ಹಾರಿ ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಂಡರು ತಿಳಿಯಿತು. ಮೊಮ್ಮಗನ ಮೃತದೇಹ ಹುಡುಕುವಾಗ ಪಕ್ಕದಲ್ಲಿ ನದಿಯ ಬದಿಯಲ್ಲಿ ತೊತೆಯಾಗುತ್ತದೆ ತಿಳಿಯಿತು. ಮಗಳು ಮತ್ತು ಅಳಿಯ ಒಳ್ಳೆ ರೀತಿಯಲ್ಲಿದ್ದು ಅಂತ ಬರೀತಾರೆ ಇಲ್ಲಿ.
ನನಗೆ
ತಿಳಿದಂತೆ ಅವರೊಳಗೆ ಯಾವುದೇ ಭಿನ್ನಾಭಿಪ್ರಾಯವಿದ್ದ ಬಗ್ಗೆ ನನಗೆ ತಿಳಿದಿಲ್ಲ. ನನ್ನ ಮಗಳು ನನ್ನ ತನ್ನ ಯಾವುದೋ ಬೇಸರದ ಜೀವನ ಜೀವಿಸಿಕೊಂಡು ಹೊಳೆಯ ನೀರಿಗೆ ಹಾರಿ ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಂಡಿದ್ದಾಗಿರುತ್ತದೆ. ಮೊಮ್ಮಗನ ಸಾವಿಗೆ ನನ್ನ ಮಗಳೇ ಕಾರಣರಾಗಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ತನಿಖೆ ನಡೆಸಿ ಮಗಳ ಮೃತದೇಹವನ್ನು ಪತ್ತೆ ಮಾಡಿಕೊಡಬೇಕಾಗಿ ಮತ್ತು ಮೊಮ್ಮಗನ ಮೃತದೇಹದ ಮೇಲೆ ತನಿಖೆ ನಡೆಸಿ ಮೃತ ದೇಹವನ್ನು ಕೊಡಬೇಕಾಗಿ. ಓಕೆ, ಆಯ್ತು.
ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 4. 4 ನಂತರ ನಂತರದ ಕಂಪ್ಲೇಂಟ್ ಅವರ ತಾಯಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ. ಶುಭ,
ಇದು 19/8.
ಹೌದು.
ಮದರ.
ಹೌದು. ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
P1.
ಒಂದನೇ ಆರೋಪಿ ನನ್ನ ಅಳಿಯ. ಸಾಕಷ್ಟು ಶ್ರೀಮಂತನಾಗಿದ್ದರು. ಮದುವೆಯಾದ 1 ವರ್ಷದ ಬಳಿಕ ಆತ ತೀರ ಕೆಟ್ಟದಾಗಿ ನಡೆದುಕೊಂಡಿರುತ್ತಿದ್ದು ಆತನಿಗೆ, ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೇಲೆ, ಆತನಿಗೆ ತನ್ನ ಕೆಲಸವಳಾದ ಸೋನ್ಸೋ ಎಂಬ ಹರಿಜನ ಮತ್ತು ತಿಲಕ ಎಂಬ ಹೆಂಗಸರೊಂದಿಗೆ ಅನೈತಿಕ ಸಂಬಂಧವಿಟ್ಟುಕೊಂಡು ಬಗ್ಗೆ ನನ್ನ ಮಗಳು ನನ್ನೊಂದಿಗೆ ಆಗಾಗ ಹೇಳುತ್ತಿದ್ದಳು. ಒಂದನೇ ಆರೋಪಿಯು ಇತರ ಹೆಂಗಸರೊಂದಿಗೆ ಅನೈತಿಕ ಸಂಬಂಧವನ್ನು ಹೊಂದಿ ನನ್ನ ಮಗಳನ್ನು ದಿನಪ್ರತಿ ಹೆಚ್ಚು ದುಡಿಸುವುದು ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸಿಸುವುದು, ಕೆಟ್ಟ ಮಾತುಗಳಿಂದ ನಿಂದಿಸುವುದರ ಬಗ್ಗೆ ಅವಳು ತೀರಾ ನೊಂದವಳಾಗಿ ನನ್ನ ಬಳಿ ಹೇಳಿಕೊಂಡಿದ್ದಳು. ಇದನ್ನು ನನ್ನ ತಂದೆಯ ಹತ್ತಿರ ಹೇಳಬೇಡಿ, ಹೇಳಿದರೆ ಪುನಃ ನನ್ನ ಗಂಡ ಕಿರುಕುಳ ಕೊಡುತ್ತಾನೆಂದು ನನ್ನೊಂದಿಗೆ ಇತ್ತೀಚೆಗೆ ಹೇಳಿದ್ದಳು. ಒಂದನೇ ಆರೋಪಿ ಅನೈತಿಕ ಸಂಬಂಧಗಳ ಬಗ್ಗೆ ನನ್ನ ಮಗಳು ವಿರೋಧಿಸಿದಾಗ, ನೀನು ಸಾಯುವುದಾದರೆ ಸಾಯಿ, ನಾನು ಮಾಡುವುದನ್ನು ಮಾಡುತ್ತೇನೆಂದು ಹೇಳುತ್ತಿದ್ದ ಬಗ್ಗೆ ನನ್ನ ಬಳಿ ಹೇಳಿದಳು. ಅದಾದ್ಮೇಲೆ ಎರಡನೇ ಆರೋಪಿಯು ಒಂದನೇ ಆರೋಪಿಯ ತಾಯಿಯಾಗಿದ್ದು ಅವನು ಮಾಡುವ ಎಲ್ಲಾ ಕೆಲಸಗಳಿಗೆ ಅವಳ ಸಹಕಾರ ಇತ್ತು. ನನ್ನ ಮಗಳಿಗೆ ಸರಿ ಕುಳಿತುಕೊಳ್ಳಲು ಸಹ ಬಿಡದೆ ಹಿಂಸಿಸಿ ತನ್ನ ತವರು ಮನೆಯವರನ್ನು ನಿಂದಿಸುತ್ತಾರೆ. ಅಲ್ಲದೆ ನನ್ನ ಮಗುವಿಗೆ ಹಾಲು ಕೂಡ ನೀಡಲು ಬಿಡುವುದಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಿದ್ದಳು. ಮೇಲಿನ ಆರೋಪಿಗಳು ನೀಡುವ ಕೃತ್ಯವನ್ನು ನನ್ನ ಮಗಳು ನನ್ನೊಂದಿಗೆ ಹೇಳುತ್ತಿದ್ದಾಗ ನಾನು ಅವಳನ್ನು ಸಮಾಧಾನಿಸಿ ಮುಂದೆಗೆ ಎಲ್ಲ ಸರಿ ಹೋಗುತ್ತದೆ ಎಂದು ತಿಳಿಸಿದೆ. ಆದರೆ ದಿನಾಂಕ ಸೋನ್ಸೋರಂದು ನನ್ನ ಮಗಳು ಮೊಮ್ಮಗನೊಂದಿಗೆ ಹೊಳೆಗೆ ಹಾರಿರುತ್ತಾರೆ ಎಂದು 1ನೇ ಆರೋಪಿಯು ಫೋನ್ ಮುಖಾಂತರ ತಿಳಿಸಿದ್ದಾಗಿ, ನನ್ನ ಗಂಡ ನಿತ್ಯಾನಂದ ಇವರು 1ನೇ ಆರೋಪಿಯ ಮನೆಗೆ ಹೋದಾಗ ಊರಿನ ಜನರು ಹೊಳೆಯಲ್ಲಿದ್ದ ಮಗುವಿನ ಶವವನ್ನು ತಂದು ಮನೆಯಲ್ಲಿ ಇರಿಸಿದ್ದರು ಮತ್ತು ಆ ಸಂದರ್ಭದಲ್ಲಿ ನಾನು ಕೂಡ ಮೇಲಿನ ವಿಚಾರಗಳನ್ನು ನನ್ನ ಗಂಡನಿಗೆ ತಿಳಿಸದ ಕಾರಣ ಅನ್ಯೋನ್ಯವಾಗಿದ್ದಾರೆ, ಆಕೆ ಆತ್ಮಹತ್ಯೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾಳಂತೆ. My lord, the fact that she committed suicide is not disputed. Only thing is whether it is because of because of cruelty meted by the accused herein, and because of their abatement she has committed suicide. Another have to establish.
I think evidence here.
PW1 is the complainant.
Complainant mother ಅಥವಾ father?
ಇಲ್ಲ, mother.
Mother.
Page number 56, my lord.
56.
56. So 57 ಗೆ ಬಂದ್ಬಿಟ್ಟು 4 ವರ್ಷ ಚೆನ್ನಾಗೇ ಇದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. 57 my lord, page number 57. 56 ಆದ್ಮೇಲೆ 57 ಗೆ ಆ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. 4 ವರ್ಷಗಳು ಚೆನ್ನಾಗಿದ್ರು, ನಂತರ ನನ್ನ ಮಗಳು ಹೊಳೆಗೆ ಹಾರಿಕೊಂಡಳು ಎಂದು ತಿಳಿಯಿತು. ನನ್ನ ಮಗಳು ಜೀವಂತವಾಗಿರುವ ಸಮಯದಲ್ಲಿ 1ನೇ ಆರೋಪಿಯು ಸುಶೀಲಾ ಮತ್ತು ತಿಲಕ ಎಂಬ ಹೆಂಗಸರೊಂದಿಗೆ ಅನೇಕ ಸಂಬಂಧ ಹೊಂದಿದ್ದರು ಎಂದು ಹೇಳಿದಳು. ಅನೈತಿಕ ಸಂಬಂಧದ ಬಗ್ಗೆ ಕೇಳಿದಾಗ ಜಗಳ ಮಾಡುತ್ತಿದ್ದರು, ನಂತರ ಮತ್ತೆ ಹೋಗುತ್ತಿದ್ದರು. 2ನೇ ಆರೋಪಿಯ ಅಕ್ಕಮ್ಮ ನಮ್ಮ ಮನೆಗೆ ನಮ್ಮಗಳ ಬೈಯುತ್ತಾ ಇದ್ದಳು. ಮತ್ತೆ 1ನೇ ಆರೋಪಿಯು ನನಗೆ ನನ್ನ ಮಗಳು ಹೊಳೆಗೆ ಹಾರಿದಳು ಎಂದು ಬೆಳೆಸು. ನಂತರ 4ನೇ ಪ್ಯಾರಾಗ್ರಾಫ್. ರಶ್ಮಿ ಮತ್ತು ಲೋಕೇಶ್ನನ್ನು ಆರೋಪಿಗಳು ಕೊಲೆ ಮಾಡಿ ಪಾಯಸ್ವಿನಿ ನದಿಗೆ ಹಾಕಿದ್ದಾರೆ. ನಂತರ ನಾನು ಸುಳ್ಯ ಪೊಲೀಸರಿಗೆ ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಅದು ನಾನು ಕೊಟ್ಟ ಕಂಪ್ಲೇಂಟ್ ಆಗಿದ್ದು ಎಕ್ಸಿಬಿಟ್ ಆಗಿ ಮಾರ್ಕ್ ಆಗುತ್ತೆ. ನಂತರ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 6 ಮೈಂಡ್
ಒಂದೊಂದ್ಸರಿ ಹೇಳ್ತಾರೆ, ಇಲ್ಲಿ ನೋಡ್ರೆ ಕೊಲೆ ಮಾಡಿ ಹಾಕಿದ್ದಾರೆ ಅಂತ
ಹೇಳ್ತಾರೆ. ಬಟ್
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹಂಗಿಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ P1A ನಲ್ಲಿ
ಸುಸೈಡ್ ಅಂದ್ರೆ ಆಕೆ ಸುಸೈಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ಬಿಕಾಸ್ ಹಿ ಹ್ಯಾಡ್ ಅನ್ ಎಕ್ಸ್ಟ್ರಾ ಮ್ಯಾರಿಟಲ್ ರಿಲೇಷನ್ಸ್
ಅಂತ ಅದು.
6th ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಥರ್ಡ್ ಲೈನ್. ನನ್ನ ಮಗಳು ರಶ್ಮಿ ನನ್ನ ಗಂಡ ಶಿವರಾಮನು ಸುಶೀಲಾ ಸೋನ್ಸೋ ಅವರೊಂದಿಗೆ ಅನೈತಿಕ ಸಂಬಂಧ ಹೊಂದಿದ್ದನೆಂದು ತಿಳಿಸಿದಳು. ಆ ಬಗ್ಗೆ ನನ್ನ ಗಂಡನು ಕೇಳಿದಾಗ 1ನೇ ಆರೋಪಿ ತನ್ನನ್ನು ಬೈಯುತ್ತಿದ್ದ ಎಂದು ಹೇಳಿದಳು. ಭೂಮಿ ಪಾಲು ವಿಚಾರದಲ್ಲಿ ಶಿವರಾಮ್, ಅಕ್ಕಮ್ಮ ಮತ್ತು ಕರುಣಾಕರ್ ತಮ್ಮ ಅಂದ್ರೆ ಅವರು ಕರುಣಾಕರ್ ಇಸ್ ದ ಬ್ರದರ್ ಆಫ್ ದ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಜಗಳ ಆಡ್ತಿದ್ರು ಅಂತ ಹೇಳಿ. ಇವರಿಬ್ರು 2ನೇ ಆರೋಪಿ ಬಗ್ಗೆ ಸ್ವಾಮಿ 8ನೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ 2ನೇ ಆರೋಪಿಯು ನನ್ನ ಮಗಳಿಗೆ ಹಿಂಸೆ ಕೊಡುತ್ತಿದ್ದಳು, ಕೆಲಸ ಮಾಡುವುದಿಲ್ಲ ಮತ್ತು ಚಿನ್ನ ತರುವುದಿಲ್ಲ ಎಂದು ಪೀಡಿಸುತ್ತಿದ್ದಳು. ಮನೆ ಕೆಲಸ ಮತ್ತು ತೋಟದ ಕೆಲಸ ಎಲ್ಲಾ ಕೆಲಸವನ್ನು ಮಾಡುತ್ತಿದ್ದಳು. ಕೆಲಸವನ್ನು ಮಾಡಿಸುತ್ತಿದ್ದರು. ನನ್ನ ಮಗಳು ಮತ್ತು ಅಳಿಯ ಒಟ್ಟಿಗೆ ನಮ್ಮ ಮನೆಗೆ ಬರುತ್ತಿದ್ದರು. ಕೆಲವು ಸಾರಿ ನನ್ನ ಮಗಳು ಒಬ್ಬಳೇ ಬರುತ್ತಿದ್ದಳು. ಸೋನ್ಸೋ ಎಂಬ ಹೆಂಗಸರು ಆರೋಪಿಗಳು ಮನೆಯ ಕೆಲಸ ಮಾಡುವ ಹೆಂಗಸರು. And she has retreated the same thing what is said in the complaint. ಹದಿನೈದನೇ ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್. ಅದ್ರಲ್ಲಿ ಕರುಣಾಕರನ ಹೆಂಡತಿ ಉಷಾ ಮನೆ ಕೆಲಸ ಮಾಡುತ್ತಿರಲಿಲ್ಲ. ನನ್ನ ಮಗಳು ಒಬ್ಬಳೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಳು. ಉಷಾಳಿಗೆ ಹಟ್ಟಿಯ ಕೆಲಸ ಗೊತ್ತಿರಲಿಲ್ಲ. ಹಟ್ಟಿಯ ಕೆಲಸವನ್ನು ನನ್ನ ಮಗಳೇ ಮಾಡಬೇಕಾಗಿತ್ತು. ನನ್ನ ಮಗಳಿಗೆ ಮೊದಲೇ ಹಟ್ಟಿ ಕೆಲಸ ಎಲ್ಲ ಬರುತ್ತಿತ್ತು. ಅದಾದ್ಮೇಲೆ ಕೆಳಗಡೆಯಿಂದ ಆರನೇ ಲೈನ್ಸ್. ಎರಡನೇ ಆರೋಪಿ ಅಕ್ಕಮ್ಮಳಿಗೆ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಎರಡನೇ ಆರೋಪಿಗೆ ಒಂದು ಮಾತಾಡಿದರೆ ಅವರು ತಿರುಗಿ 9 ಮಾತನಾಡುತ್ತಿದ್ದಳು. ಎರಡನೇ ಆರೋಪಿಗೆ ಆಯಾಸವಾಗಿದ್ದರೆ ಮಾತ್ರ ಮಾತು ನಿಲ್ಲಿಸುತ್ತಿದ್ದಳು. ನನ್ನ ಮನೆಯಲ್ಲಿ ನನ್ನ ತಾಯಿ ಇದ್ದ ಹಾಗೆ ಅವರು 85 ವರ್ಷ ವಯಸ್ಸು. ಮನೆಯಲ್ಲಿ ಅಡುಗೆಯನ್ನು ಸೊಸೆ ಮಾಡುತ್ತಿದ್ದಳು. ಎರಡನೇ ಆರೋಪಿ ಮನೆಯಲ್ಲಿ ಟಿವಿ ನೋಡುತ್ತಿದ್ದಳು. Swami, last 17th paragraph. Page number 62, my lord. ಸಾಕ್ಷಿ ಪುನಃ ಹೇಳುತ್ತಾರೆ, ಮದುವೆ ಸಮಯದಲ್ಲಿ ವರದಕ್ಷಿಣೆ ಕೊಟ್ಟಿದ್ದೇವೆ. ಸೋನ್ಸೋ ಏನೇನ್ ಕೊಟ್ಟಿದ್ದೇವೆ ಅಂತ ಅವರು ಲಿಸ್ಟ್ ಹಾಕ್ತಾರೆ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೈ ಲಾರ್ಡ್, 19th paragraph. ಆ ಇಬ್ಬರು ಹೆಂಗಸರು ಮನೆಯ ಹೊರಗಡೆ ಊಟವನ್ನು ಇದೇನಿಲ್ಲ. ಕಮಿಂಗ್ ಟು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಇಪ್ಪತ್ತೆರಡನೇ ಪ್ಯಾರಾಗ್ರಾಫ್. 22. ಸಾಯುವ 1 ವರ್ಷ ಮೊದಲು ಪ್ರಥಮವಾಗಿ 1ನೇ ಆರೋಪಿಯು ಇಬ್ಬರ ಹೆಂಗಸರೊಂದಿಗೆ ಅನೈತಿಕ ಸಂಬಂಧ ಹೊಂದಿದ್ದಾನೆ ಎಂದು ನನ್ನ ಮಗಳು ಹೇಳಿದಳು. ಆಗ ನನ್ನ ಮಗಳು ಆ ಇಬ್ಬರ ಹೆಂಗಸರ ಜೋರು ಮಾಡಿದ್ದೇನೆ, ಈಗ ಸಂಬಂಧ ನಿಂತಿದೆ ಎಂದು ಹೇಳಿದ್ದಾಳೆ.
ಹ್ಮ್
23rd paragraph ಅಲ್ಲಿ ಸ್ವಾಮಿ, in the middle line ಅಲ್ಲಿ, ನನ್ನ ಗಂಡ ಅಲ್ಲಿಂದ ತಾರೀಕು 19/8/2005 ನಾನು ನನ್ನ ಗಂಡ ಮತ್ತು ಮಗ ಬೆಳಗ್ಗೆ 10 ಗಂಟೆಗೆ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿದ್ದೆವು. ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳು ನಾನು ವಿಷಯವನ್ನು ತಿಳಿಸಿದೆನು. ಪೊಲೀಸರು ನಾನು ಹೇಳಿದ್ದನ್ನು ಕೈಯಲ್ಲಿ ಬರೆದುಕೊಂಡರು. The next witness is a
ಅಲ್ಲ,
neighbor.
ಪ್ಯಾರಾ 24 ಹೇಳ್ತಾರೆ, ಅತ್ತೆ ಮತ್ತು ಗಂಡನಿಗೆ ನನ್ನ ಮಗಳ ಮೇಲೆ ಪ್ರೀತಿ ಇತ್ತು ಅಂತಾನು ಹೇಳ್ತಾರೆ ನೋಡಿ.
ನನ್ನ
ಕೊನೆಯ ಲೈನು
ಅತ್ತೆ ಮತ್ತು ಗಂಡನಿಗೆ
64 ಅಲ್ಲಿ
ಪ್ರೀತಿ ಇತ್ತು ಅಂತ. ಅಲ್ಲ, ಪ್ರೀತಿ ಅದೇ ಅವಳು ಹೇಳೋದು ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ 4 ವರ್ಷ ಚೆನ್ನಾಗಿದ್ರು, 1 ವರ್ಷದಿಂದ ಈ ಒಂದು ವಿಷಯ ನಡೀತಾ ಅವ್ರಿಗೆ ಇರ್ಸು ಮುರ್ಸ ಜಗಳಗಳಾಗ್ತಿತ್ತು ಅಂತ. ಮತ್ತೆ ಆತನಿಗೆ ಇದ್ದಂತ ಅನೈತಿಕ ಸಂಬಂಧದ ಬಗ್ಗೆ ಕನ್ಸಿಸ್ಟೆಂಟ್ ಆಗಿ ಬೇರೆ ವಿಟ್ನೆಸ್ ಕೂಡ ಹೇಳಿದ್ದಾರೆ.
ಹೇಳಿದಾರಾ?
ಹಾ, ಹೇಳಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ವಿಟ್ನೆಸ್ ಬಂದು ಅವ್ರ ನೇಬರ್ ಹೆಸರು PW2.
ನೆಕ್ಸ್ಟ್ ವಿಟ್ನೆಸ್ PW2 ನಾ?
ಹಾ, PW2 66 ಪೇಜ್ ನಂಬರ್. ಅವರ ಮನೆ ಮತ್ತು ನನ್ನ ಮನೆ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಇದೆ. ಅಕ್ಕಪಕ್ಕದವರೇ. ಲಾಸ್ಟ್ ಬಟ್ ಒನ್ ಲೈನ್ಸ್. ನನ್ನ ಮುಂದೆ ರಶ್ಮಿಯು ನನ್ನ ಮುಂದೆ ನನ್ನ ಗಂಡನಿಗೆ ತಿಲಕ ಮತ್ತು ಸುಶೀಲಾ ಎಂಬ ಹೆಂಗಸರ ಜೊತೆ ಅನೈತಿಕ ಸಂಬಂಧ ಇತ್ತು ಮತ್ತು ಗಂಡನ ಮನೆಯಲ್ಲಿ ತನಗೆ ಅತ್ತೆ ಮತ್ತು ಗಂಡ ತುಂಬಾ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದರು ಎಂದು ಹೇಳುತ್ತಿದ್ದಳು. ಮತ್ತೆ ರಶ್ಮಿ ಅಳುತ್ತಾ ಇದ್ದಳು. ಸಾಯುವ 2 ತಿಂಗಳ ಮುಂಚೆ ನನಗೆ ರಶ್ಮಿ ಸಿಕ್ಕಿದ್ದಳು. ಹಿಂಸೆ ಅಂದರೆ ಮಾನಸಿಕ ಮತ್ತು ದೈಹಿಕ ಹಿಂಸೆ ಕೊಡುತ್ತಿದ್ದರು ಎಂದು ಹೇಳುತ್ತಿದ್ದಳು. ಈ ರೀತಿ ಹಿಂಸೆ ಕೊಟ್ಟರೆ ನಾನು ಬದುಕುವುದಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಿದ್ದಳು. ಆಗ ನಾನು ನಿನ್ನ ತಂದೆ ತಾಯಿಗೆ ಈ ವಿಷಯ ತಿಳಿಸು ಎಂದು ಏನಾದರೂ ಬಂದು ವ್ಯವಸ್ಥೆ ಮಾಡಬಹುದು ಎಂದು ನಾನು ಹೇಳಿದೆ. ಊರಿನಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಸುಶೀಲಾ ಮತ್ತು ಶಿವರಾಮನಿಗೆ ಮತ್ತು ಶಿವರಾಮ್ ಮತ್ತು ತಿಲಕ ಮಣಿ ಎಂಬ ಹೆಂಗಸಿಗೆ ಅನೈತಿಕ ಸಂಬಂಧ ಇತ್ತು ಎಂಬ ಬಗ್ಗೆ ಗೊತ್ತಿತ್ತು. ರಶ್ಮಿಯ 16ರಂದು ತೀರಿಕೊಂಡಿದ್ದು ಇಸ್ವಿ ಸರಿ ಗೊತ್ತಿಲ್ಲ. ಪೇಜ್ ನಂಬರ್ 69 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಇಂದ 10ನೇ ಲೈನ್ಸ್, ಪೇಜ್ ನಂಬರ್ 69. ನಾವೆಲ್ಲರೂ ಅಂದರೆ ಸ್ವಸಹಾಯದ ಸಂಘದ ಸದಸ್ಯರು ರಶ್ಮಿ ಕೊಲೆಯಾಗಿದೆ, ಆರೋಪಿಯನ್ನು ಬಂಧಿಸಬೇಕು ಮತ್ತು ಎಂದು ಒತ್ತಾಯಿಸಿದೆವು ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಹೇಳುತ್ತಾರೆ, ರಶ್ಮಿಯ ಶವ ಸಿಗದ ಇದ್ದ ಕಾರಣ ನಾವು ಪೊಲೀಸರಿಗೆ ಶವವನ್ನು ಹುಡುಕಲು ಒತ್ತಾಯ ಪಡಿಸಿದೆವು ಎಂದು. ನಮ್ಮ ಮತ್ತು ಆರೋಪಿಗಳ ಮನೆಯವರ ನಡುವೆ ಮಾತುಕತೆ ಇಲ್ಲದೆ ಸುಮಾರು 10 ವರ್ಷ ಮೇಲಾಗಿದೆ. ಒಬ್ಬರ ಮೇಲೆ ದ್ವೇಷದಿಂದ ಅವರ ಮನೆಯಲ್ಲಿ ಆಹಾರವನ್ನು ಅಂದ್ರೆ ಈ ಸ್ವಸಹಾಯ ಗುಂಪಿನಲ್ಲೂ ಕೂಡ ಈಕೆ ಸದಸ್ಯಳಾಗಿದ್ಲು. ಹಂಗಾಗಿ ಅವ್ರ ಶವ ಸಿಕ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಗಲಾಟೆ ಮಾಡಿರ್ತಾರೆ ಪೊಲೀಸರ ಮೇಲೆ.
ನಮ್ಮ ಮತ್ತು ಆರೋಪಿಗಳ ಮನೆಯವರ ನಡುವೆ ಮಾತುಕತೆ ಇಲ್ಲದೆ ಸುಮಾರು 10 ವರ್ಷ ಮೇಲಾಗಿದೆ. ಒಬ್ಬರ ಮೇಲಿನ ದ್ವೇಷದಿಂದ ಅವರ ಮನೆಯಲ್ಲಿನ ಆಹಾರವನ್ನು ಅವರು ಸ್ವೀಕರಿಸುವುದಿಲ್ಲ. ನಮ್ಮ ಮನೆಯ ಆಹಾರವನ್ನು ಆರೋಪಿಗಳು ಸ್ವೀಕರಿಸುವುದಿಲ್ಲ. ರಶ್ಮಿ ಯಾವತ್ತಿಗೂ ನನ್ನ ಮನೆಗೆ ಬಂದಿರಲಿಲ್ಲ. ನಾನು ಆರೋಪಿಗಳ ಮನೆಗೆ ಯಾವತ್ತಿಗೂ ಹೋಗಿಲ್ಲ. ಸರಿಯಲ್ಲ ಅಂತಿಲ್ಲ, ಯಾವತ್ತಿಗೂ ಹೋಗಿಲ್ಲ. ನನಗೆ ಮತ್ತು ರಶ್ಮಿಗೆ ಮಾತುಕತೆ ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ ಅಷ್ಟೇ.
ಆರೋಪಿಗಳ ಮೇಲಿನ ದ್ವೇಷದಿಂದ ಈ ಮಾತು ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
There is an enmity from last 10 years.
ಅಲ್ಲ, ಎನಿಮಿಟಿ ಇದೆ ಅಂದ್ ಮಾತ್ರಕ್ಕೇನೆ ಅಂದ್ರೆ ಅವರು ಇವರ ಗಂಡನ ವಿಷಯದಲ್ಲಿ ಈಕೆ ಗಂಡ 2ನೇ ಮದ್ವೆ ಮಾಡ್ಕೊಂಡಿರ್ತಾನೆ. ಆ 2ನೇ ಮದ್ವೆ ಮಾಡ್ಸಿರೋದು ಈ ಶಿವರಾಮ್ ಅಂತ ಹೇಳಿ ಅದನ್ನ ತಗೊಂಡ್ ಬರ್ತಾರೆ. ಹಂಗಾಗಿ ನಿಮ್ಗೂ ಅವ್ರಿಗೂ ದ್ವೇಷ ಇತ್ತು ಅನ್ನೋದು ಇದ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ನೆಕ್ಸ್ಟ್
ಇವ್ರ ಡಿಸೀಸ್ಡ್ ತಂದೆ.
PW ತಂದೆನಾ?
ತಂದೆ PW3. PW4 is the brother of the deceased. At page number 17, my lord. ಇವಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಆಗತ್ತೆ ಸುಮ್ಮನೆ. ಇವಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಇದೆ. PW4.
ಬ್ರದರ್.
ಹಾ, ಬ್ರದರ್. ಸ್ವಾಮಿ 78 ಇಂದ ನನ್ನ ಅಕ್ಕ ರಶ್ಮಿ ಹೆರಿಗೆ ಆದ ನಂತರ ಗಂಡನ ಮನೆಗೆ ಹೋದ 6 ತಿಂಗಳ ನಂತರ ನಾನು ಹೋದಾಗ ನನ್ನ ಅಕ್ಕ ರಶ್ಮಿ 79 ಪೇಜ್ ನಂಬರ್ ನನ್ನ ಗಂಡ ಅಂದರೆ 1ನೇ ಆರೋಪಿಗೆ ಸುಶೀಲಾ ಎಂಬ ಹೆಂಗಸಿನ ಜೊತೆ ಅನೈತಿಕ ಸಂಬಂಧ ಇದೆ ಎಂದು ಹೇಳಿದಳು. ನಾನು ಅಕ್ಕನಿಗೆ ಸಮಾಧಾನ ಮಾಡಿ 1ನೇ ಆರೋಪಿ ನಮ್ಮ ಕರುಣಾಕರನಿಗೆ ಈ ವಿಷಯ ಹೇಳಿ, ಕರುಣಾಕರ ಬಂದು ಅವ್ರ ತಮ್ಮ ಆಗ್ತಾರೆ,
ಗೊತ್ತಾಯ್ತು,
ಹೇಳಿ ಸರಿಪಡಿಸುತ್ತೇನೆಂದು ಸಮಾಧಾನ ಹೇಳಿದೆನು. ನಂತರ ನಾನು 1ನೇ ಆರೋಪಿ ತಮ್ಮ ಕರುಣಾಕರನಿಗೆ ಈ ವಿಷಯ ತಿಳಿಸಿದೆ. ಅವರು ಅದನ್ನು ಸರಿಪಡಿಸುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು. ರಶ್ಮಿ ಸಾಯುವ 15 ದಿನಗಳ ಮೊದಲು ನಾನು ಆರೋಪಿಗಳ ಮನೆಗೆ ಹೋಗಿದ್ದೆ. ಆಗ ನನ್ನ ಅಕ್ಕ ರಶ್ಮಿಯು ಈ ಬಗ್ಗೆ ಗಂಡನಲ್ಲಿ ಪ್ರಶ್ನಿಸಿದಾಗ ಆರೋಪಿಗಳಿಬ್ಬರು ನನಗೆ ಹೊಡೆದು ಬಡದು ಹಿಂಸೆ ಮಾಡುತ್ತಿದ್ದರು ಎಂದು ಹೇಳಿದರು. ಆ ಬಗ್ಗೆ ನಾನು ಅಕ್ಕನಲ್ಲಿ ಭಾವ ಸಂಬಂಧಿಕರಲ್ಲಿ ಹೇಳಿ ಸರಿಪಡಿಸುತ್ತೇನೆ ಮತ್ತು ಈ ಸಮಯವನ್ನು ಈ ಸಮಸ್ಯೆಯನ್ನು ಬಗೆಹರಿಸುವುದಾಗಿ ಧೈರ್ಯ ಹೇಳಿದೆ. ನಂತರ 16/8/2005 ಸುಮಾರು 8 ಗಂಟೆಗೆ ನನ್ನ ತಂದೆಗೆ ಫೋನ್ ಮಾಡಿ ಸೋನ್ಸೋ ಈ ವಿಷಯ ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳಿ. ನಾನು ಆರೋಪಿ ಮನೆಗೆ ಹೋಗುವ ಸಮಯದಲ್ಲಿ ಊರಿನ ಜನರು ಆರೋಪಿಗಳ ಮನೆಯ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಹುಡುಕುತ್ತಿದ್ದರು. ಅಷ್ಟು ಹೊತ್ತಿಗೆ ಯಾರೋ ಒಬ್ಬರು ಬಂದು ಮಗುವಿನ ಶವ ತೋಟದಲ್ಲಿ ಅಂದರೆ ಹೊಳೆ ಬದಿಯಲ್ಲಿ ಸಿಕ್ಕಿದೆ ಎಂದು ತಿಳಿಸಿದರು. ನಂತರ ನಾನು ಹೊಳೆಯ ಬದಿಗೆ ಹೋದೆ, ಅಲ್ಲಿ ಮಗುವಿನ ಶವ ಇತ್ತು. ಆಗ ನಾನು ಸುಳ್ಯಕ್ಕೆ ಬಂದು ನನ್ನ ತಂದೆಗೆ ಈ ವಿಷಯವನ್ನು ತಿಳಿಸಿದೆ. ನಂತರ ನನ್ನ ತಂದೆ ಪೊಲೀಸರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆರೋಪಿಗಳಿಬ್ಬರು ರಶ್ಮಿಗೆ ಹೊಡೆದು ಬಡೆದು ದೈಹಿಕ ಹಾಗೂ ಮಾನಸಿಕ ಹಿಂಸೆ ಕೊಟ್ಟಿದ್ದರಿಂದ ನನ್ನ ಅಕ್ಕ ಸತ್ತಿದ್ದಾಳೆ. ನನ್ನ ಅಕ್ಕ ನನ್ನ ಆರೋಪಿಗಳಿಬ್ಬರು ಕೊಲೆ ಮಾಡಿರಬಹುದೆಂದು ನನಗೆ ಸಂಶಯ. Next, PW5 man. ಇವರು ಕೂಡ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ. ಲಾಸ್ಟ್ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಲಾಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ.
PW5.
5. He is also neighbor. ತಿಲಕಮಣಿ ಎಂಬುವರು ಗೊತ್ತು. ಆರೋಪಿಗಳ ಮನೆ ಪಕ್ಕದಲ್ಲಿ ತಿಲಕಮಣಿಯ ಮನೆ ಇದೆ. 1ನೇ ಆರೋಪಿ ಮತ್ತು ತಿಲಕಮಣಿ ಇಬ್ಬರು ನಡುವೆ ಅನೈತಿಕ ಸಂಬಂಧ ಇತ್ತು ಎಂದು ಮಾತನಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದರು. ಅವರಿಬ್ಬರೊಳಗೆ ಸೋಂಸೋ ಇದ್ದ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿದೆ. ಸುಶೀಲಾ ಎಂಬುವರು ಗೊತ್ತು. ಅವರು ತೋಟದಲ್ಲಿ ಕೆಲಸ ಮಾಡುವರು. ರಮೇಶ್ ಎಂಬುವನು ಸುಶೀಲಾಳ ಗಂಡ. ಈ ಘಟನೆ ನಡೆಯುವ ಸಮಯದಲ್ಲಿ ರಮೇಶ್ ಸುಶೀಲಾ ಜೊತೆ ಇರಲಿಲ್ಲ. ಸುಶೀಲಾ ಮತ್ತು 1ನೇ ಆರೋಪಿ ನಡುವೆ ಸಂಬಂಧ ಹೇಗಿತ್ತು ಎಂದು ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ಸುಶೀಲಾ 1ನೇ ಆರೋಪಿಯ ಮನೆಗೆ ಕೆಲಸ ಹೋಗುತ್ತಿದ್ದಳು. ಸುಶೀಲಾ 1ನೇ ಆರೋಪಿಯ ಮನೆ ಕೆಲಸ ಹೋಗುತ್ತಿದ್ದ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತು. ಆ ಸಮಯದಲ್ಲಿ ಅವರಿಬ್ಬರು ಸಂಬಂಧ ಹೇಗಿತ್ತು ಎಂದು ಒಂದನೇ ಆರೋಪಿ ಮತ್ತು ತಿಲಕಮಣಿ ಮತ್ತು ಹೆಂಗಸರೊಂದಿಗೆ ಅನೈತಿಕ ಸಂಬಂಧ ಇದ್ದುದರ ಬಗ್ಗೆ ರಶ್ಮಿ ಪ್ರತಿಭಟಿಸುತ್ತಿದ್ದು, ಆ ಬಗ್ಗೆ ಆರೋಪಿ ಅವಳಿಗೆ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದ ಬಗ್ಗೆ ಹತ್ತಿರದ ಮನೆಯವರು ಮಾತನಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದರು. ನೆಕ್ಸ್ಟ್ 84th ಪೇಜ್ ಅಲ್ಲಿ
ಹ್ಮ್
ಆ ಮಗುಗ್ ಹುಷಾರಿರಲ್ಲ, ಅವಾಗ ಇವ್ರ ಹತ್ರ ಹೋಗಿರ್ತಾಳ ಅವಳು, ನನ್ನ ಹತ್ತಿರ ಬಂದಿದ್ದು.
ಟ್ರೀಟ್ಮೆಂಟ್ ಹೋಗಿದ್ರು ಅಂತ.
ಹೌದು, ಅವಾಗ ಅವಳು ಹೇಳಿದ್ಲು ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ, ಏನು ಹೇಳಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ,
ಆ ಸಮಯದಲ್ಲಿ ರಶ್ಮಿ ಔಷಧಿ ತೆಗೆದುಕೊಳ್ಳುವ
ನನ್ನ-
ಸಮಯದಲ್ಲಿ ರಶ್ಮಿ ನನ್ನ ಮುಂದೆ ಏನು ಹೇಳುತ್ತಿರಲಿಲ್ಲ. ಅವಳಿಗೆ ಕಿರುಕುಳವಾಗುತ್ತಿರೋ ಬಗ್ಗೆ ಊರಿನವರು ಹೇಳಿ ಗೊತ್ತು ಅಷ್ಟೇ.
ಆ ನಂತರ ನನ್ನ ಹತ್ತಿರ ಬಂದಿದ್ದಳು, ನಾನು ಮಗುವಿಗೆ ಔಷಧಿ ಕೊಟ್ಟಿದ್ದು, ಅದು ಗುಣಮುಖವಾಗಿದೆ. ಆ ಸಮಯದಲ್ಲಿ 84th ಪೇಜ್ ಅಲ್ಲಿ, ಆ ಸಮಯದಲ್ಲಿ ರಶ್ಮಿ ಔಷಧಿ ತೆಗೆದುಕೊಳ್ಳುವ ಸಮಯದಲ್ಲಿ ರಶ್ಮಿ ನನ್ನ ಮುಂದೇನು
ಏನು ಹೇಳುತ್ತಿರಲಿಲ್ಲ.
ಅವಳಿಗೆ ಕಿರುಕುಳವಾಗುತ್ತಿರುವ ಬಗ್ಗೆ ಯಾರು ನನ್ನವರು
ಏನು ಹೇಳ್ತಿರ್ಲಿಲ್ಲ, ಊರಿನವರು
ಮಾತಾಡೋದ್ ಬಗ್ಗೆ
ಗೊತ್ತು ಅಂತ ಅಷ್ಟೇ. ಊರಿನವರು ಹೇಳಿ ಗೊತ್ತು, ಆಕೇನು ಹೇಳಿಲ್ಲ. ಹ್ಮ್.
ನೆಕ್ಸ್ಟ್ PW6 ಅವರು ಅದೇ ಊರಿನವ್ರನ್ನೇ. ಪೇಜ್ ನಂಬರ್ 86 ಅಲ್ಲಿ ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಆರೋಪಿಗಳು ರಶ್ಮಿಕಾ ಮನೆಯಲ್ಲಿ ಜಾಸ್ತಿ ಕೆಲಸ ಕೊಡುತ್ತಿದ್ದರು. ಸುಶೀಲಾ ಎನ್ನುವರು ಗೊತ್ತು. ಸುಶೀಲಾ ಎಂಬುವರು ಶಿವರಾಮನ ಮನೆಗೆ ಕೆಲಸಕ್ಕೆ ಹೋಗುತ್ತಿದ್ದರು. ರಶ್ಮಿ ಮತ್ತು ಶಿವರಾಮನಿಗೆ ಗಲಾಟೆ ಇದ್ದ ಬಗ್ಗೆ ನಮ್ಮ ಮನೆಗೆ ಕೇಳುತ್ತಿರಲಿಲ್ಲ. ಸುಶೀಲಾ ಮನೆಗೆ 1ನೇ ಆರೋಪಿ ಹೋಗುತ್ತಿದ್ದನು. ಆ ಬಗ್ಗೆ ರಶ್ಮಿ ಯಾಕೆ ಹೋಗುತ್ತಿ ಎಂದು ತನ್ನ ಗಂಡನನ್ನು ಕೇಳುತ್ತಿದ್ದಳು. ಸುಶೀಲಾ ಮನೆಗೆ 1ನೇ ಆರೋಪಿ ದಿನಾಲು ಸಾಯಂಕಾಲ 5-6 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಬರುತ್ತಿದ್ದನು. 1ನೇ ಆರೋಪಿ ಸುಶೀಲಾ ಮನೆಗೆ ಸಾಯಂಕಾಲ ಆಗಾಗ ಬರುವುದು ನಾನು ನೋಡಿದ್ದೇನೆ. ಪೇಜ್ ನಂಬರ್ 89 ಅಲ್ಲಿ 5ನೇ ಲೈನ್. ಸುಶೀಲಾ ಮತ್ತು 1ನೇ ಆರೋಪಿ ನಡುವೆ ದಣಿ ಮತ್ತು ಕೂಲಿ ಕೆಲಸ ಸಂಬಂಧ ಮಾತ್ರ ಇತ್ತು ಎಂದರೆ ಸರಿಯಿಲ್ಲ. PW5 ಏನಂತ ಇದಿಲ್ಲ ಸರ್, ಇದು ಹಿಯರ್ಸೆ ಎವಿಡೆನ್ಸ್ ಆಗುತ್ತೆ. PW5 ಹಿಯರ್ಸೆ ಎವಿಡೆನ್ಸ್.
5 ಅಲ್ಲ 7 ಇರ್ಬೇಕು.
ಸಾರಿ, PW7. ಅವ್ರು ಮಾತಾಡ್ಕೊಳ್ತಿದ್ರು, ಅದು ನಂಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತ ಮಾತ್ರ ಹೇಳ್ತಾರೆ. ಇದ್ರಲ್ಲಿ ಒಂದು ಪೇಜ್ ನಂಬರ್ 91 ನಲ್ಲಿ 91 ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3 ನಲ್ಲಿ 1ನೇ ಆರೋಪಿ ನಡತೆ ಸರಿ ಇಲ್ಲದ ಕಾರಣ ರಶ್ಮಿಯು ಮಗುವಿನ ಜೊತೆಗೆ ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಂಡಿರಬಹುದು ಎಂದು ನನಗೆ ತಿಳಿಯಿತು ಮತ್ತು ಹಾಗೆ ಊರಿನವರು ಮಾತನಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದರು. ತಿಲಕಾಮಣಿ ಎಂಬ ಹೆಂಗಸರೊಂದಿಗೆ 1ನೇ ಆರೋಪಿ ಸಂಬಂಧ ಇತ್ತು. 1ನೇ ಆರೋಪಿಯು ತಿಲಕಾಮಣಿಯನ್ನು ತನ್ನ ಮೋಟಾರ್ ಬೈಕ್ ನಲ್ಲಿ ಕುಳ್ಳಿರಿಸಿಕೊಂಡು ಹೋಗುವುದನ್ನು ನಾನು ಅನೇಕ ಬಾರಿ ನೋಡಿದ್ದೇನೆ ಎಂಬ ಹೆಂಗಸಿನ ಸಹ ಸಂಬಂಧ ಇತ್ತು. PW 8 hostile actors. Janardana ಅಂತ. Nine PW 9 ಬಂತು inquest ಅವ್ರನ್ನೇ cross inquest 10 hostile actors. You Mazar witness ಅಷ್ಟೇ sir. 11. 12 is also Mazar witness.
Only grounds of the prosecution is that he was having
Illicit
an extramarital relationship and hence he committed suicide ಅಂತ. ಅಷ್ಟೇ. You are relying upon only the evidence of neighbors, two neighbors.
ಹೌದು. And PW
Apart
4.
from the parents.
A parent ಮತ್ತೆ brother.
Brother.
PW 4.
ಬೇರೆ ವಿಟ್ನೆಸಸ್ ಅದೇನಿಲ್ಲ. No consequence. That's all.
Two citations, my lord, which I am producing it. The death has occurred within 7 years of marriage, my lord. The presumption has to be drawn. One is right in one of the decision, my lord, 2018.
Mainly PW 1 to 6.
My lord?
PW 1 to 6 mainly. Evidence of PW 1 to 6 on there.
Dowry harassment ಬಗ್ಗೆ ಏನು ಅಂತ dowry harassment ಬಗ್ಗೆ ಇಲ್ಲ. ಆದ್ರೆ ಈ ಅನೈತಿಕ ಸಂಬಂಧದ ಮೇಲೆನೆ
main focus is only on the extramarital relationship.
So bride committing suicide in one of the case, my lord, citation which I have given, bride committing suicide, harassment due to alleged dowry demand, cruelty meted out to the deceased, having illicit relationship with another woman as causes suicide. High Court rightly maintained conviction. This is a conviction ಮೇಲೆ appeal ಬಂದಿದ್ದಾಗ. ಅದರಲ್ಲಿ first paragraph ಅಲ್ಲಿ it cannot be said that the appellant's act of having illicit relationship with another woman would not have affected to negate the ingredients.
ಯಾವ್ದು ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ರಿಲೈ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಥವಾ
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 2008 18 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 621 ಅಲ್ಲಿ
18 ಪ್ಯಾರಾಗ್ರಾಫ್
so my first head note alene
head note having illicit relationship with other woman.
His illicit relation would have definitely created psychological imbalance to deceased, which led her to take extreme step of committing suicide. It cannot be said that the appellant's act of having illicit relationship with another woman would not have affected to negate ingredients of section 306. So fact that within 4 months of a marriage, deceased took extreme step. This is 5 years of marriage, my lord.
Convening panchayat deceased committed suicide or showing any leniency in quantum.
Paragraph number 7, my lord. Abatement in so-and-so case, Randir Singh case, abatement involves a mental process of instigating a person or in any manner aiding that person in doing of the thing. Court should carefully assess the facts of each case before deciding whether the cruelty meted out to the victim which induces her to commit suicide. In the next para, there is one. Illicit relationship with another woman would have definitely created the psychological imbalance to the deceased, which led to her to take an extreme step of committing suicide. It cannot be said that the appellant's act of acting relationship and so on. The fact that everyone speaks of illicit relationship, my lord. Of course, there can, in cross-examination, some kind of enmity or some kind of relationship with the deceased, with the accused. They are trying to bring in that, because of some kind of an enmity, the witness is speaking otherwise. Anta heli cross-examination al tarlik nodta idare. But the fact remains that all of them have consistently said that the deceased, I mean, accused number one had a relationship with the two women. In the next citation, my lord.
This is with regard to the cruelties.
Second, presumption ಬಗ್ಗೆ. Next page is. High Court rightly raised the presumption under section 113A to hold that the suicide was abetted by the appellant. Prosecution, by leading cogent evidence, established that the deceased had committed suicide within a period of 7 years from the date of her marriage, and the husband has subjected to her to cruelty. ಅದರಲ್ಲಿ eighth paragraph also. From the explanation to section so and so, cruelty, any willful conduct which is of such a nature.
Which para you are reading?
Some eighth paragraph.
Para 8.
Para 8. ಅದರ ಮೇಲ್ಗಡೆ ಪ್ರಿಸಂಪ್ಷನ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ 113A ಬಗ್ಗೆ. Any cruelty 498A, any willful conduct which is of such a nature as is likely to drive the women to commit suicide. So this is, my lord, the fact that she committed suicide is not in dispute, my lord, as I made a submission in the beginning. It is not their case that she committed suicide otherwise. Circumstantial evidence has to be looked into, my lord. Last paragraph number 11 alli sonu. That view of the matter, the High Court has rightly raised the presumption under section 113A of the Evidence Act to hold that the suicide was abetted by the appellant. There cannot be any disagreement to the proposition so and so relied upon by the learned counsel for the appellant to submit that unlike section 113B of Evidence Act, a statutory presumption does not arise in section 113A by operation of law merely on the proof of circumstances enumerated in the said provision. So the fact that she committed suicide within 7 years of the marriage, the fact that consistently the witnesses have also spoken about the accused number one having a relationship, my lord, extramarital affair with another woman. So all this has made her to commit suicide. Initially, my lord, when the father gave the complaint, the body of the deceased was not found. So maybe, my lord, to have a better understanding within the family, the father never wanted to lodge a complaint otherwise. The court ought to have convicted the accused number one, my lord, at least, if not the accused number two. They are relying on one decision, my lord, where the Supreme Court has held recently that in revision petition, the court cannot convict the accused. It has to be, the matter has to be remanded back. If that is so, my lord, the matter may be remanded back for a fresh consideration, my lord.
Now this is not revision, now this is an appeal.
Appeal, I'm sorry.
Revision.
Because de facto complainant has filed this appeal, this revision. It was converted to appeal, then later again it was converted to revision.
Again revision.
That's all.
Yes.
Pass it to.
ಪಾಸ್ ಓವರ್ ಎಲ್ಲ ಇಲ್ಲ, ಹೇಳ್ಬೇಕು ಮುಂಚೆ ಹೇಳ್ಬೇಕು. ಪಾಸ್ ಓವರ್ ಇದ್ರೆ ನಾನು ನಿಮ್ ಸೀನಿಯರ್
Yeah.
ಬಂದಾಗ್ಲೇ ಕೇಳ್ತಾ ಇದ್ದೆ.
Senior was here, my lords.
Huh?
He was here, my lords, but he rushed to
No,
court.
counsel beginning. I thought that you are going to argue the matter. ಮತ್ ಪಾಸ್ ಓವರ್ ಆದ್ರೆ ರೀಚ್ ಆಗಲ್ಲ. ಇವತ್ ಬೇರೆ ಮತ್ 3:45 ಹೇಳ್ಬೇಕು. ಹೇಳಿ ನೀವೇ ಹೇಳಿ ಏನು.
Will address the arguments. He is prepared. He is prepared, my lords. I have not read the files.
He is prepared ಆದ್ರೆ he should be before the court. ನಿಮ್ಮನ್ನೊಂದ್ಸರಿ ಏರ್ ಮಾಡೋದು, ಅವ್ರನ್ನೊಂದ್ಸರಿ ಏರ್ ಮಾಡೋದು, ಆಮೇಲೆ ಪಾರ್ಟರ್ಡ್ ಆಗೋದು, ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಹೇಳೋದು, ಅವೆಲ್ಲ ಯಾಕೆ ಬೇಕು? ಯಾವುದು ಬೇಡ. ಇಲ್ಲ ಹೇಳಿ ಕೇಳೋಣ. ಇಲ್ಲ ಬರೆಯೋಣ.
Password. 2:30.
ಬಿಫೋರ್ ಕಮೆನ್ಸಿಂಗ್ ಹೇಳ್ಬೇಕಿತ್ತು ನೀವು. 2:30 ಅಂದ್ರೆ ಮತ್ತೆ ರೀಚ್ ಆಗಲ್ಲ. ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಇರುತ್ತೆ. ನೀವು ಮೊದಲೇ ಕಮೆಂಟ್ಸ್ ಹಾಕಿನ ಮುಂಚೆ ಹೇಳ್ಬೇಕು. ಕರ್ಸಿ, ಗೆಟ್ ಹಿಮ್ ಇಮಿಡಿಯೇಟ್ಲಿ
ಪ್ಲೀಸ್.
Admissions.
Yes.
Admission at 31.
No, here is a case where, my lord,
Santosh Raj for R2.
The case was registered for the offence under section, my lord, P23.
Complainant appeal.
Complainant appeal.
Records ಎಲ್ಲ ಬಂದಿದೆಯಲ್ಲ?
Records ಎಲ್ಲ ಬಂದಿದೆ. The only thing is, my lord, the trial court has not examined the witnesses.
Admit ಮಾಡಿ ಡೇಟ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ವಾ witnesses?
Examine ಮಾಡಿಲ್ಲ. No police officer IO examine ಮಾಡಿಲ್ಲ. Complainant CW7 is examine ಮಾಡಿಲ್ಲ. A police witness in examine ಇಲ್ಲ. Mahajar witness in examine ಮಾಡಿಲ್ಲ. And even though, my lord, the witnesses came before the court, my lord, they send it back. And then the summons was not properly issued. ಬಂದಾಗ ಎಕ್ಸಾಮ್ ಮಾಡಲ್ಲ, ಬಂದ್ರ ಮೇಲೆ ವಾಪಸ್ ಕಳ್ಸಿದ. CW2 was the most important witness because he is the owner of the house. CW2 is the most important witness. He is the owner of the property, and he is running some organization in the house property. The property stands in his name. All the revenue documents are entered. Tahsil also not been examined. Investigation officer conducted the Mahajar. It shows that the building was there, and loss of property is about 65,000 rupees is a property was lost. It has been recorded in the Mahajar witness.
Admit ಮಾಡಿ final hearing date fix ಮಾಡಿ.
Lords, may I submit, my lord? Lords, it deserves to be not admitted, my lords, on the ground, my lords. Lords, there was delay of 3 months in reporting the incident, my lords. The trial court, my lords, have considered this issue, that there is no satisfactory explanation to the delay caused in reporting the offence. My lords would find it at, my lords, page 29.
Page 29.
29. Lords may kindly come to 9 lines below. The delay in lodging the complaint is fatal to the case. PW1 to 3, who are the brothers, are interested witness. The oral evidence of PW1 to 3 are not corroborating it. And so, my lords, the trial court has come to conclusion, my lords, about the delays, my lords. There is nothing explanation forthcoming in exhibit P1, which is the complaint. They further, my lords, they improvised their statement in the deposition, my lords, that they were being threatened at the hands of the complaint. It was only at the first instance, my lords, when they were before the court, my lords, they say this. And my lords, there is nothing forthcoming in the complaint. This was considered. Number 2, my lords, the PW1 to 3 are my lords, are the brothers. They, my lords, their statement also, my lords, did not corroborated with the exhibit P1. And my lords, the statement of the PW1 did not corroborated with exhibit P1, which is the complaint. My lords, the abusive words used, my lords, as stated in the complaint, did not further corroborated with the statement of the PW1 in his testimony. All these things were considered, my lords, and my lords, the trial court came to a conclusion that, my lords, they have not proved it.
Order sheet kodi.
But it's not correct, you lost me kindly say.
ನೀವು not examined CW2 ಅಂತೀರಿ.
CW2 is not examined.
ನಿಮಿಷ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ in this case despite of giving sufficient opportunity to the prosecution.
Yes.
The prosecution has not examined CW2 8 to 14. CW2 is material witness. Admittedly, there is a dispute between CW2 and the accused in respect of property bearing serial number 35R2. Under such circumstances, non-examination of CW2 is also fatal to the case of prosecution.
Correct.
Despite of giving sufficient opportunity to the prosecution has not examined the investigating officer, Tahsildar, PSI, ASI and Deputy Superintendent of Police. The non-examination of CW 10 to 14 also fatal to the case of prosecution.
Yes.
Corroborated oral version of PW 1 to 4.
Yes.
It creates doubt about their version. The uncorroborated oral evidence of PW 1 is not sufficient to hold that the accused has committed the offences of 448, 427, 506. So and so.
You lost me kindly say. Right, it is observed. Order sheet you lost me kindly say. Page ಎಲ್ಲ ಬೈಂಡ್ ಓವರ್ ಮಾಡಿದಾರ.
CW2 ಯಾವಾಗ ಬಂದಿದ್ರು ಹೇಳಿ.
CW2 you lost me kindly say date and ಮಲಡ್ 11/7/2014 you lost me kindly say.
11/7/2014.
ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. Straight away come to Malad 16/10/2014 you lost me kindly say.
11/7/2014.
14, the summons have been issued.
Application is allowed on imposing penalty of ₹300. Warrant is
yes
to deposit.
On 16/10/2014, you lost me.
16/10/2014.
Accused present.
And to present.
CW1 and 2 present.
Witnesses are suffering from viral fever. Hence, both the
Bind
witnesses are bind over as final chance.
In fact, on that day, they were present. People intentionally, they said, no, you just go. That is the summons. Then you lost me kindly see again.
Prosecution or time counter.
Again, you lost me kindly see. On 26/5/2015. 26/5/2015.
15.
26/5/2015.
ಏನಾಯ್ತು?
ಅವತ್ತು CW2 and 3 present and bind over. This intentionally, they don't want to give the evidence before the court. ಅದಾದ್ಮೇಲೆ ಸುಮಾರು ಸಲ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡೋದು, ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡೋದು, ಪೊಲೀಸ್ ಅವ್ರು ಬರೋದಿಲ್ಲ, ವಿಟ್ನೆಸ್ ಬಂದವ್ರಿಗೆ ಎಕ್ಸಾಮ್ ಮಾಡೋದಿಲ್ಲ, ಇನ್ಯಾರೋ ಸಪೋರ್ಟ್ ಮಾಡಲ್ಲ, ಕನ್ಸರ್ನ್ ಪರ್ಸನ್ ಇಲ್ವೋ ಅವ್ರನ್ನ ಎಕ್ಸಾಮ್ ಮಾಡೋದು, ಇಂಟ್ರೆಸ್ಟೆಡ್ ಪರ್ಸನ್ ಎಕ್ಸಾಮ್ ಮಾಡಲ್ಲ ಈ ಕೇಸಲ್ಲಿ. ದಿಸ್ ಇಸ್ ಔಟ್ ಮಲಟ್. ಮತ್ತೆ ಆಫ್ಟರ್ ಅಲ್ಲಿ ತನಕ ಟ್ರಯಲ್ ಕನ್ಕ್ಲೂಡ್ ಆಗೋ ತನಕ ಲಕ್ಷ್ಮಿ ಕೈಲಿಸಿ 25/11/2016 ಅಲ್ಲಿ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿ CW2 to 4ಗೆ ಮತ್ತೆ ಬರಲೇ ಇಲ್ಲ. ಮತ್ತೆ ಏನ್ ಫರ್ದರ್ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿಲ್ಲ ಕೋರ್ಟ್. So far as the CW2 is concerned.
CW2, my lords, he was not at all relevant, my lords, as
not at all relevant andre why trial court has made an observation that CW2 is a material witness.
PW1 to 3, my lords, PW1 claims that, my lords, CW2 is the owner of the shed. My lords,
and my lord said my lord complete
at the initial itself, my lord,
4 months
they
delay
failed to prove certain facts, my lords, which are forthcoming in the judgment.
My lord, incident has taken place 16/1/2011, and the very day itself, my lord, I went to the police station, lodged a complaint, but they did not taken the complaint, and they asked me to go to the CRE cell. Then immediately I went to the CRE cell, filed a complaint with very day itself, and CRE cell has conducted investigation, and the CRE cell CW10 has referred the matter to the police station, and CRE cell CW10 is the complainant before the police. Then only FIR was registered. That is on 8/4/2011. Prevented, all the witnesses have been prevented to give the evidence before the court. Even police officers did not stand up even before the court. Colluded to even accused and police. They don't want to serve the notice on me.
This is also considered, my lord. This very statement is also considered in the judgment, my lord.
When the material witnesses, my lord, is there before the lord wanted to give an evidence, they have given, they were awarding.
Issue NBW against CW2 and witness summons to PW2 and 3 and payment of cost of ₹500 each. Condition that they will be
evidence model
examined on the date present without seeking any adjournment. Office has not issued NBW and summons. Issue NBW against CW2 witness.
Main witnesses are examined. Police or when the merger was conducted, When this shows that, my lord, it is.
TW2
destroyed.
absent, NBW, hence evidence TW2 is
ಕೋರ್ಟ್ ಸಮನ್ಸ್ ಮಾಡಿದ್ರು ವಾರೆಂಟ್ ಮಾಡಿದ್ರು ಕೊಡಲ್ಲ ಪಾರ್ಟಿಗಳಿಗೆ ವಿಟ್ನೆಸ್ಗಳಿಗೆ. CW2 has filed a civil case and it was injunction was granted, status was there, police have came, partnership inspection conducted, photos have taken, they did not produce it before the court. ನಾವು ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಫೋಟೋಸ್ ನಾವು ಕೊಡ್ಲಿಲ್ಲ ಕೋರ್ಟ್ಗೆ. ಆ ಫೋಟೋಗಳು ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕಾಗಿ
ಆ ಸೂಟ್ ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿದೆ. That is also admitted by the PW 123 that there was a civil dispute between accused and the CW2 and the suit filed by CW2 was also dismissed, is admitted by them. My lords, they couldn't establish that, my lords, they were there in the shed on the alleged date of incident and they were running a Samiti association called Dr. Ambedkar Seva Samiti and no documents were produced. And my lords, the Major also does not reveal, my lords, certain furniture worth 50 to 60,000 were destroyed.
Kindly see the Major.
Nothing is forthcoming, my lords. Based on all this, my lords, the trial court came to a conclusion, my lords, and acquitted the accused.
Kindly see the Major.
ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಅಂತಾನೆ ಬರ್ದಿದ್ದಾರೆ.
ಬರೀತಾರೆ, ಇದಕ್ಕೂ ಇಲ್ಲ ಅಂತ ಬರ್ತಾರೆ, ಏನ್ ಮಾಡೋದು? ಮಾಜರ್
ಸೀಸ್ ಆಗಿಲ್ಲ.
ಮಾಜರ್ photos also is produced, D75. ನಾವು ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಪ್ರೊಡ್ಯೂಸೇ ಕೊಡೋದಿಲ್ಲ.
D75
ಬೇರೆ ಕಡೆ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಫೋಟೋಸ್ ಎಲ್ಲ ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ.
ಆ ತರ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕೆ ಆಗಿಲ್ಲ ಅಷ್ಟೇ.
ಇದು ಮಹಜರ್ ಲಾಟ್ಸ್.
My lords, may kindly see page 27, my lords.
IO ಬಂದು ಇದು ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಅಕ್ವಿಟಲ್ ಮಾಡಿಸಿ.
Yes.
So, my lord, you let me kindly see the Mahaja. There are three grounds, my lord, for the acquittal. One is, my lord, limitation. They did not lodge a complaint immediately on 16/1/2011. But the complaint was lodged. Not you let me kindly see the complaint. Complaint was lodged in the same day before the police authorities. But they did not take the complaint. They, on the other hand, they are advised to go before CRSL. Then immediately, my lord, we went to the CRSL in the same day, and the case was registered before the CRSL, and investigation was conducted. And CRSL CW10 Inspector Chelvaraju not internally filed a complaint to the respondent police, and then only, my lord, that is on 8/4/2011, my lord, complaint was FIR was registered. Therefore, my lord, there is no delay in lodging the complaint by the complainant here. And the second ground is, my lord, the materials, photos have not been produced for having the standing there, shed and compound and all for demolition of one. You lost me kindly see the Mahajar, you lost me kindly see. Mahajar was conducted along with witnesses. And in the Mahajar it clearly says, ಫಿರ್ಯಾದಿದಾರರ ಶ್ರೀ ಲೋಕೇಶ್ವರ ಅವರು ತೋರಿಸಿದ ಕೃತ್ಯದ ಸ್ಥಳವು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ಬನ್ನೇರುಘಟ್ಟ ರಸ್ತೆಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 35/2 ಕಲೆನಗರವಾಗಿದ್ದು ಬಿಜಿ ರಸ್ತೆ ಕಡೆಗೆ ಸುಮಾರು 200 ಅಡಿ ಉದ್ದಕ್ಕೆ ಕಲ್ಲು ಕೂಸ ಹಾಗೂ ಮುಳ್ಳುತಂತಿ ಬೇಲಿ ಹಾಕಿದ್ದು ಕಟ್ಟಿದ 2 ರೆಕ್ಕೆ ಗೇಟ್ ಸಹ ಇರುತ್ತದೆ. ತಂತಿ ಬೇಲಿಯಿಂದ ಸುಮಾರು 20 ಅಡಿ ದೂರದ ಪೂರ್ವದ ಕಡೆಗೆ 10 × 12 ಅಡಿಗಳ ಉದ್ದದ ಒಂದು ಡ್ಯಾಮೇಜ್ ಮಾಡಿರುವ ಶೆಡ್ ಇದ್ದು ನೆಲದಿಂದ ಸುಮಾರು 8 ಅಡಿಗಳ ಎತ್ತರಕ್ಕೆ ಸಿಮೆಂಟ್ ಶೀಟು ಡ್ಯಾಮೇಜ್ ಆಗಿರುವುದರಿಂದ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಉತ್ತರ ಕಡೆದ ಬಾಗಿಲು ಮತ್ತು ಕಿಟಕಿ.
Any major witnesses are examined?
No, not at all. Even material witness has not been examined. Major witness has not examined. Investigating officer has not been examined. Because unless it has been marked by the investigating officer, how it is possible to come to conclusion? It has been referred even by the trial court. It did not come forward to the of substance opportunity court, the material witness Barilla. The court can bring them. You know, they don't want police officer, but they have colluded with the accused person. They don't want to serve the summons into the witnesses. Complaint voluntary court ಬಂದಿದ್ದರಿಂದ ಅದು ಅಸ್ಪದ ಕಂಪ್ಲೇಂಟ್ ಅದು ಮಾಡಿದ್ದು ಏನ್ ಮೆಟೀರಿಯಲ್ಸ್ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಹಿಂಗ್ ಕೊಡಕ್ಕಾಗ್ತದೆ ಓನರ್ ಕೊಡ್ಬೇಕಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತಹಸೀಲ್ದಾರ್ conducted the investigation, not collected all the documents from the Tahsildar, revenue authorities. Even revenue authorities have not been examined. Therefore, it's a case exercise to set aside the art of the trial court and let them. My humble request is this is a fit case to conduct the trial before the trial court. It is required, my lord. Let me kindly.
Counsel, respondent.
My lords may kindly come to page 26 of the appeal memo. Lords, the findings of the trial court is, my lords, the acquittal order was passed mainly on the ground, my lords, delay of 3 months, and there is no explanation in Exhibit P1, which is the complaint. More than 3 months. My lords, the major witnesses were not examined. My lords, the findings to that effect is at page 27. In this case, the independent major witnesses have not examined on the side of the prosecution. The document Exhibit P2 major marked through PW1, if at all the accused and his supporters were distracted the furnitures in the shed, the investigation officer would have seized the same under major. But on perusal of the document Exhibit P2, the major, no material object were seized. PW1 to 3 have deposed that the accused dragged PW1 out of the shed and by knocking them down on the ground, kicked them. There is no medical evidence to show that the accused dragged PW1 out from the shed and by pushing them down on the ground and kicked them. My lords, and the third ground, my lords, is that, my lords, the prosecution did not establish the fact that, my lords, the complainant PW1 was running association in the name of Dr. Ambedkar Seva Samiti. My lords, that findings would be found at page 27. My lords, other Indian page, my lords, kindly come to 26. Last 2 lines in the inordinate delay of 3 months in lodging the complaint is not satisfactorily explained by PW1 to 3. It is the case of the prosecution that CW1 to 5 were running Dr. V.R. Ambedkar Seva Samiti registered. The shed belongs to CW2 situated at so and so, Admittedly, there is a civil dispute pending between accused and CW2 in respect of the property bearing so and so. PW1 to PW3 have admitted the suggestion that the court has passed status quo order in MA 100/2020 2005 in respect of survey number so and so. Under such circumstances, it is very difficult to believe that CW1 to 5 were running Dr. B.R. Ambedkar Seva Samiti in the shed situated at so and so. More than that, the prosecution has not produced any document to show that there was any such Seva Samiti by name Dr. B.R. Ambedkar Seva Samiti running in so and so, so and so. My lords, the contradiction, my lords, the fourth ground, my lords, the acquittal order was passed on the ground that, my lords, the contradiction in the statement of PW 1, 2, and 3. My lords, the improvised abusive language so stated in the deposition is also, my lords, found at, my lords, page 19. My lords may kindly come to page 19. On perusal of, my lords, paragraph 13, ಕೆಳಗಿಂದ ಐದನೇ line. On perusal of oral evidence of PW2, there is no corroboration to the oral evidence of PW1. The abusive language which is deposed by PW2 is not corroborating with the deposition of PW1. PW2 has deposed that he has not produced any documents to show there exists such association called so and so, so and so. Dr. Seva Samiti. My lords, the non-corroboration of the abusive words is also, my lords, recorded at page number 17. My lords may kindly see paragraph 11. From below 5 line, my lords, the abusive language used for abuse the cash which mentioned in Exhibit P1 complaint is not corroborates with the deposition of PW1. There is no such word as Dana Tinnuvaru as deposed by PW1 as mentioned in Exhibit P1. If at all, the accused and others drag so and so and so and so. My lords, PW1 states so that, my lords, the abusive language used by the accused was page number 15 ಅಲ್ಲಿ it is extracted. Olaya Madiga nan makla Dana Tinnuvaru. But whereas, my lords, that Dana Tinnuvaru was not at all found in the Exhibit P1. That is also findings of the trial court. Further, my lords, the PW2 further improvises that abusive words as Kilu Jati nan makla illi. My lords may kindly see page 18. Last line. Kilu Jati nan makla ili tinno nan makla oleya nanna magane madiga nanna magane. This was not at all found in the complaint. So, my lords, and further, my lords, the prosecution case got damaged, my lords, in the statement of PW3. My lords, he does not speaks about the abusive language. Insofar as, my lords, PW5 and 6 is concerned, my lords, they were not considered as an eyewitness, my lords, because they did not corroborate with the statement of PW1 to 3. So, my lord, these grounds were well considered by the trial court. And, my lords, the acquittal order was passed. Moreover, my lords, there was a civil dispute between accused and CW2. And, my lords, the CW2 have lost all the civil dispute filed against the respondent, this respondent. So, my lords, considering all this, my lords, there was no offense made out under 448. Because they couldn't prove that, my lords, that he was the owner of the property. One, the threat, so, my lords, given at the hands of this respondent while they went to file a complaint, my lords, that was not established because, my lord, that was not forthcoming in Exhibit P1. Delay was not explained. Non-corroborative statement of Exhibit PW1 to 3 is, my lords, damaged the case of the prosecutor. My lords, considering all these only, my lords, a detailed judgment was passed for acquitting the respondent here. So, my lords, the appeal deserves to be not admitted and, my lords, to be dismissed.
So, this matter is listed for admission and records are also secured and heard the matter with the consent of both the counsel and merits. The factual matters of case of the prosecution before the trial court that CW1 lodged the complaint stating that CW1, CW3 to 5 and others were running their office of Dr. Ambedkar Seva Samiti in the shed belongs to CW2 in survey number 35/2 situated at BG Road, Kalena, Agrahara. They installed the board and had furnitures in the said shed. That on 16 to 2011 at about 2 p.m. accused number 1 along with other accused persons with common intention trespassed into the office of Dr. B.R. Ambedkar Seva Samiti and dragged CW1 to CW5 out of shed and destructed the furnitures, windows, door, and caused the loss to the tune of rupees 65,000 and also demolished the wall of the shed. It is also the case of prosecution that intimidated CW1 to 5 with dire consequences to their life and abused by taking their caste name and humiliated and insulted them. Based on this complaint, information was based on the first information statement dated 5/3/2011 lodged to Inspector General of Police, CRE cell, which referred to the Pulimavu Police on 8/4/2011. The PSI of Pulimavu Police Station registered the case in crime number 118 of 2011 and dispatched FIR to the court. The investigating officer visited to the place of incident and conducted the merger. The investigating officer, after collecting all the materials on completion of investigation, has filed the charge sheet. For the offences punishable under section 448, 427, 506, read with section 34 of IPC, and also under section 31 within bracket Roman 4, Roman 5, Roman X of SC/ST Prevention of Atrocities Act. The accused persons were secured before the trial court and they are not pleaded guilty, and hence accused ಒಬ್ರೇನಾ ಇಲ್ಲ
ಒಂದೇ accused.
ಒಬ್ಬನೇ accused
ಒಂದೇ accused.
accused but ಅಲ್ಲಿ ಒಂದು ಏನ ಅವನು ಜೊತೆ 7-8 ಜನ ಬಂದಿರೋ ಅಂತಿದ್ರು.
Also could not
Along with other accused persons with common intention trespassed.
They couldn't establish that also.
Filed the charge sheet against only accused number 1, and accused number 1 was secured before the trial court and he did not plead guilty and hence claims the trial. The prosecution, in order to prove the case, relied upon evidence of PW 1 to 6 and also got marked document exhibit P1 and P2 and P1A and P2A. The accused was subjected to 313 statement and thereafter defense have not led any evidence, and trial court, having considered the material, comes to the conclusion that prosecution has not proved the case of trespass as well as causing of any damage as well as life threat. Mainly coming to the conclusion that the oral evidence of PW 1 to 3 regarding alleged abusive language used to abuse in the name of caste is not corroborating with each other. Apart from that, PW 1 to 3 are the brothers and interested witnesses. And also trial court comes to the conclusion that in spite of sufficient opportunities given to the prosecution, not examined the CW2 and CW8 to 14, and CW2 is a material witness since the case of prosecution that CW2 constructed the shed. And so also the official witnesses of investigating officer, Tahsildar, PSI, ASI and Deputy Superintendent of Police have not been examined, who have been cited as CW 10 to 14, and the same is also a fatal to the case of prosecution.
I'm sorry, madam.
The uncorroborated oral version of PW 1 to 4 is creates doubt about their version and hence acquitted the accused persons. And hence the present appeal is filed before this court. The counsel appearing for the appellant would vehemently contend that the complaint was immediately lodged and police did not receive the complaint and referred the complaint into CRE cell, and CRE cell, having received the complaint, conducted the inquiry and having found the material, referred the matter to the jurisdictional police, and CW10 registered the case, and there was no any delay, but the trial court committed an error in coming to the conclusion that there was an observed delay in lodging the complaint. The counsel also would vehemently contend that The trial court hurriedly passed the order of not examining the witnesses, even though CW2 was present in two occasions. In one occasion, the learned public prosecutor sought time on the ground that both CW1 and 2 are suffering from viral fever, and hence case CW1 and 2 are bound over. And later on also CW1 was examined, and when CW2 was present before the court, he was not examined and again bound over. And thereafter, non-bailable warrant was issued and the same was also executed and ultimately dropped the CW2, and he is a material witness. And trial court committed an error in coming to the conclusion that CW2 was not examined before the trial court. The counsel also vehemently contend that when the Major was conducted in terms of Exhibit P2, and Major witnesses are also not been examined, and only allowed the prosecution to lead evidence of PW1 to 6 and not given any opportunity. And even IO was also not examined. And official witnesses were also not examined, including the Tahsildar and the police who have conducted the investigation and erroneously acquitted the accused. Per contra, the counsel appearing for the respondent accused would vehemently contend that even though evidence was commenced long back in 2014 itself, and also though CW2 bound over, and records clearly disclose that the case was pending before the court at the instance of CW2 and also the accused persons. And when CW2 is interested person and he had constructed the shed and his shed was demolished, he would have voluntarily appeared before the court. Instead of warrant was issued on several occasions, he did not appear before the court. And also the trial court made an observation that in spite of opportunities given, prosecution have not led any evidence before the trial court. Even warrants are issued against the PW 4 and 6 when they have not been cross-examined and taken as nil, and subsequently cross-examination was also made. And even from 2014 to 2018, they did not come forward to give evidence, and ultimately the trial court, the prayer of the learned public prosecutor was rejected, since even warrant was also not executed. And PW 2 and 3 were cross-examined on 6/6/2018 fully. And thereafter, considering the evidence of PW 1 to 6, comes to the conclusion that there is no any corroborative piece of evidence, and PW 1 to 3 are the brothers who are interested witnesses, and regarding causing of mischief also no evidence was placed, and hence trial court rightly appreciated the evidence and not committed any error. Having heard the appellant counsel and also the counsel appearing to the respondent, and also having perused the evidence available on record, the point that would arise for the consideration of this court are whether the trial court committed an error in acquitting the accused persons, and whether this court can exercise the appellate jurisdiction. What order? Having heard the appellant counsel and also the counsel appearing for the respondent, and main case of the prosecution is also that on particular date of incident, the accused persons, this accused along with other accused persons trespassed to the land of the CW2 and caused the damage to the shed which was constructed, and hence invoke the offences under section 447, 427, 506 read with section 3 and 4. Having perused the document of complaint exhibit P1, no doubt an allegation is made also that they uttered the word by taking their caste, and hence the offences under the special enactment was also invoked. Now the court has to take note of the evidence available on record. PW1 who has been PW 1 to 3 who have been examined before the court reiterated regarding the incident is concerned that on 14/1/2011 at about 2 p.m. when the CW 2 to 5 were there in the office, 8 to 9 persons came in the car and suddenly trespassed and caused the damage to the table, chair, and also the door, and also removed the board. And in the cross examination of PW1, he admits that the accused belongs to the Gounder community. He has not produced any document. And also he is not aware of this owner of survey number 133 A, 33 bar B, 33C. And also denies this suggestion that the same belongs to the accused persons and the same was denied. However, he admits, however, suggestion was made that there was a case in OS number 34 of 2005 filed by Ramachandra against the accused persons, but he says he doesn't know about the same. And also suggestion was made that there was an interim order. And also the suit filed against the accused was dismissed on 31/3/2005, and also he denies the same. And in the cross examination, he admits that when he was assaulted, only the members of Sangha were present. The other witness, PW2, is also the brother of the PW1. He reiterates the same. And in the cross examination, he admits the that there is a civil suit between the CW2 and also the accused persons in respect of survey number 35/2. And though PW1 denies the same, but PW2 admits that there was a civil dispute between the CW2 and the accused persons. And also he admits that he has not produced any document to show that the shed belongs to the Ambedkar Seva Samiti. And also suggestion was made that some of the cases in OS number 1212 of 2004, 1212 of 2014, 1212 of 2013 are filed against the accused persons and also obtained an interim injunction, and the witness says he is not having any information regarding the said property injunction order. The PW3 is also another witness who is also the brother of PW1 and 2, and in his evidence also he reiterates the same about trespassing of the property and causing damage and also abusing, taking their caste name. But in the cross examination, he admits that he came to know about the accused persons from the date of incident. And he says that CW2 is the secretary of the said Sangha. And he also denies about the case filed against CW2. However, he admits the MA number 100 of 2005 in respect of survey number 35/2, 35/1 and 35/2. And he denies the dismissal of application filed in the MA. The other witness is PW4, who claims that and in survey number 32/2 there was a shed, and the same shed was taken on 16/1/2008 from Ramachandra, and also they started Sangha in the said shed. And he also reiterates with regard to the incident is concerned. However, in the cross examination he categorically admits that he know the CW2 since 5 years and he was supplying size stones to the CW2 and he do not have any document to show that he is the member of Dr. Ambedkar Seva Sangha, and also he know the case number filed in respect of survey number 35/2, 33/1, which is going on for the last 8 years. The other and also admits that then admission next PW5 claims that he took the electric connection. He gave the electric connection in respect of the shed which constructed by CW2. But in the cross examination, he admits that he belongs to the caste of complainant. And also suggestion was made that if any illegal construction was made, no such electric power will be supplied, but the same was denied. The other witness is PW6, who is the contractor. And he says that on the request of CW2, he constructed the shed, spending rupees 55,000. And he also says that he witnessed the incident. And in the cross examination, he says that he know the accused from the date of incident and he has not seen the incident. CW2 has told him about the same. And PW1 to 4 and CW2, he knows them from 2004. And also know them through contract work. He also admits that he has not seen any permission obtained by the CW2 from corporation or concerned authority with respect to construction of shed. He also further admits that contractors don't construct without the approval plan and they construct only as per the approved plan. Having taken note of the evidence available on record, PW1 to 3 are the brothers and other witnesses, though claims that they have witnessed the incident. It is very clear in the evidence of PW1 to 3 that though they denied that there was a civil dispute between the CW and CW and also accused, but PW2 categorically admitted that there was a civil dispute in respect of survey number 35/2, and even PW1 and 3 denies, but PW2 admits the same. It is important to note that PW4 is the witness who claims that he also witnessed the incident, but in the cross examination he admits that he is having he was supplying the side stones to the CW2, and CW2 is none other than the person who claims to be the constructed the shed, and also PW5 is the electric contractor. He claims that he gave the electric connection, but the fact that PW6 categorically deposes, though he claims that he was an incident, he was the present, but he came to know about the date of accused from the date of incident. He has not seen the incident, and hence it is clear that though he claims that he was present at the time of the incident, but admission elicited from the mouth of PW6 is very clear that he had not seen the incident, and he came to know about the incident through CW2. But in the case on hand, CW2 was not examined, and no doubt counsel appearing for the appellant brought to notice of this court, CW2 was present twice, and Learned Public Prosecutor first instance sought time on the ground that he was suffering from viral fever and hence he was not examined, and in the second time he was bound over. And also it is important to note that when the CW2 claims that he had constructed the shed, and when the shed was demolished according to the prosecution and according to the complainant CW1, he is the interested witness. He ought to have been voluntarily appeared before the court and there was no need to issue NBWA against him. But even he was appeared before the court and he was bound over, and later on he did not appear before the court, and the same was observed by the trial court. And even from 2014 to 2018, either the CW2 and other witnesses CW8, CW10 to 14 were not appeared before the court, and ultimately the court, after considering the 4 years of period when the witnesses did not appear before the court, and apart from that, it is emerged during the course of evidence also the dispute between the CW2 and also the accused. There was a civil dispute and case was also pending. And when such material discloses that CW2 was an interested person, that he who constructed the shed and his building was demolished, he ought to have appeared before the court, but he did not appear before the court, and the same was also observed by the trial court. And apart from that, though an allegation was made that the witnesses were assaulted in the incident, no document of taking up treatment with regard to the assault or wound certificate is placed before the trial court. And rightly, trial court comes to the conclusion that the evidence of witnesses who have been examined, though limited witnesses of PW 1 to 6 have been examined, and evidence of each witnesses not corroborates each other, and the same has been observed in paragraph number 21 and 22. And trial court also taken note of the oral evidence of PW1 and PW3 regarding the delay in lodging the complaint is not forthcoming, but the counsel appearing for the appellant brought to notice of this court that when the complaint was not received, matter was referred to the CRE cell, and the fact that CRE cell referred the matter to the CW10 is also not in dispute, and hence the reasoning given by the trial court that there was a delay cannot be accepted. However, the court has to take note of material available on record whether the evidence of PW 1 to 6 is consistent. And I have already pointed out that there is no any corroboration with regard to the incident is concerned, and also the other material witnesses were also not examined, particularly the PW2 who claims to, CW2 who claims that he had constructed the building, and the same was given to the Sangha, and material witness CW2 did not appear before the court from 2014 to 2018. And trial court also made an observation in paragraph number 22 that admittedly there is a dispute between CW2 and accused in respect of the property bearing survey number 35/2. Under the such circumstances, non-examination of CW2 is also fatal to the case of prosecution. It is also observed that despite of giving sufficient opportunity to the prosecution has not examined the material witnesses, including the investigating officer, Tahsildar, PSI, ASI, and Deputy Superintendent of Police. And even non-examination of CW 10 to 14 also fatal to the case of prosecution. The order sheet of the trial court also reveals that the evidence was commenced in the year 2014 until 2018, though even coercive steps was taken, issuing NBW also the witnesses were not secured. Even interested witness of CW2 who claims that his property was damaged, he did not choose to appear before the trial court and give evidence, and now opponent counsel cannot contend that no opportunity was given to the prosecution to lead evidence. And having considered the material on record, and I have already pointed out that with regard to the incident is concerned, nothing is placed on record, and measure which has been drawn also not been proved by examining even measure witnesses also, and the very contention that opportunity was not given cannot be accepted even when CW 1 to 3 were examined and they are having the knowledge about pendency of case. For a period of 4 years, there was no any progress for examination of material witnesses. Under the circumstances, even remanding the matter also no purpose will be served when the CW2 himself has not taken any interest and not appeared voluntarily before the court on even on issuance of non-bailable warrant also he did not choose to appear before the court. Under the circumstances, no ground is made out to set aside the order of the trial court, and hence no ground to admit and the admit the appeal, and there is no any merit. In view of the discussions made up, I pass the Palangoda. Appeal is dismissed.
My submission is, my lord, from the beginning, police are not supporting me. Huh? From the beginning, even from the date of
ಆಯ್ತ್ರಿ ನಿಮ್ಮವನೇ ಕೇಸ್ ಹಾಕೊಂಡಿದ್ದಾನೆ CW2 ಅವನಿಗೆ ಹೋಗ್ಕೇನಾಗಿತ್ತು ಕೋರ್ಟಿಗೆ
ಸರ್ವೆ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಆಯ್ತ್ರಿ 2 ಸರಿ ಬೌಂಡ್ ಓವರ್ ಆಯ್ತು, ಆಮೇಲೆ ವಾಲಂಟರಿಲಿ ಹೋಗ್ಬೋದಿತ್ತಲ್ಲ ಅವನು, ಯಾಕೆ ಹೋಗ್ಲಿಲ್ಲ? The issue is between CW2 and the accused, ಹೌದಲ್ಲ? ಅಲ್ಲ ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಕೊಳ್ಳಿ ಮೇಡಮ್. The case of prosecution is the case of complainant is also the accused number 1 and 7 to 8 persons committed the trespass, and also the mischief. But the police after the investigation only filed the charge sheet against accused number 1 and not arrayed against the other accused persons also. And the same is also fatal to the case of prosecution ಅಂತ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ ಅವರು ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, ಸಿಕ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಅದಕ್ಕಾಗಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಲಿಲ್ಲ, ಸ್ಪ್ಲಿಟ್ ಆಫ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರಲ್ಲಿ ದಟ್ ಇಸ್ ದ ವರ್ಡ್ they have used in the charge sheet. ಕಾಲಮ್ ಅಲ್ಲಿ
they have not secured even
ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Incident 2011 for a period of 15 years. Next.
32.
Grateful.
N. Shiva Reddy, Mohammed Tahir.
Shiva Reddy, Mohammed Tahir. ಹೇಳ್ರಿ ಅಂತ. ಏನೋ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆಯಲ್ಲ?
Divergent finding.
ರೆಕಾರ್ಡ್ಸ್ ಬೇಕು ಬಂದಿದೆ.
ಬಂದಿದೆ ಸರ್.
ಹೇಳಿ ರೆಡಿ ಇದೀರಲ್ಲ? 24 ಮ್ಯಾಟರ್.
ರೆಡಿ.
ಅರ್ಜೆನ್ಸಿ ಅಡ್ಮಿಟ್ ಮಾಡೋಣ, ಆಮೇಲೆ ತಗೊಂಡ್ರಾಯ್ತು.
ಆಗಿದೆ ಸ್ವಾಮಿ, ಇವತ್ತು ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ಗೆ ಅಂತ ತಾವು ಇದು ಮಾಡಿದ್ ಸರ್.
24 ಮ್ಯಾಟರ್ ಏನ್ರಿ, ಇನ್ನು 2012 ಎಲ್ಲ ಇದೆ. ಅಡ್ಮಿಟ್ ಮಾಡೋಣ, ಕಳ್ಸೋಣ, ತರ್ಸೋಣ, ಇದನ್ನ ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್ ಮಾಡೋಣ. ಏನು
ಅಡ್ಮಿಟ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ, ಅದಕ್ಕೆ ಎರಡು ನೋಡ್ಬೇಕು, ಮೆಟೀರಿಯಲ್ ನೋಡ್ಬೇಕು, ರೀಸನಿಂಗ್ ಆಫ್ ದಿ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಅಡ್ಮಿಟ್ ಆಗ್ಬೋದು ಸ್ವಾಮಿ, ಅಡ್ಮಿಟ್ ಆಗಿ ಅಟ್ ಲೀಸ್ಟ್ ಮಂತ್ ಎಂಡಿಗೆ
Heard the appellate counsel and also the counsel appearing to the respondent.
Before vacation, my lordship.
ಎಲ್ ವೆಕೇಶನ್ ಎಲ್ಲ ಬರೀ ರಜೆಗಳೇ ಇದಾವಲ್ರಿ, ಪೂರಾ ರಜಾನೆ ಜಾಸ್ತಿ ಎಲ್ಲ. ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್
very long back amount was lent by him.
One date may fix, lordship, in later date also may be fixed. So later on we'll not should run around the court for posting.
Heard the appellate counsel and also the counsel appearing to the respondent. This appeal is filed against the divergent finding of the lower courts. And trial court convicted the accused, directing the accused to pay of rupees 4,52,000, and the same was reversed in the appeal, and hence matter requires reconsideration. Admit records are already received, and hence list the matter immediately after summer vacation for final hearing.
33.
Pratap VS.
Memo for withdrawals. Case withdraw
ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಬೆಳಗ್ಗೆ ಯಾರು ಹೇಳಿದ್ರಲ್ರಿ ಇದ್ರಲ್ಲಿ ಏನೋ ಮೆಮೋ ಅಂತೇನ, ಏನೋ ಲಿಬರ್ಟಿ, ಈಗ ಲಿಬರ್ಟಿ ಬೇಡವಾ, ಬೇರೆ ಮೆಮೋನ? ಈಗ ದಿ ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಫೈಲ್ಸ್ ಮೆಮೋ seeking permission of this court to withdraw the appeal and hence permitted to withdraw. 34 TV Vijayaraghavan. ಇದು ಅಷ್ಟೇ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಂಗಿದೆ.
ಹೌದು.
Issue notice against the respond number 2. ಸಾರಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆ. ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದಾಗ ಯಾಕೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ? ಮಾಡ್ಬೇಕಿತ್ತಲ್ವಾ?
ಹೌದು,
ಮತ್ತೆ
ಎಲ್ಲ ಮಾಡಿದ್ರು.
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಸ್ ಸೂನ್ ಆಸ್ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ರಿಸೀವ್ಡ್. ಅಲ್ಲಿ ಸಾರಿ ಬಂದಿದಲ್ಲ, ಹಾಗಾದ್ರೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 28/4 ನೋಡೋಣ ಅಷ್ಟರೊಳಗೆ ಜಾರಿಯಾಗಿ ಬರುತ್ತೆ. 35 ಸಿರಾಜುದ್ದೀನ್ ಅಹಮದ್ A2 appeal 20 years.
A2 is the woman, my lords, having 4 children. She is a woman, my lords, having 4 children, my lords.
Are impleading an application ಆಗ್ತಂಗಿದೆ?
Impleading for the respondent, my lords.
Yeah,
respondent ಮಾಡಿರಲಿಲ್ಲ, victim complainant ಗೆ respondent ಮಾಡಿರಲಿಲ್ಲ, so that impleading application.
ಈ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಇಸ್ ಹೆಲ್ಡ್ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಆಗಿದೆ.
Sufficient.
ಯಾವಾಗ ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್?
Last date.
ನೋಟಿಸ್ ಇಶ್ಯೂಡ್ ಅಗೇನ್ಸ್ಟ್ ಇದು ಮೋಸ್ಟ್ಲಿ ಅಯ್ಯ ಅಲೋ ಆಗಿಲ್ವಾ ಮೇಡಮ್? ಅಯ್ಯ ಅಲೋ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದಾರ?
Yes, my lords, ಅಯ್ಯ ಅಲೋ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಯ್ಯಗೆ ಮೇಲೆ ಯಾಕೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕ್ರಿ? ಸ್ಟ್ಯಾಟ್ಯೂಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಸೇಸ್ ಟು ಮೇಕ್ ದೆಮ್ ಆಸ್ ಪಾರ್ಟಿ. ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಒಂದು ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟು ಕೇಳ್ಬೋದು, ಬೇಲ್ ಕೊಡೋದ್ರ ಬಗ್ಗೆ ಮಾತ್ರ ಕೇಳ್ಬೇಕಷ್ಟೇ, ನಾಟ್ ಫಾರ್ ಮೇಕಿಂಗ್ ದೆಮ್. ಏನಾಯ್ತು? ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಅಂತ ಮಾಡ್ಬಿಟ್ರಾ? This court has issued notice against respondent number 2 on IA number 1 of 25, and notice is served on the mother of victim and unrepresented, and for the reasons stated in the accompanying application and affidavit, IA is allowed. The appellant counsel is directed to amend the cast title and file amended cast title within 1 week. List this matter on 9/4.
It's already amended, my lords. Amended, my lords.
ಯಾವಾಗ ಅಮೆಂಡ್ ಹೆಂಗ್ ಮಾಡಕತ್ರಿ? ಅಯ್ಯ ಅಲೋ ಮಾಡದಲ್ಲೇನೆ?
Let's last date filed, my lords, and amended.
ಅಯ್ಯ ಅಲೋ ಆಗಿದೆ ಮೇಡಮ್, ಮೊದಲೇನೆ ಇಲ್ಲಲ್ಲ, ಮತ್ತೆ ಹೆಂಗ್ ಇವ್ರು ಅಮೆಂಡ್ ಮಾಡ್ತಾರೆ? ಆಯ್ತು, ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕಿ.
ಏನು ಅಮೆಂಡ್ ಮಾಡಿಲ್ಲ ಸರ್.
Needful said to have been done heard. ಹಾಗೆ ಮಾಡಿಲ್ಲ ಮಾಡ್ಬಿಟ್ಟು ಹಾಕಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವ್ದಾರು ಡೇಟ್ ಕೊಡಿ. 9/4 ನೋಡೋಣ, ಅಷ್ಟರೊಳಗೆ ಬರೋಂಗಿದ್ರೆ ಬರಲಿ ವಿಕ್ಟಿಮ್ ಕಡೆಯವ್ರು.
36
ಅದೇನೋ ಆಯ್ತಲ್ಲ, ಇದು ರಕ್ಷಿತ್ ಆರ್ ಏನೋ ಟೈಮ್ ಕೇಳ್ದಂಗಿತ್ತು ಮೇಡಮ್.
It's appearing for appellant, my lords. Lords, ಇದಲ್ಲ R2 ಇದಾರೆ, my lords.
ಏನೋ ಟೈಮ್
R2 ಇದಾರೆ, my lords. Notice.
ಆಯ್ತು. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನೆಸ್ಟ್ R2 ಮಾಡಿದಿರಿ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿ
ಆಗಿದೆ, my lords.
through court, and also issue notice through IO, and the counsel for the appellant is directed to serve one more copy to the additional SPP to serve the same through IO.
Please, my lord.
ಆಯ್ತು. List this matter on 21/4.
Grateful.
37.
Somashekara KH.
I am permitted to withdraw, my lord.
ಮಧ್ಯಾಹ್ನ
I am permitted to withdraw the appeal.
withdraw the appeal. ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ.
Since my lord already criminal petition filed. Criminal petition stay ಆಗಿದೆ.
Stay ಆಗಿದೆಯಾ? ತಗೊಳ್ಳಿ. Counsel for the appellant would submit that the criminal petition is filed in criminal petition number 2745 of 2025, and stay is granted, and hence seeks permission of this court to withdraw the appeal, and hence permitted to withdraw.
Liberty member. Liberty member.
ಏನ್ ಲಿಬರ್ಟಿ? ಲಿಬರ್ಟಿ ಏನ್ ಬರ್ತದ್ರಿ?
ಸಪೋಸ್ ಅದೇನಾದ್ರು ವಜಾ
ಲಿಬರ್ಟಿ ಏನಿಲ್ಲ, ಬಂದ್ರೆ ಅಲ್ಲೇನಾದ್ರು ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಆಮೇಲೆ ಫ್ರೆಶ್ ಪಿಟಿಷನ್ ಹಾಕೊಳ್ಳೋದು ನೀವು ಅಷ್ಟೇ.
ಅದಕ್ಕೆ ಒಂದು ಲಿಬರ್ಟಿ ಬಂದು.
ದಟ್ ಈಸ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ರಿಸಲ್ಟ್ ಅಷ್ಟೇ. Next, 38, special leave, delay of 1048 days.
Lord, this is the 138 acquittal, my lord. There is second round of
1048 days can delay in ಹೇಳಿ first.
That, my lord, they are both the complainant and his wife admitted to hospital for various illness, my lord. Open heart surgery.
Documents ಏನಾದ್ರು ಹಾಕಿದೀರಾ?
My lord.
Documents ಹಾಕಿದೀರಾ ಅದಕ್ಕೆ?
Documents ಹಾಕಿಲ್ಲ sir.
ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ
kindly issue
1048 days delay ಅಂತಂದ್ರೆ
I'm having the documents, my lord.
ಕೊಡಿ, ಹಾಕಿ ಆಮೇಲೆ ನೋಡೋಣ. The counsel seeks time to place on record the medical records with regard to the delay in filing the appeal, and hence list this matter on 9/4.
Right.
Remaining matters at 2:30.
Your lordship, sir. I am extremely sorry. I was on my legs in the other court, my lord. Serial number 30, my lords.
At least your counsel would have made mention before hearing the matter.
I wanted to.
ಅಲ್ವಾ?
I am extremely.
ಇವ್ರಿಗೆ ಹೇಳಿದೆ ನಾನು, ಡೆಫರ್ ಆದ್ರೆ ಮತ್ತೆ ರೀಚ್ ಆಗೋ ಡೌಟ್ ಅಂತ. ಏನಾಗ್ತದೆ ನಾವೀಗ ಪಾಠ ಮಾಡ್ಕೊಳ್ಳಂಗು ಇಲ್ಲ. ಈಗ ಪಾಠ ಆಗ್ಬಿಟ್ರೆ ಮತ್ತೆ ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಬಣ್ಣ ಕಟ್ಟೋದೆಲ್ಲ ಬೇಡ. ಅದ್ ಯಾಕ್ಬೇಕು ನಮ್ಗೆ?
ಇಲ್ಲ, this is made parted long back.
ಏನ್ ಯಾವಾಗ ಇಬ್ರು ರೆಡಿ ಇರ್ತೀರಿ, ಹಿಯರ್ ಮಾಡ್ತೀವಿ, ಡಿಸ್ಪೋಸ್.
This is already parted ಮಾಡ್ತೆ. Since afternoon only 1 hour, my lords, this will take some time for me to submit, my lords.
ಅರ್ಜೆಂಟ್ ಮಾಡೋದಿಲ್ಲ
ಅಲ್ಲ, 1 ಗಂಟೆ
ನೀವೇ ಬಂದು ಹೇಳಿ ಅಷ್ಟೇ. ಏನ್ 1 ಗಂಟೆ
ಅಲ್ಲ, ಆಫ್ಟರ್ನೂನ್ 2:30
ಬಂದು ಹೇಳಿ, ನೀವು ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ. ಇಲ್ಲ ಕೇಳಿ.
I may be excused for submitting 2:30.
I heard the revision petition of counsel.
I am ready, my lord.
It will be fresh in my memory.
Please, I do.
Come and assist the court. I will hear and dispose of the matter.
Please.
Revision scope is very limited.
Please.
You argue within the limit. ಅಷ್ಟೇ.
Great.
ಆಯ್ತಾ? ಎಲ್ಲ ರೆಫರ್ಡ್
Last time,
TCR ನಿನ್ನೆ ಕಾಲ್ ಆಗಿರೋದಾ? ಹೌದು ಕಳಿಸ್ತಾರೆ. ಇನ್ನೇ 31. ಅಲ್ಲ ಸರ್ ಕಳಿಸ್ತಾರೆ.
ಪಾಸ್ ಮಾಡ್ಬಿಡೋ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಕಾಲ್ ಫಾರ್ TCR. ಮೇಡಮ್ 3:30 ತನಕ ಯಾವುದು ರೆಫರೆನ್ಸ್ ಇದೆಯಾ? 3:30 ತನಕ ಸಿಟ್ಟಿಂಗ್
3:30 3:45.
ಇದೊಂದು ಫೈಲ್ ಸರ್ ಫೈಲ್
ಬಂದೆ.
ಯಾರೋ ಒಬ್ರು ಕೊಟ್ಟಿಲ್ವಂತೆ ಏನೋ ಗಲಾಟೆ ಮಾಡಿದಾರಂತೆ ಅಂತ ನ್ಯೂಸ್. ಅದು ಹೆಂಗೆ ಅಂತ ಅರ್ಥ ಆಗಲಿಲ್ಲ, ಅದೇನು ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಅಂತ ಅರ್ಥ ಆಗಲಿಲ್ಲ. ಹೇಳ್ತದೆ ಏನೋ ರೆಫರ್ ಟು ಲೋಕಲ್ ಅದು ಡೇಟಿಂಗ್ ಇಲ್ಲ, ಅದೆಲ್ಲಿ ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೋ ಅಲ್ಲಿ
ನೋಟಿಫೈ ಮಾಡ್ತಾರೆ.
ಬೆಳಿಗ್ಗೆನೇ ಎಲ್ಲಾನು ರೆಫರ್ ಟು ಲೋಕ್ ಅದಾಲತ್ ಆಗಿದೆ. ಅದಿರೋದೇ ರೆಫರ್ ಟು ಲೋಕ್ ಅದಾಲತ್. ನೋಡ್ಲಿಲ್ವಾ ನೀವು? ನಿಮ್ಮ ಸೀನಿಯರ್ ಅಲ್ಲ, ಇಲ್ಲಿ ನೋಡಿ ಮೇಡಮ್, ಸೀನಿಯರ್ ಹೇಳೋದಲ್ಲ ನೋಡಿ. ಫಾಲೋಯಿಂಗ್ ಕೇಸಸ್ ಆರ್ ಲಿಸ್ಟೆಡ್ ರೆಫರಿಂಗ್ ಟು ಲೋಕ್ ಅದಾಲತ್ ಅಂತ ಇದೆ, ನೀವು ನೋಡಿಲ್ಲ ಮೇಡಮ್. ಇಲ್ಲ ರೆಫರ್ ಟು ಲೋಕ್ ಅದಾಲತ್ ಆಗುತ್ತೆ. ಲೋಕ್ ಅದಾಲತ್ ಅವರು ಇಷ್ಟಿಷ್ಟು ಫೈಲ್ಸ್ ಅಂತ ಅವ್ರು ಹಾಕ್ತಾರೆ. ಯಾವಾಗ ನೆಕ್ಸ್ಟ್ ಲೋಕ್ ಅದಾಲತ್ ಇರುತ್ತೋ ನೆಕ್ಸ್ಟ್ ತಗೊಳ್ತಾರೋ ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟು ಹಾಕ್ತಾರೆ. ಇವತ್ತಿಂದಲ್ಲ, ಇವತ್ತು ಬರ್ದಿದ್ದು ಮೇಡಮ್ ಕೇಳಿದ್ರೆ ಮೇಡಮ್ ಬೇಕಾಗುತ್ತೆ.
ಮೇಡಮ್ 60 ಪಾಯಿಂಟೆಡ್ ಆಗುತ್ತಾ ನೋಡಿ.
ಲಾಸ್ಟ್ ಮ್ಯಾಚ್ ಅಲ್ವಾ?
ಹೌದು 230.
ಇಲ್ಲ ಮಾತಾಡಲ್ಲ, ಅದು ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ 230 ಅಂತ ಆಗಿದೆ ಅಷ್ಟೇ.
ಇಲ್ಲ ಇಲ್ಲ ನೋಡಿ,
ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ.
ಮಾತಾಡ್ ಅಂತ ಆಗಿದೆಯಾ?
It may be taken as part of an submission ಇದೆ ನಮ್ಗೆ.
ಅಲ್ಲ, ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಟು ಟೇಕ್ ಇನ್.
ಪಾಸ್ವರ್ಡ್ ಬದಲ ಎಷ್ಟಿಗೆ
$230 ಬಂತಲ್ಲ 230 ಇದು ಒಂದೇ ಕೊಡ್ತೀನಿ. ಏನೋ ಕೈ ನೋವು ಸೊಂಟ ನೋವು ಚೇಂಜ್ ಮಾಡಿಸ್ಕೊತೀನಿ. ದಿನ ಏನ್ ತಿಂದ್ಯಮ್ಮ ಅಂದ್ರೆ ಬ್ರೆಡ್ ಕಾಫಿ ಅಂತ 6 ಕರಿತೀನಿ ಸರ್, ಕರೆದ್ಮೇಲೆ ಕರಿತೀನಿ ಕಾಲು. ಅವಳಿಗೆ ಬಿಸಿಬೇಳೆ ಭಾತ್ ಇಷ್ಟ ಆಗಲ್ಲ, ಆಮೇಲೆ ವೆಜ್ ಏನೋ ಪಲಾವು ವೆಜ್. ಅವರು ಕರ್ನಾಟಕದವರು ಅದನ್ನ ಇಷ್ಟಪಡಲ್ಲ. ಕರ್ನಾಟಕದಲ್ಲಿ ಸಾಮಾನ್ಯವಾಗಿ ಏನು ರೈಸ್ ಐಟಮ್ಸ್ ತಿನ್ನೋದು. ಹಾರ್ಡ್ ಇರ್ಬೇಕು ತಿನ್ನಬೇಕು. ಯಾರೇ ಕರ್ನಾಟಕದವರು
ಬೇರೆ ಬೆಂಚಲ್ಲಿ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಎರ್ಲಿಯರ್ ಇದ್ದವರು. 60 ಕರೀರಿ ಏನದು.
60.
I want to bring to your lordship's kind notice, the order passed on 24th, my lords. 24/2/2025, my lords. Because it was supposed.
ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲ?
ಹೌದು ಸರ್.
ಹೇಳಿ ಏನು?
It was supposed to proceed before coordinated with minutes for further hearing. Certain directions have been issued.
Is called as Vijay Kumar Majgal, learned counsel, also for directions issued by this court is also. ಹೇಳಿ. ಅವರ ಪಾಠಾಡ್ ಅಂತ ಮಾಡ್ಕೊಂಡಂಗ್ ಮಾಡಿದಾರಲ್ಲ. ಇದಿದೆ ಅಲ್ರಿ. Taking note of the fact that this court has spent sufficient time on the subject and has noticed vacuum in the Prisons Act and rules having regard to the fact that if a convict fails to adhere to the instructions of the jailer, what course to be adopted by the jail authorities, especially when the convict is physically able to undergo the task that has been assigned to him as a part of rigorous imprisonment. Therefore, list this matter on 3rd April 25 at 2:13 ಅವರೇ ಟೈಮ್ ಇಸ್ಕೊಟ್ಟಾರ. ಅವ್ರ ಮುಂದೆ ತಗೋಬೇಕಿತ್ತು, ಯಾಕೆ ನಮ್ಮ ಮುಂದೆ ಯಾಕೆ ಹಾಕಿದ್ರು?
It was listed for final hearing, my lords, before your lordships.
ಅದಕ್ಕೆ ನಾವೇನ್ ಮಾಡೋಣ, ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ಈ ತರ ಆರ್ಡರ್. ಟೇಕಿಂಗ್ ನೋಟ್ ಆಫ್ ದಿ ಫ್ಯಾಕ್ಟ್ ದಟ್ ದಿಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಸ್ಪೆಂಡ್ ಸಫಿಶಿಯಂಟ್ ಟೈಮ್ ಆನ್ ದಿ ಸಬ್ಜೆಕ್ಟ್ ಅಂತ ಇದೆಯಲ್ಲ, ಅವ್ರ ಮುಂದೆ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕಿತ್ತು. ಅವ್ರನ್ನ ಕೇಳ್ಕೊಂಡ್ ಮಾಡ್ಬೇಕಿತ್ತು, ನಮ್ಮ ಮುಂದೆ ಯಾಕೆ ಹಾಕಿದ್ರು? ಆರ್ಡರ್ ಅಂತ ಇಲ್ಲೇ ಇರ್ಬೋದು, ಬಟ್ ದೇರ್ ಇಸ್ ಎ ಸ್ಪೆಸಿಫಿಕ್ ಆರ್ಡರ್ ಟು ಪ್ಲೇಸ್ ದಿ ಮ್ಯಾಟರ್ ಆನ್ 3rd April 2025 at 2:13.
Just I brought your lordships kind notice, my lords, previous order.
ಏನ್ರಿ ಅವ್ರು ಕೊಟ್ಟ ಮುಂದೆನೆ ಹೋಗ್ಬೇಕು, ಬೇರೆ ಕಡೆ ಹೋಗಕ್ ಬರಲ್ಲ ಇದು.
And today it is posted for final hearing, my lords, before your lordships. It is posted for final hearing before your lordship, my lords.
Observation ಇದೆ.
That's that, my lords.
Taking note of the fact that this court has spent sufficient time on the subject and has noticed vacuum in the Prisons Act and rules having regard to, mostly ಅವ್ರ ತಲೆಯಲ್ಲಿ ಏನೋ ಇರಬೇಕು ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡಕ್ಕೆ, ಅಮೆಂಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಥವಾ ರೂಲ್ಸ್ ನ ಇನ್ ಕೇಸ್ ಇಫ್ ದಿ ರಿಗರಸ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಇದ್ದಾಗ.
Once rigorous imprisonment was ordered, if he is not
that is not adhere to the
direction
of the court, then what would be the course of action ಅಂತ. ಕೋರ್ಸ್ ಆಫ್ ಆಕ್ಷನ್ ಗೆ ಪ್ರಿಸನ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಅವರು, ಜೈಲ್ ಮ್ಯಾನ್ಯೂಲ್ ನಲ್ಲೂ ಇಲ್ಲ ಅಂತ. ಅದಕ್ಕೆ ಏನಾದ್ರು ಒಂದು ಡೈರೆಕ್ಷನ್ ಏನು ಕೊಡ್ತಾರೆ ಅವ್ರ ತಲೆಯಲ್ಲಿ ಅದಿರ್ಬೇಕು ಮೋಸ್ಟ್ಲಿ. ಅದಕ್ಕೆ ಹೆಂಗ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ. ಆಯ್ತು, ಅವ್ರ ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ಕೊಂಡು ಹಾಕೊಳ್ಳಿ, ನಾನು ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡ್ತೀನಿ ಈಗ ತಗೊಳ್ಳಿ. Perused the order passed by this court, wide order dated 24/2/25, and this court having spent sufficient time on the subject and has noticed a vacuum in the Prisons Act and rules having regard to the fact that if a convict fails to adhere to the instructions of the jailer, what course to be adopted by the jail authorities, especially when the convict is physically able to undergo the task that has been assigned to him as a part of rigorous imprisonment, and hence fix the date for today and also timings. And when such observation is made in the order, it is appropriate to place the same before the very same bench and list this matter. ಅವರಿಗೆ ಇಲ್ಲಿ ಇಲ್ವಾ ಮೇಡಮ್?
ಇಲ್ಲ
ಇಲ್ಲೇ ಇದಾರಲ್ಲ,
ಧಾರವಾಡ ಬೆಂಚ್
ಶಾನಂದ್ ಅವರು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವ್ದಾದ್ರು ಫ್ರೈಡೆ ಮಧ್ಯಾಹ್ನ ಬೇಕಾದ್ರೆ ಮಾಡಿ, ಯಾವ್ದಾದ್ರು ಫ್ರೈಡೆ ಹಾಕ್ಸಿ. 9/4 ಫ್ರೈಡೆ ಯಾವ್ದು ಬರುತ್ತೆ? ನೆಕ್ಸ್ಟ್
25th
11th ರಜಾ ಮತ್ತೆ ಹಾಗಾದ್ರೆ
25th
ನಾಳೆಗಾಗುತ್ತಾ ಅಥವಾ 25th? 25th of April. ಅವರು ಬ್ರಾಂಚ್ನವ್ರಿಗೆ ಕೇಳ್ಕೊಂಡು ಅವ್ರ ಟೈಮಿಂಗ್ಸ್ ಏನು ಅಂತ ಕೇಳ್ಕೊಂಡು ಹಾಕ್ಸಿ ಅಷ್ಟೇ. ಅಥವಾ ನಾವು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋದಕ್ಕಿಂತ ಅವ್ರನ್ನೇ ಕೇಳ್ಕೊಂಡು ಯಾವ್ದಾರು ಹಾಕ್ಬಿಡ್ಲಿ, ಅವ್ರು ಯಾವ ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ಅಂತ ಹಾಕಿ ನಾನ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಬಹುದು. ಯಾಕೆಂದ್ರೆ ಮತ್ತೆ ಲಾಸ್ಟಿಗೆ ಉಳಿಯೋದೇ 3 days ಆಫ್ ಏನೋ ವೆಕೇಶನ್ ಗಿಂತ ಮುಂಚೆ. ಲಿಸ್ಟ್ ದಿ ಸೇಮ್ ಬಿಫೋರ್ ದಿ ವೆರಿ ಸೇಮ್ ಬೆಂಚ್ ಅಂತ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ ಸಾಕು. ನಿಮ್ಗೆ ಯಾವಾಗ ಲಿಸ್ಟ್ ಯಾರು ಇಲ್ಲೋ ಅಲ್ಲ ಇದಾರ? ಆಯ್ತು, ದ ಸೆಂಟ್ರಲ್ ಪ್ರಿಸನ್ ಯಾರವರು?
ಚೀಫ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್
ಆಫ್ ಜೈಲ್ ಈಸ್ ಆಲ್ಸೋ ಅಪಿಯರ್ಡ್ ಥ್ರೂ ವಿಸಿ
ಮೈಸೂರು ಸೆಂಟ್ರಲ್ ಜೈಲ್.
ಅವ್ರೀಗ ಯಾವ ಡೇಟ್ ಒಂದು ನಾವು ಫಿಕ್ಸ್ ಮಾಡಕ್ಕಲ್ಲ, ಬಟ್ ನೀವೇ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ಬೇಕು. ನೀವು ಸ್ಟೇಟ್ಗೆ ಅಪಿಯರ್ ಆಗ್ತಿರಲ್ಲ, ನೀವು ಲಿಸ್ಟ್ ಆದಾಗ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಅಷ್ಟೇ. ನೀವು ಅಡಿಷನಲ್ SPP ಅಲ್ವಾ?
SPP2
SPP2 is directed to intimate the concerned DGP prison ಅಂತೇನೋ ಇದ್ದಂಗೆ ಇದೆ.
DIG actually it should be DIG prisons.
DIG ನದು DIG prison when the matter is listed before the concerned bench. ಹೇಳಿ ಹೇಳಿ ನಿಮ್ಗೆ ಹೇಳ್ಬಿಡಿ ಅದೇ.
Please. I am grateful. My lord, this is a revision petition filed by the instance of the first informant.
It has already read the evidence.
Please.
Only you argue regarding grounds.
Please. May I beg to submit
30 ಅಲ್ಲ? Serial number 30. ಹೇಳಿ.
My lord, the initial complaint filed by the father.
ಆಯ್ತು ಅದೆಲ್ಲ ಫಾದರ್ ನೋಡಿದೀನಿ. ಫಾದರ್ ಏನ್ ಹೇಳ್ತಾರೆ ಎಲ್ಲ ಚೆನ್ನಾಗಿದ್ರು ಏನಿಲ್ಲ ಅಂತ ಆಮೇಲೆ
My lord, since this
later on one more complaint was given by the mother.
After 3 days.
That's some improvement.
Please, my lord. Now, my lord, kindly see the judgment of the trial court, my lord, to appreciate whether it's legally any perversity or illegality is there in the judgment, my lord. Kindly permit me to read the judgment itself. I don't have the paper book.
Judgment ಹೇಳಿ ಸಾಕು.
Judgment ಅಲ್ಲಿ
Evidence already
page number 7, para 27. Para 27 mentions about the complaint of 1908.
ಅದೇ ಮದರ್ದು.
Mother iddo. Now, my lords, kindly see, turn to para 32. It is very significant to note that on 16/8/2005, father of Rashmi by name Nityananda Gowda had lodged a complaint before Sulya police. He has received the information over the phone that on so and so his daughter and his grandson found to be missing, and also he came to know that he has reached Sulya that his daughter and son have committed suicide by jumping to the Payaswini river. Further, this is a that he has jumped to commit suicide is itself a hearsay.
And there was no oath, but
in his complaint, he has stated that his daughter and son-in-law were living very cordially. There is no misunderstanding among them. His daughter had committed suicide by frustrating in her life. Hatashe gundu shabda ide. It is also stated his daughter has thrown his grandson to the river and his daughter is responsible for the death of the grandson. Request the police to find out the body. On the strength of the said complaint, my lord, police have registered the case of 302 because daughter has thrown the baby. Crime number 113. 302. Moreover, it is shown that on 22/8/2005, body of Rashmi was found in river so and so. On 17/8, further statement, the very same complaint he has unequivocally stated that his daughter was given in marriage to so and so. There was no talks regarding dowry. He is residing cordially with son-in-law. This on 17/8. He has also not come across any ill treatment. 34. In the earlier complaint, in the light of the earlier complaint dated.
Complaint plus statement.
Illa. Deemed necessary to discuss. Next, para 35 discusses, my lords. Now, kindly see para 35. Though PW1 has spoken about the ill treatment of so and so and so, but during the course of cross-examination, she has unequivocally admitted that on 16/8 in the complaint, she has stated that her daughter and son-in-law were cordial. 16/8, my lord, executive magistrate had come, she was also questioned. Police had also come, she was also questioned. And she states she was lodged a complaint on so and so and stated that they were cordial. Further, during the course of cross-examination, stated after death of so and so, husband had gone to the house of the accused and demanded to return 17 pound. The problem starts here. 2 of gold from the accused, but accused have not agreed. Thereafter, they had a deliberation in their house and thought of lodging the complaint. Accordingly, they have lodged the complaint P1. Looking to the version of it, it's quite evident that when the accused have refused to hand over the gold as demanded by the husband, then the complaint was filed. Next page 11. ನನ್ನ ಮಗಳು ಹಟ್ಟಿ ಕೆಲಸ ಮಾಡುವಾಗ ಮಗನ ಸ್ವಯಂ ಹತ್ತಿರ ಬಿಟ್ಟು ಹೋಗುತ್ತಿದ್ದಳು. ಎರಡನೇ ಆರೋಪಿ ಮಗನ ಮೇಲೆ ಪ್ರೀತಿ ಇತ್ತು. ಅತ್ತೆ ಮತ್ತು ಗಂಡನಿಗೆ ನನ್ನ ಮಗಳ ಮೇಲೆ ಪ್ರೀತಿ ಇತ್ತು.
ನನ್ನ ಮಗಳ ಮೇಲೆ
ಪ್ರೀತಿ ಇತ್ತು. Looking to the above version taken wherein deceased Rashmi is to live with her husband so and so when she used to attend a work and accused 1 and 2 had love and affection for daughter. Para 36. Looking to the version of P1, quite evident that first of all, as per the complaint lodged by the father, there is no ill treatment to the Rashmi, and moreover accused had love and affection. Apart from that, complaint as per P1 came to lodge only after an afterthought. That too when the accused refused to return the gold. Then my lord, PW2.
ಇದು ಎಲ್ಲಿಂದ ಬಂತು ಇದು refused to return the gold ಅನ್ನೋದು?
Cross examination ಅಲ್ಲಿ.
ಕ್ರಾಸ್ ಅಲ್ಲಿ
ಅವ್ರು ಒಪ್ಕೊಂಡವರೆಲ್ಲ. ಆ ನಂತರ ನಾವು ಬಹಳ ಆಲೋಚನೆ ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡುವಂತ ತೀರ್ಮಾನ ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ವಿ.
ದುಡ್ಡು ಕೇಳಿದ್ವಿ, ಅಲ್ಲಿ ಗೋಲ್ಡ್ ಕೇಳಿದ್ವಿ,
ಆ ನಂತರ ನಾವು ಆಲೋಚನೆ ಮಾಡಿ ಕೊಟ್ವಿ. And also kindly see the very same
PW1 ಕ್ರಾಸ್ ಅಲ್ಲಿ.
ಹೌದು, very same PW1, my lords. She was questioned by the police on 16/17. No allegation. She says
ಅವಾಗ ಏನು ಹೇಳಿಲ್ಲ.
ಏನು ಹೇಳಿಲ್ಲ, she admits it and it's a part of the record. Because one body was found on 16th. ಆ ಇನ್ಕ್ವೆಸ್ಟ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಇದೆ, ಅದರಲ್ಲಿ ಏನು ಸಮಸ್ಯೆ ಏನಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Then PW2 learned trial judge says ಅವಳಿಗೆ ಎನಿಮಿಟಿ ಇದೆ ಅಂತ ಒಪ್ಕೊಳ್ತಾನೆ. PW2 ಮೊದಲಿನ ಮಾತುಕತೆ ಇಲ್ಲ. PW2 ನೇಬರ್.
PW2 ಅದು ಗೊತ್ತಾಯ್ತು, ನಾನು ಆಗ್ಲೇ ಅವರಿಗೆ
ಹೇಳ್ತಾನೆ. And my lord, now kindly see turn to page 14. Para 43. This is also relevant. This is a case of, kindly see Payaswini river, my lords, in Sulya, Subramanya. It is overflowing in the August in that part. And kindly see this is very important. Para 43. There was no suicide at all. On the strength of the complaint lodged by father so and so, earlier complaint wherein the police had drawn the spot margin on 17/8. It is stated as noted as follows. ತಕ್ಷುರು ಸ್ಥಳ ಸುಳ್ಯ ತಾಲೂಕು ಅಲೆಟ್ಟಿ ಗ್ರಾಮದ ಪಾಲಕ ಎಂಬಲ್ಲಿ ರಶ್ಮಿಯು ಮೈದುನ ಕರುಣಾಕರ್ಮ ಸೇರಿದ ಅಡಿಕೆ ತೋಟದ ದಕ್ಷಿಣ ಬದಿಯಲ್ಲಿ ಪಯಸ್ವಿನಿ ಹೊಳೆಗೆ ಇಳಿಯುವ ದಾರಿಯಲ್ಲಿ ಆಗಿರುತ್ತದೆ. ಈ ಸ್ಥಳದಲ್ಲಿ ಒಂದು ಕಡೆ ಮಣ್ಣು ಸ್ವಲ್ಪ ಜರಿದು ಹವಾಯಿ ಚಪ್ಪಲಿ ಜಾರಿದ ಗುರುತು ಇತ್ತು ಎಂದು ಸಾಕ್ಷಿದಾರರು ನುಡಿಯುತ್ತಾರೆ. ಅವರ ಕೇಸ್ ಇಸ್ ದೇ ಅಡ್ಮಿಟೆಡ್. ಪಂಪ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪಂಪ್ ಇರೋದು ಅಲ್ಲೇ, ಪಯಸ್ವಿನಿ ನದಿ ಮೇಲೇನೆ ಪಂಪ್ ಇರೋದು. ಪಂಪ್ ಆನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಳೇ ಹೋಗೋದು, ಮಳೆಯಲ್ಲಿ ಹೋಗಿದ್ದಾಳೆ, ಹೋಗುವಾಗ ಜಾರಿ ಬಿದ್ದಿದೆ. ಇಟ್ಸ್ ಅವರ್ ಡಿಫೆನ್ಸ್. Nobody has seen this. This is based on this probability. Para 44. Even the further statement Pillar 1 recorded in 17.8 is also asserts there is a sign of mud being slipped. Even the statement of Padmaya K also stated in the same fashion. If the reliance is placed on the contents of the complaint lodged by father in crime number 113, also the spot measure, also stated by witnesses, it clearly goes to show that Disi Rashmi had gone to the pump shed to start the motor. She has slipped into Payaswini river. Next matter 45 is very pertinent to note that during the course of cross-examination, Pillar 1 has stated ಪಯಸ್ವಿನಿ ನದಿ ಹತ್ತಿರ ಇರುವ ಪಂಪಿನಿಂದ ನೀರು ಬಿಡಿಸಲು ನನ್ನ ಮಗಳು ಹೋಗುತ್ತಿದ್ದಳು. ಒಮ್ಮೆ ವಿದ್ಯುತ್ ಶಕ್ತಿ ಹೋದ್ರೆ ಪುನಃ ಪಂಪ್ ಶೆಡ್. These are rural life, how it happens, my lords. Para page number 15, same thing. Then the decision, so the honorable court holds that there was no material. Now, my lord, as far as the honorable court exercise the revision is concerned, my lord, there should be some perversity and total illegality, etc. Otherwise, my lord, it will not be. The honorable court will not interfere, my lords. And also kindly see throughout the version is kole madidare. That was the version, and that comes later. And there is a 313 statement filed by the accused also, wherein they have stated this, my lords. So considering all the facts, my lord, the trial judge has come to this conclusion. May, with kind permission, my lord, pass on the recent decision of the Honorable Supreme Court as far as the power of the Honorable Revisional Court is concerned, my lord, in a case of acquittal. Please. So nothing is alleged that the learned magistrate has committed any perversity in his approach. Now, my lord, as far as the para, kindly see, my lord, the discussion para 39. Proceedings in the position of law. Adrolage. Para 30. This court in Bindeshwari Prasad Singh laid down there is a limit to the powers of the court, revisional court. We have carefully examined the material on record dash ladmele. May I read it with kind permission, my lord?
Para 12.
Oh, para 12. We have carefully considered the material on record and satisfied the High Court was not just reappreciating so and so and so under.
It is neither possible nor advisable to make an exhaustive list of circumstances in which exercise of revisional may be justified. But decision of this court have laid down the parameters of exercising of revisional jurisdiction by the High Court.
Please.
104.
401. And then para 40 recent 2022 view, my lords. There para extracted portion last sentence I beg to read, my lords. The High Court has revisional power to examine whether there is manifest error of law or procedure. Manifest, however, after giving its own findings and on the findings recorded by the court, accused
remit the matter to the trial
court, if required, only remit, that it cannot be converted into conviction. This is the view, my lords.
Yes.
And para 41 also, my lords. Then kindly see para 42. 42, my lords. I beg to read the extracted portion. Interference with order of acquittal is called for.
Cannot convert into a conviction.
And only in exceptional cases where there is manifest error of law, of procedure, resulting in miscarriage of justice. And accused has been, acquittal is caused by shutting out evidence which otherwise ought to have been considered. So, my lord, with regard to these facts, my lords, my respectful submission is, none of the reasons assigned by the trial judge, my lords, is neither perverse nor illegal or any incorrectness, my lords. On the other hand, has properly appreciated in this case, my lords. Facts of the case, my lords. And prosecution witnesses, my lord, they were also not knowing anything. They were saying murder agirbodu. This all I understand, my lord, how it happens, my lords. And accidentally death has happened, my lords. A doubt arises naturally, my lords. And now no doubt was their initial stage. After 3 days, when we refused to return the gold ornaments, doubt arises. It's concocted story, my lords. They have been harassed with this complaint. In fact, there was no such allegations. And the allegations who are making those allegations for illicit relationship, etc., are the neighbors with whom there is no, they are not in talking terms at all. They admit, ನಮ್ಮ ಮಾತುಕತೆ ಇಲ್ಲ, ಅವ್ರ ಮನೆಗೆ ನಾವು ಹೋಗೋದಿಲ್ಲ, ಆ ಫಂಕ್ಷನ್ ನಾವು ಹೋಗೋದಿಲ್ಲ. Those persons start making the spreading false rumors. And they now join hands with the my lords with them after 19.
Yes. Lord, heard the revision petition of counsel and also the counsel appearing for the respondent. this appeal is filed against, this revision petition is filed against the order of acquittal passed by the trial court for the offence punishment 498A and B, A and B, and 306 of IPC. The counsel appearing for the de facto complainant would vehemently contend that A1 is a husband of the deceased and also A2 is the mother-in-law. The complainant is the mother of the deceased. The counsel would submit that marriage was taken place on 12/11/2001 and incident was taken place on 16/8/2005 and death was taken place along with the child who is aged about 2 years old. And it is the case of prosecution that she jumped into the river on account of cruelty meted out to her within the span of 7 years of marriage. And counsel also would contend that body of the child was recovered on the same day and the body of the mother was recovered, victim was recovered on 22/8/2005. And the incident was taken place on 16/8/2005. And the first instance complaint was given by the father in terms of exhibit P15 and later on mother has given the complaint in terms of exhibit P1. The counsel would vehemently contend that the evidence of prosecution witnesses is consistent with regard to the accused was having extramarital relationship with two ladies. And trial court not properly appreciated both oral and documentary evidence and trial court carried away with the exhibit P15 and fails to take note of contents of exhibit P1 complaint given by the mother and also fails to take note of the evidence of other witnesses PW 2 to 6, PW 2 to 4 and 6. PW 2 to 6, PW 2 to 6. The counsel during the course of argument also brought to notice of this court the PW1 mother deposed before the court, particularly the contents of the evidence of PW1. She has reiterated the complaint government's exhibit P1A and also spoken about the accused was having illicit relationship with two women and their names are also mentioned in paragraph number 6. And also the ill treatment given by accused number 2, that getting the work done through the daughter of the PW1. In the cross examination it is illustrated that both husband and wife visiting their house once in a month and also the daughter of the PW1 was only doing more work and other daughter-in-law, wife of Karnataka, was not doing any household work. The counsel also relies upon the evidence of PW2, who is the neighborer, who also supports the case of prosecution with regard to the deceased was expressing her husband relationship between the other two women. And the same was known to the villagers. And this witness was also subjected to cross-examination. The other witness is father of the deceased and he deposes before the court. At the first instance, he was not aware of the ill treatment meted out to the daughter and hence he has given the complaint in terms of exhibit P51 and later waived revealed the same. But in the cross examination confronted the document exhibit D1 and admits that in the complaint dated 16/8/2006 not made any allegation against anybody else. The other witness is brother of the deceased, PW4. And he says that both of them cordial for about 2 years. And thereafter, when they comes to know about the extramarital relationship, the same was brought to the notice of accused brother Karnataka, and he promised that he would separate the things. And in the cross-examination, he admits that they went and lodged the complaint. He went along with his father to lodge the complaint and given the complaint. The other witness is also neighbor, who is PW5. And he says only due to cruelty meted to the deceased, they might have committed the suicide. And people are talking about the same. And people are also talking about the extramarital relationship. And also neighboring persons were talking about the accused was subjecting her for cruelty when the deceased came to know about the extramarital relationship. In the cross-examination, this witness also admits that he came to know about people are talking about the same, but he is not personally aware of the same. And he came to know about when the people are talking about the same. People of villager talking about the same. PW6 is another villager. And he says that accused was visiting the house of the woman Sushila. And he witnessed the same. And in the cross-examination, that Sushila was having ill will against him. And other witness is PW7. He is only a hearsay witness. And though number of witnesses are examined, PW8 also turned hostile, and PW9 is inquest witness, and PW10 is also hostile, turned hostile. PW11 major witness to exhibit P2, and PW12 is also major witness to exhibit P5. And only PW3 speaks about she found the dead body in the river, and PW14 speaks about postmortem report, and PW15 is HC, having given the FIR to the court, and other witnesses are also formal witnesses. Only evidence remains, particularly PW1 to 6. For contra, the counsel appearing for the state respondent accused would vehemently contend that the trial court in detail considered the material available on record and also taken note of ill will between the witnesses who have deposed with regard to the extramarital relationship between the accused and other two women. And PW2 categorically admits that not in talking terms from last 10 years. And other witnesses evidence also only hearsay evidence, and they says they came to know about through the villagers, and villagers were talking and no positive evidence is placed. And apart from that, trial court also having taken note of the spot measure wherein found a mark of slip from the place of incident, also taken note of and taken the material available on record, and rightly comes to the conclusion that there are no materials to convict the accused. The counsel appearing for the revision petitioner also relied upon the judgment 2018 within bracket 9 Supreme Court cases 6-1, wherein discussion was made that husband having illicit relationship with another woman established as causes for suicide, and brought to notice of this court paragraph number 7 and 8. The counsel also brought to notice of this court the judgment of 2024-10 SCR 54. Parveen Kumar versus State of Himachal Pradesh, wherein also discussion was made with regard to the presumption is concerned, and brought to notice of this court discussion made in paragraph number 8 with regard to the 498A of IPC. It is discernible that the word cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide. Any willful conduct which is of such a nature as is likely to cause grave injury or danger to life, limb or health of the woman, and harassment of the woman with a view to coercing her, any person related to her, to meet any unlawful demand. And detailed discussion was made even with regard to section 113A of Evidence Act. The counsel appearing for the respondent also brought to notice of this court the judgment of the apex court passed in criminal appeal number 5560 5561 of 2024, delivered on January 29th of 2025, and brought to notice of this court paragraph number 39, wherein extracted paragraph number 12 of the judgment of Bindeshwari Prasad Singh versus State of Bihar with regard to the jurisdiction of the revisional court, and wherein held that it is neither possible nor advisable to make an exhaustive list of circumstances in which exercise of revisional jurisdiction may be justified, but decisions of this court have laid down the parameters of exercise of revisional jurisdiction by the High Court under section 401 of Code of Criminal Procedure in an appeal against acquittal by a private party. The counsel also brought to notice of this court the paragraph number 40, wherein also discussion was made Joseph Stephen and others versus Santana Swami and another, reported in 2022 within bracket 13 SEC 115, and plain reading of subsection 3 of section 401 of CRPC, wherein also discussion was made with regard to the scope of the revision, even if court comes to the conclusion that court cannot convert the same into conviction, only to remit the matter to the trial court if any perverse finding is found. And also brought to notice of this court paragraph number 42, wherein also same discussion was made. The counsel also in his argument would vehemently contend that scope of revision is very limited, and if any perversity found in the appreciation of evidence, only court can interfere with the exercising of revisional jurisdiction, and hence no ground is made out to exercise the revisional jurisdiction. Having heard the appellant counsel and also the counsel appearing for the respondent accused, and also considering the grounds urged in the revision petition as well as oral submissions as well as principles laid down in judgments referred supra by both the counsel, the point that would arise for the consideration of this court, whether the trial court committed an error in acquitting the accused and whether this court can exercise the revisional jurisdiction, having noticed any perversity in the reasoning of the trial court. What order? Having heard the respective counsel and also on perusal of material, it is not in dispute that the victim mother died on 16/8/2005 and immediately body of child was found on the very same day. And body of the mother was recovered on 22/8/2005 after almost 6 years, 6 days. It is also not in dispute that immediately after the incident, complaint was lodged by the father in terms of Exhibit P15, wherein also no any allegations are made against the husband and only it is stated that both of them were cordial. But she committed suicide. She also caused death of her child and hence invoke and requested to invoke the offense of murder. But the fact is that the child was aged about 2 years is also not in dispute at the time of death. It is also important to note that mother also gave the complaint subsequently and the same is marked as Exhibit P1. It is important to note that when the PW1 was examined, having considered the earlier complaint of Exhibit P15 and also Exhibit P1, there is an improvement in the subsequent complaint of the mother which is marked as Exhibit P1A, wherein an allegation of extramarital relationship with accused was attributed by the PW1. In the cross-examination of PW1, it is illustrated that both of them are visiting their house once in a month and they are coming in the bike. And also it is important to note that the trial court also taken note of answer illustrated from the mouth of the PW1 for having demanded 17 ತೊಲಾನ ಗ್ರಾಮ್ ಅದು
ಅಲ್ಲಿ ತೊಲಾ ಅಂತಾರೆ.
ತೊಲಾನ 17 ತೊಲಾ of gold, and when the same was did not return, a complaint was lodged and the same is also discussed by the trial court while considering the material on record. It is also important to note that and having perused the material on record and a reassessment of evidence, no material found against the accused number 2 mother-in-law except stating that she is extracting the work from the deceased other than the wife of another son Karnataka. And only with regard to the extramarital relationship is concerned, the prosecution relies upon the evidence of PW2 who is the neighbor. And no doubt PW2 neighbor deposes that deceased was expressing the same with her about extramarital relationship. But in the cross-examination categorically admitted that they were not accused and their family were not in cordial terms for more than 10 years. And hence it is clear that there was an animosity between the accused and PW2. Even in the evidence of PW1 also, PW3, father of the deceased also categorically admits in the cross-examination that when the complaint was given on 16/8/2006, not suspected anything about any of the person, even stated before the police that both of them were cordial. And also document was confronted and Exhibit D1 also marked. And also in the cross-examination stated that his daughter might have been died on account of accidental death along with mother. And the same is found in the paragraph number 8 of evidence of PW3. And the trial court also taken note of even spot measure. And no doubt brother of the deceased also given evidence stating that he came to know about the illicit relationship and the same was brought to the notice of him. But he has taken, he told that he would inform the same to Karnataka. But the fact is that he categorically admits in the cross-examination that he himself and his father went to the Sulya police station. On the very same day, they lodged the complaint at 4:30. But in the complaint given by the father, there was no any accusation against the husband, that is accused number 1, and having reassessed the evidence of PW 5 and 6 also, they are the neighbor and villagers, and their evidence is also unequivocal that they came to know about the same, that villagers are talking about the same. And PW 6 says that the accused was visiting the house of woman Srila, but in the cross examination, he also categorically admits that he was having grudge against the said Sushila. And when such evidence available before the court, and when the trial court also, considering the material available on record, when the same is not corroborative with each other, and also found the animosity with the prosecution witnesses, and at the first instance, the complaint lodged by the father, nothing is suspected, and even answer elicited from the mouth of the father is very clear that it may be a accidental slip. And also in paragraph number 43, trial court taken note of spot measure dated 17/8/2005, and the same is extracted. There is a mark of slipped from the place of incident, and the same is discussed in paragraph number 44, and also taken note of in paragraph number 45. PW1 also admits with regard to her daughter used to visit Payaswini river in order to run the pump. And same is also discussed when the relationship between the accused and deceased Rasmi were cordial as per the version of the very parents of the deceased as per earlier complaint, then the question of either ill-treating or harassment doesn't arise, and also no other allegation of any demanding of the money or anything subsequent to the marriage. And when such material available on record, and in order to invoke the offence under section 498A, there must be a cruelty, as well as there must be a proximity to cause of death to invoke section 306, to take extreme step of committing suicide. No doubt the child and mother lost their life, and in the absence of any cogent evidence before the court, and also trial court has not committed any error in appreciating the evidence, and finding of the trial court is also not perverse. And when such being the case, the question of exercising the revisional jurisdiction doesn't arise. No doubt the counsel appearing for the revision petitioner relied upon the judgment referred supra with regard to the illicit relationship which leads to taking of extreme step, which also amounts to a 498A and 306 as held by the apex court. But in the absence of any cogent evidence established that there was an illicit relationship between the accused as well as other two women with regard to the extramarital relationship, and even observation made by the apex court also very clear, his illicit relationship would have definitely created psychological imbalance to deceased, which led her to take extreme step of committing suicide. But in the absence of corroborative evidence before the court, and that too evidence relied upon by the prosecution witnesses also hearsay, and only speaks about talking in the village, and PW2 categorically admits the ill will between the accused and PW2, and so also PW6 also admits ill will with the one of the woman. And when such material available on record, I do not find any error committed by the trial court. The scope of revision is also very limited as contended by the counsel appearing to the respondent, and in the absence of perversity, question of setting aside the order also doesn't arise, and even for remitting the matter also there are no material, and hence I answered the point as negative. In view of the discussions made above, I pass the following order. Revision petition is dismissed.
Grateful.
Next. Sorry, Amicus Curiae ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ Amicus Curiae ಇದೀರಾ ಮೇಡಮ್? Amicus Curiae ಫೀಸ್ ಬೇಡವಾ? ಹಂಗೆ ಹೋಗ್ತಾ ಇದ್ದೀರಿ? ತಗೊಳ್ಳಿ. The revision petitioner counsel is appointed as Amicus Curiae, and the counsel also assisted the court and hence registry is directed to pay the fee of rupees 5,000 to the amicus curiae.
Passed on matter, list 1, serial number 6, Dilraj Rohit, my lord. Pay ಮಾಡಿ.
Counsel submits that balance amount of bond amount.
Balance amount.
Balance in bond amount enri. Balance bond amount of rupees 25,000 is paid. Next ಏನಾಗಬೇಕು? ಎಲ್ಲ ಕ್ಲಿಯರ್ ಆಯ್ತಾ ಬಾಂಡ್ ಅಮೌಂಟ್ ಏನು? ಏನಾಗಬೇಕು ನೆಕ್ಸ್ಟ್? ಅಡ್ಮಿಟ್ ಆಗಿದೆ. ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್. ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. 2013 ಮ್ಯಾಟರ್ 22/4 ರೆಡಿ ಆಗಿ ಬನ್ನಿ. ಅವತ್ತು ಮತ್ತೆ ಟೈಮ್ ಕೇಳಂಗಿಲ್ಲ. 9 ಕುಲಕರ್ಣಿ ಅಬ್ದುಲ್ ರಶೀದ್ ಸಿಕಂದರ್ ಸಾಬ್. ಏನ್ರಿ ಇದು? ಏನಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತು?
Matter my lord, last day I had submitted that. My lord, there are 5 connected matters in this. First matter was already dismissed on merits. For my lord's.
ಮೊನ್ನೆ ಹೇಳಿದ್ರಲ್ಲ ಅದ? ಸೇಮ್ ಸಿಮಿಲರ್?
Similar my lords. Common judgment. Though it is not different.
Earlier it was common judgment.
Not common.
ಹಾಗಾದ್ರೆ ಇದನ್ನ ರೆಫರ್ ಮಾಡಿ ಹಾಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ ಸಾಕಾ? There are no grounds ಅಂತ?
My lord, it is already decided. Same grounds only.
This matter is listed for furnishing a PF along with copy of appeal, and counsel for the appellant placed on record the similar matter was disposed of by this court in criminal appeal number 38 of 2019 with order dated 23rd day of January 2020. The counsel also brought to notice of this court paragraph number 13 wherein discussion was made with regard to question is as to whether the accused has issued the said checks towards the legally enforceable debt. This court observed that in this regard the accused have got marked 2 sale deeds exhibit D1 and D2 through PW1. The said sale deeds are executed by the complainant and his daughter in favor of one Mr. Khalil, N. Khalil, and one Mr. Farooq in respect of the same property. It is also clearly mentioned in the said sale deeds that the vendors have received the full sale consideration and they have acknowledged the receipt of the same. The execution of the sale deeds in respect of those persons have been admitted by PW1 in his cross-examination. The contention of the learned counsel for the appellant is that the said 2 persons are the nominees and therefore the balance sale consideration is supposed to be paid by the accused in terms of the sale agreement at exhibit P6. Though there is a mention in clause number 7 of the sale agreement exhibit P6 stating that vendors have agreed to register the sale deed in favor of the purchasers or as nominees of the accused, however, there is nothing to show that persons mentioned in the sale deeds are the nominees of the accused. When it is clearly mentioned in the sale deed marked as exhibit D1 and D2 that the vendors have received full sale consideration and they have acknowledged the receipt of the same, then, it cannot be said that amount mentioned in the checks said to have been issued by the accused are legally enforceable debt as claimed by the complainant. This court also taken note of 313 statement of the accused. Accused has answered the question number 6 stating that the complainant assured to give the site, however, he did not. That this court having considered the material available on record, particularly the recitals of document exhibit D1 and D2 in the names of 2 persons and received the full sale consideration, and comes to the conclusion that therefore cannot claim the balance sale consideration is liable to be paid by the accused in terms of the checks issued by him and dismiss the same. When similar issue was arisen.
Page number 3, my lord, my condition.
Yeah, page number 3.
Number 3 of the order. Bill 38 of 2000. That is second check is the present, that is involved in the present case.
This is in respect of?
Present case, the present case. 132,485 is the present check.
485.
485.
In this case also, the amount mentioned in check number 132,485 for a sum of rupees 20 lakh, correct?
Yes.
Correct. And when similar issue was taken note of, and also this court comes to the conclusion that recitals of exhibit D1 and D2 is very clear having received the entire sale consideration. And question of admitting this appeal and doesn't arise, and hence I do not find any merit in the appeal to admit the same, and hence appeal is dismissed.
Seal number 10.
Mahantesh Hiremat,
please, my lords. Amendment has been carried out.
Carried out. The counsel for the appellant submits that he has carried out the amendment and filed the amended appeal memo. Appeal memo hakidra ande.
Yes,
process?
ಅದು ತುಂಬಿದ್ದೀನಿ.
And also submit that he has paid the process also. And hence issue notice against ಯಾರಿಗೋ book notice.
Respondent number 2 ಮೇಲೆ 15.
Respondent number 2 ಗ ನಿಮಗೆ notice ಆಗಿದೆ already? ಆಗಿಲ್ಲ. ಆಗಿಲ್ಲ. Additional ಆಗಿದೆ ಮೇಡಮ್? ಆಗಿದೆ ಅಂತಲ್ಲ. ನೀವು ಆಗಿದೆ ಅಂತೀರಾ ಅವ್ರು ಆಗಿಲ್ಲ ಅಂತಾರೆ. ಏನ್ ಹೇಳ್ಬೇಕು? ಏನ್ ಬರಿಬೇಕು ನಾನು ಆರ್ಡರ್ ಹೇಳಿ? ಆಗಿದ್ರೆ ಸರಿ. ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನಾಯ್ತು ಇದು? ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ಅದಕ್ಕೇನೋ ವೆರಿಫೈ ಮಾಡ್ತೀವಿ ಇದ್ರಲ್ಲಿ ಏನಾಯ್ತು?
The connected matter itself, your lordships.
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 1777 ಅಲ್ಲಿ ಏನಾಯ್ತು? ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಬರ್ಲಿಲ್ಲ?
They have informed that they have not
ಆಯ್ತು.
received the
ಕನೆಕ್ಟೆಡ್ ಅವೈಟ್ ರಿಪೋರ್ಟ್ ಆಫ್ ನೋಟಿಸ್ ಅಗೇನೆಸ್ಟ್ R2 ಅಂತ ಹಾಕಿ ಒಂದು ಡೇಟ್ ಕೊಡಿ ನೋಡೋಣ. ನಿಮ್ದು ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ 22/4
ಪ್ಲೀಸ್.
ಯಾವ್ದು ಪಾಸ್ ಓವರ್ ಇದ್ದಾಗಿಲ್ಲಲ್ಲ? ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಆಗಿದೆ ಆದ್ರೆ ಮತ್ತೇನಿಲ್ಲ. ಆಯ್ತು. ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ RFA 39 ಏನ್ರಿ ಇದು?
Can you recollect that? This is suit for partition by law. That
ಇದೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಆಗಿದೆ ಏನೋ
ಆಗಿತ್ತು ಸ್ವಾಮಿ. ತಾವು ಅದು
ಜಜ್ಮೆಂಟ್ ಗೆ ಹೋಗಿತ್ತು. ಜಜ್ಮೆಂಟ್ ಗೆ ಹೋದ್ಮೇಲೆ ಏನೋ ನೀವೇನೋ
ಡಿಲೀಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು ಸ್ವಾಮಿ ಅದು ಪ್ರೀವಿಯಸ್.
ಆಯ್ತು ಈಗ ಅವ್ರನ್ನ ಈಗ ಪಾರ್ಟಿ ಮಾಡಿದ್ರಿ.
We have made them party.
ಮತ್ತಿಂದೇನ ಬೇರೆ ಹೇಳೋದಿದೆಯಾ?
Nothing is there.
Nothing. ನಿಮ್ದೇನಾರು ಹೇಳೋದಿದೆಯೇನ್ರಿ?
Yes, I want to add something to the argument which I have already addressed. But taking note of the fact that there is some error in the application filed by the appellant seeking direction for scientific examination insofar as DNA profiling of the appellant, the respondent number 2, and one among the legal representatives of the defendant number 1. Lord, the
arguments of respondent ಹೇಳಿ ಏನು ಅಡಿಷನಲ್ ಗ್ರೌಂಡ್ಸ್? ಎರಡು ನೋಟ್ಸ್ ಮಾಡಿದೀನಿ earlier ನೀವು ಇಬ್ರು ಹೇಳಿದ್ದನ್ನ. ಈಗ ಏನಾದ್ರು ಅಡಿಷನಲ್ ಹೇಳೋದಿದ್ರೆ ಹೇಳಿ.
ಹೌದು. ಒಂದು in fact I have brought to the notice of my lords regarding two judgments of the apex court wherein
regarding DNA test ಇರಬೇಕು.
Yes. Yes.
2022
one second.
para 9 11 14 ಆಮೇಲೆ ಮೂರು ಇನ್ನೊಂದು ಮಿಯರ್ ಆಸ್ಕಿಂಗ್ ಕೆನಾಟ್.
Yes, Ashok Kumar
DNA
Raj Gupta.
No prima facie case.
And this is Aparna Ajinkya Firodias, 2 cases. As my learned friend tried to impress upon this honorable court by producing a judgment passed by this honorable court in writ petition Chandru versus Kucharayappa. At that point of time, I have not gone through this judgment and
citations.
I think it is produced. Two rulings, orders passed by coordinate bench of 1, and the
one is mine and another is another.
Someday judgment in fact it is recommended for reporting also. For the issue between a son who is alleging that he is fathered by the defendant number 1 in the suit for partition, wherein application for DNA profiling was requested and the same was favored, and no, in fact it was rejected, and on the writ petition filed before this honorable court, my lord has taken note of the proposition of law laid down by the honorable apex court. In fact, it is a little bit exhaustively done judgment. Ultimately, having noticed the facts of the said case,
it depends upon each case.
Of course, my lord. So here what happens? The plaintiff therein has contended that the defendant number 1 was his father, whereas his mother was not alive as on the date. And there was a contention taken by the defendant number 1 that some other person on Basappa by name was the father, and his mother has also availed the terminal benefits of the deceased Basappa. And accordingly, there was a serious dispute insofar as the alleged relationship that the plaintiff tries to establish before the trial court. my lord has come to the conclusion that while answering in favor of a DNA test, wherein the application was rejected, my lord, at para 22, it is also important to note that when the defendant number 1 especially specifically denies that he is not his son, and also specific defense he has taken, he is the son of Basappa Jadar and he has to prove the same, and mere taking defense is not enough. At page 19, internal page 19, para 22. And further, my lord has gone further. In the case in hand, the plaintiff, in order to prove his contention, he sought for DNA test, and DNA test is not only substantial piece of evidence, and this said DNA test will come to the aid of the petitioner in order to prove the claim. The fact that he alleged that the defendant number 1 is his father and he has to prove the same. If the same has not been proved, one of the factors goes against him in the suit relief for partition and separate possession. When such being the case, the trial court ought to have taken note of the said fact into consideration, and instead of committing, an error in coming to the conclusion that burden is on the plaintiff to prove that he is not the son of Basappa Jadar and Somamma is not the wife of Basappa Jadar, and also plaintiff has to prove that he is the son of defendant number 1 through his mother Somamma. A negative inference cannot be drawn. That's the opinion taken. When the plaintiff himself is ready to take the result of DNA test, whether he would be called as bastardized in future or not, under such circumstances, the trial court ought to have allowed the application and committed the error in rejecting the application. Well, by holding that, so my lord, your lordship has allowed the application. My lord, taking into consideration the consistent flow of law, the Honorable Apex Court has
ಏನಾಗಿದೆ ಅಂದ್ರೆ ನೆಗೆಟಿವ್ ಆಗಿ ಪ್ರೂವ್ ಮಾಡಬೇಕು ಅಂತ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ, and that is the reason only the court comes to such a conclusion. It depends
so far
upon
as
the facts and circumstances of each case, whether the judgment of Apex Court applies or not ಅನ್ನೋದು ಅಷ್ಟೇ question.
So far as my lord,
I did this in Dharwad bench.
ಹೌದು, ಧಾರವಾಡ bench ಅಲ್ಲಿ September 27th. So far as the present set of facts are concerned, my lord, I would conveniently like to make submission that the proposition laid down by your lordship will not be applicable to the facts of the case.
ನೀವು distinguish ಮಾಡಿದಿರಿ ಈಗ.
Please.
Next.
My lord, the thing is here in commonality, majority of the disputes arose wherein the DNA profiling coming to picture. My lord, it is between father and son. The son or daughter represented by the mother, wherein the husband alleges fidelity quotient. In those cases, and section 112, what it presupposes, non-excess. Non-excess is the predominant factor which would attach, because paternity is one aspect and legitimacy is other aspect. In the recent judgment in January this year, my lord, the Honorable Apex Court has, in an exhaustively dealt judgment, has rendered that by considering, Firodia's case, which I have already cited, Lord, it says, unless it is discharged in accordance with the proposition which is found in 112, my lord, it says that it gives primacy to the presumption attached under, this is the recent one, court officer. But the facts of this case is, a mother has filed a petition representing her minor son, contending that the defendant number 1 was his father and his name is required to be entered as father in the records pertains to her son. Lord, the mother of the appellant herein, was married to one Raju in 1989, and in 2006 there was a divorce by mutual consent, and this respondent was born during the subsistence of that marriage. There was no issue between legal father. What I wish to quote it, because and subsequent to the divorce between the mother and father, the mother only has approached the civil courts by filing a declaration suit that respondent number one is the father, and she has assigned, because before that she has approached the revenue authorities and she has given certain evidence. However, she was directed to approach the civil court to get a decree in that regard, because they cannot act unilaterally. And the case made out that particular person, I mean, her son was fathered by particular person. But earlier the application was rejected, which was conferred by the High Court, and thereafterwards, a petition for maintenance was came into picture. In that, there is a variation by the family court insofar as allowing, a petition for maintenance in which DNA test was ordered. But this time, the alleged father who has approached the apex court, which is a second round of litigation, and taking into consideration the flow of propositions from Gautam Kando till, this one, Aparna Ajinkya Firodia, which is the recent one, 2024 7 ACC. My lord, the Honorable Apex Court has formulated, while deciding this case, 2 points in the first paragraph itself, just above the facts. Second paragraph, the first one, paternity and legitimacy are independent concept of law. Because this is the argument forwarded by the respondent's son, that both are though distinct, and insofar as his curiosity to know about the parentage, his parentage, then a order for direction to, submit to both the parties was imminent. Lord, here I would like to draw my lord's attention to the issues formulated by the apex court at page 7, C issues. Having given our thoughtful consideration to the submissions at length, the following issues arise for consideration to this court: whether the presumption of legitimacy, if not displaced, determines paternity in law. And the rest of two are, not applicable to our facts of the case. Next one, D1, displacing the presumption of legitimacy and permitting a DNA test. The issue herein is regarding the effect of conclusive presumption of legitimacy, how it can be displaced, and under what circumstances a court may order a DNA test. To this end, the appellant argued that the presumptions of legitimacy is conclusive until it is rebutted by leading evidence reflecting non-access between spouses when the child was begotten. Only when non-access is made out, the court may order a DNA test. The appellant further argued that the result of such a DNA test may bastardize an innocent child and violate the right of the privacy of dignity of the persons involved. An order for DNA test therefore must be resorted to sparingly. In support of these contentions, judgments, previous judgments of its own are referred. Per contra, the respondent argued that even in a positive finding by a court regarding the legitimacy of a child would not be sufficient to prove paternity for the purpose of maintenance. Further, the respondent argued that the courts have ordered DNA test because it is within the best interest of the child to know their biological father. In support of their contentions, the respondent cited decisions so and so, so and so. We are of the considered view that this issue hinges on two primary prongs requiring detailed analysis: difference between legitimacy and paternity, and consequently their circumstances under which the presumption of legitimacy is displaced to permit an inquiry into paternity, the exercise of balancing of interest, and evaluating the eminent need for a DNA test. Displacing the notion of legitimacy. The respondent has vehemently argued that legitimacy and paternity are different concepts, the former being rooted in law while the latter is rooted in the science. The High Court upheld this view and thereby permitted the revival of the maintenance proceedings as an inquiry into paternity and not legitimacy. In this vein, we agree that scientifically and technically a legitimate child, that is one born during the subsistence of a valid marriage between two persons, may not always be the biological child of the persons in the marriage. In our view, it would be possible to and easy to contemplate such a situation arising, which leads us to the postulation that more technical sense the terms legitimacy and paternity may indeed undertake different meaning. The question that, however, arises is whether the law contemplates and accepts such a differentiation. To answer this, we deem it appropriate to investigate the law governing presumption, legitimacy, and the paternity globally. My Lord, the apex court has taken note of the position in UK and United States and as well as in Malaysia. Why? Because 112 Indian Evidence Act is as if it is incorporated and adopted in by Malaysian Evidence Act 1950. But I would like to skip these two pages wherein the position, legal position is discussed. Now at page 12, so far as the position in India, having discussed at the page 20, para 25, 26 and 27, I would like to draw my lord's attention to para 28. The language of the provision makes it abundantly clear that there exists a strong presumption that the husband is the father of the child born by his wife during the subsistence of their marriage. This section provides that the conclusive proof of legitimacy is equivalent to paternity. So this is the one, the question posed by the apex court. Aparna Ajinkya Firodia is referred. In fact, my lord has also taken much about this judgment. The object of this principle is to prevent any unwarranted inquiry into the parentage of a child. Since the presumption is in favor of legitimacy, the burden is cast upon the person who asserts legitimacy to prove it only through non-access. It is well established that access and non-access under section 112 do not require a party to prove beyond reasonable doubt that they had or did not have sexual intercourse at the time of the child could have been begotten. Access means merely refers to the possibility of an opportunity for marital relationship. To put it more simply, in such scenario, while parties may be on non-speaking terms, engaging in extramarital affairs, or residing in different houses in the same village, it does not necessarily preclude the possibility of spouses having an opportunity to engage in marital relationship. Non-access means the impossibility and not mere inability of the spouses to have marital relationship with each other. For a reason, for a person to rebut the presumption of legitimacy, they must first assert a non-access, which in turn must be substantiated by evidence. Well, this is where the point I am asserting in my case. Taking into consideration the next para 30, it is only when such assertion is made that the court can consider the question of ordering DNA test to establish paternity. In Gautam Kandu, so and so, this court laid the following parameters to decide whether a court can order a DNA test for purpose of section 112. The courts in India cannot order blood test as a matter of course. Whenever applications are made for such prayers in order to have roving inquiry, the prayer for blood test cannot be entertained. There must be a strong prima facie case in that the husband must establish non-access in order to dispel the presumption arising under section 112 of the Evidence Act. The court must carefully examine as to what would be the consequence of ordering the blood test, whether it will have the effect of branding a child as a bastard and the mother as an unchaste woman. At para 31, the parameters have been subsequently followed by this court in so and so. So for women, in these cases, it was held that DNA test may be ordered only if a strong prima facie case of non-access is made out with sufficient material placed before the court to arrive at a decision. The rest of the portion I would like to skip, my lord. Para 33, in our considered opinion, the challenge raised before the High Court that the paternal legitimacy are distinct and independent concepts is a misdirected notion and it is liable to be rejected. The High Court's view that a paternity can be determined independent of the concurrent finding regarding the legitimacy of the child thus cannot be sustained. So this is the, opinion expressed by the Honorable Apex Court. Now, my lord, I would like to draw my lord's attention to page 17, D122, eminent need for a DNA test. When dealing with the eminent need for a DNA test to prove paternity, this court balances the interest of those involved in must be considered whether it is possible to reach the truth without use of such test. First and foremost, the courts must therefore consider the existing evidence to assess presumption of legitimacy. Kindly note, my lord, if that evidence is insufficient to come to a finding, only then should the court consider ordering a DNA test. Once the insufficiency of evidence is established, the court must consider whether ordering a DNA test is in the best interest of the parties involved and must ensure that it does not cause undue harm to the parties. There are thus two blockades to ordering a DNA test. First, insufficiency of evidence, and second one, a positive finding regarding balance of interest. By whom, Lord, the rest of the thing I would like to skip because the Honorable Apex Court ultimately has given primacy to the presumption attached under Section 112 of the Evidence Act. Even in Firodia case, my Lord, the husband has accepted that he will take that child as his, his own son, only for the purpose of, proving his doubt regarding fidelity of his wife. He has requested for a DNA test, which was favored by the family court, affirmed by the High Court. But however, Apex Court has, reversed it, giving primacy to Section 112 of the Evidence Act. My Lord, now the facts of the present case are that the plaintiffs are asserting that they are the daughters of one Ramaya, Ammayamma and Subbarayappa. But the original defendant, our father has not doubted whatever the assertions made by the plaintiffs. Our father, asserted before the trial court that no, my mother name is also Ammayamma, but my father name is Ramaya. So this is the specific contention taken, and further that apart from himself, he was also having one, sister by name Vasanti. But the PW5, who is examined on behalf of the plaintiffs, who is stated to be the nearest relative, she admits that this defendant number 1 was having a sister by name Vasanti. She died much prior to the initiation of this suit. But after the death of the defendant number 1, because what happened, my Lord, according to my instructions, there was a serious altercation taken place during the pendency of the civil court matter before the civil court, and he is being a sensitive person. He commits suicide by consuming poison on the very grave of his mother Ammayamma. So this is subsequently, my Lord, our mother, because the present respondents are the minors, and she has pursued with the case, and she has produced all necessary documents, including government records, cumulative records. SSLC marks card belongs to the defendant number 1, and other related documents issued by the local bodies, wherein consistently it is mentioned that the father name of the defendant number 1 is Ramaya. Well, now this is what my submission is, that when the defendants have proved successfully by placing all positive documents to establish that who is our grandfather, how come an application can be filed that too at this stage? Because the Apex Court has also taken note of, in Rajgupta's case, the time of filing of the application is also very much important. Wherein in that case, my Lord, parents are not there, and that was the dispute between brother and sisters. Sisters only have filed an application which was rejected by the trial court. And ultimately, Apex Court has come to the conclusion that when the plaintiff has established through evidence, documents, who is his father, then no need to resort to, making an order for, for a DNA test. So that is in Rajgupta's case. So here, my Lord, without making anything except producing 2 sale deeds and a will, an unregistered will. But the trial court has also discussed regarding dual persuasion of the matter by the plaintiffs, that at one stage they say that they are having, existing rights insofar as claiming partition. At the another stretch, what they claim is to 3/4 of the property is bequeathed in favor of the defendant number 1, and 1/3 portion is bequeathed in favor of her own daughter. Then the trial court has forced to make an observation that without making any prayer for cancellation of that will, even as on the date of filing of the suit, both the plaintiffs are not having any substantive right to claim partition in the scheduled property. So this is only a one property, 4060 site situated in Yelahanka. My Lord, the plaintiffs, except producing the oral evidence of herself as well as the PW 2 to 5, well, there is nothing on record. Whereas the defendants have proved beyond all reasonable doubt. My Lord, the documents, and these are all the state, related documents. And when such being the case, my Lord, there is no case made out by the appellant just because of their, doubts, confusions, conundrums, etc. We cannot be made as testing modules for clearing the whatever they have sought for. Lord, I may be harsh, I have sentiments as the appellants are concerned, but looking into, I mean, the flow of proposition that the apex court starting from Gautam Cartus in 1988 until today, my lord, the positive evidence that the defendants have produced definitely will dispel that there is no reason, occasion warrant for this honorable court to entertain an application. And before that, my lord, one application which is also pending for consideration is regarding amendment, which is filed by the appellants seeking to withdraw certain admissions.
Amendment.
Yes. One application is pending, which was filed long back in order to obviate 2009 ಅಲ್ಲೇ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಸಿವಿಲ್ ಅಂತ ಆಗಿದೆಯಾ?
2009 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
Not been acted upon.
ಅಲ್ಲ ಇರ್ಲಿ will acted upon ಅಂತ ಆಗಕ್ಕಾಗಿದೆ. It is not a partition deed. Though my lord, the proposed amendment, though the deceased Ammayamma had executed will in favor of the
ಗೊತ್ತಾಗ್ತದೆ ಹೇಳಿ. 348.
ಇಲ್ಲ ಒಂದು 5 ನಿಮಿಷ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ನಾನು.
5 ನಿಮಿಷ.
ಮೇ ಐ ಕಂಟಿನ್ಯೂ ಟುಮಾರೋ?
ಅದಕ್ಕೆ ರೆಫರೆನ್ಸ್
ಇಲ್ಲ ನಾಳೆ
ನಿಮ್ದು ಆಗುತ್ತಾ ಇನ್ನು ಆಮೇಲೆ? ನಿಮ್ದು 2 minutes.
ನಾಳೆ ಒಂದು 10 ನಿಮಿಷ ಅವಕಾಶ ಕೊಡಿ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ ಸರ್.
ಆಯ್ತು ತಗೊಳ್ಳಿ. The respondent counsel parted ಆಗಿದೆಲ್ಲ ಮೇಡಮ್?
ಹೌದು.
Heard further arguments of respondent counsel. This matter ನಾಳೆ ಆಗಲ್ಲ, ಮಂಡೆ. ನಾಳೆ ಲಿಸ್ಟ್ ಆಗೋಗಿದೆ. ಆಗುತ್ತಾ ಮೇಡಮ್? ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗಿದೆಯಾ? ಆಯ್ತು ಬಿಡಿ, ಮಂಡೆಗೆ ಹಾಕ್ಸಿ ಅಂತಂದ್ರೆ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇನ್ನೊಂದು ಯಾವ್ದು ಇದೆಯಲ್ಲ, 304A 308 ಜಗದೀಶ್ ಬಾಳಿಗ. ಯಾವಾಗ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಯಾವಾಗ? ಯಾರು ನೀವು ಅವ್ರು ಹೇಳಿದಾರಾ?
No, your lordships, state appeal for acquittal against acquittal. I'm ready, your lordships.
ಆಯ್ತು, ಯಾವಾಗ?
Tomorrow or Monday, any day is fine.
ಡೇಟ್ಸ್ ಕೊಡಿ ಮೇಡಮ್, ಯಾವಾಗಿದೆ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹೆಂಗಿದೆ?
9th ವರೆಗೆ ಜಾಸ್ತಿ ಇದೆ.
ಇಲ್ಲ 22nd ಕೊಡಿ ಅಷ್ಟೇ. ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇದು. ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕೊಳ್ಳಿ, ಬೇರೆ ಹೊಸ ಫ್ರೆಶ್ ಬೇಡ ಅಷ್ಟೇ. ಈಗ ಅಪ್ ಟು ಇದ್ರೊಳಗೆ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ? ಆಗಿದೆ. 22ಗೆ ಆಗುತ್ತೆ. 22/4
Lordships 2/5 short date.
ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
9th ವರೆಗೆ ಬೇಡ.
9th
ವರೆಗೆ ಬೇಡ.
9th ವರೆಗೆ ಬೇಡವಾ? 16th ಕೊಟ್ಟಿರಿ ನೋಡಿ. ಪಾರ್ಟೆಡ್ ಅಲ್ಲ 16/4
ಇರೋದು ಪಾರ್ಟೆಡ್.
ಅವು ಪಾರ್ಟೆಡೇನಾ ಇವೆಲ್ಲ?
41 appellants have concluded their argument.
ಆಯ್ತು, ನಿಮ್ ಸೈಡ್ ಆಗ್ಬೇಕಾ?
Please.
ಯಾವಾಗ?
Date may fix. Any date.
ಎಲ್ಲ ಜಾಸ್ತಿ ಇದೆ ರೀ, 16th 17th ಎಲ್ಲ ಹಾಕಿರಿ. ಎಲ್ಲ ಪಾರ್ಟೆಡ್ ತಗೊಳ್ಳೋಣ, ಬಾಕಿ ಫ್ರೆಶ್ ಏರ್ ಮಾಡೋದು ಬೇಡ. 9th ಕೊಟ್ಟಿರಿ.
But if one humble request.
9/4
It may be taken up at 2:30. Humble request.
ಯಾವಾಗ ಬೇಕು ಮತ್ತೆ?
9th.
9th
ಇಲ್ಲ. 9th ಬಿಟ್ಟು.
9th ಬಿಟ್ರೆ ಮತ್ತೆ ಡೇಟ್ ಇರೋದೇ ರಜಾ. 16th 16/4
Serial number 55.
42 ಪಾರ್ಟೆಡ್ ಇದು. 16/4 ಕೊಟ್ಟಿರಿ ನೋಡೋಣ.
42.
ಆಯ್ತು 17.
Serial number 42. May I request on 22nd if that's okay?
22nd ಆಯ್ತು. 22nd
Grateful.
22/4
55.
ಯಾವ್ದು ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ರೋಸ್ಟರ್ಲಿ ಎಲ್ಲ ಪಾರ್ಟೆಡ್ ಎಲ್ಲ ರಿಲೀಸ್ ಮಾಡೋಕೋದು. ಯಾಕೆಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದಿದ್ರೆ ಈ ರೋಸ್ಟರ್ ಮಾತ್ರ. will not carry any parted matter for next roster. ಆಯ್ತು.
Final hearing matter 43.
Final hearing.
Respondent.
Comments ಆಗಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ, ಇನ್ನೂ ಆಗಿಲ್ಲ.
22/4
44.
42 also 22/4
45.
45 also 2013 22/4 22/4 ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದೆಯಲ್ಲ?
46.
Respondent.
22/4
47.
ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ 12 13 ಎಲ್ಲ ರೆಡಿ ಆಗಿ ಬರಬೇಕು. ಮತ್ತೆ ಡೇಟ್ ನಾನು ಕೊಡೋದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ 47 2015 ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್ ಇದು.
ಇಲ್ಲ ಸುಮ್ಮನೆ we both are ready.
ಕೊಡಿ, ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. 23/4
Published.
48 ಗಿರೀಶ್ ಬಿ ಬಳದರೆ ಅಂಡ್ 2018 ಇದೆಲ್ಲ ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್ ಕೊಡಿ ಮೇಡಮ್.
49.
ಲಾಸ್ಟ್ ಎಷ್ಟು ಸರ್ ಅದು ವರ್ಕಿಂಗ್? 22nd ಇಲ್ಲ ಹಾಕಿರಿ ನೋಡೋಣ. 23rd ಹಾಕಿರಿ. 23/4 48
49.
Sachin BS 24-4.
Lords, ಅದ್ರಲ್ಲಿ it was listed day before yesterday. Lords, ಅದ್ರಲ್ಲಿ complainant party ಇಲ್ಲ ಅಂತ ಹೇಳಿ it was posted today, my lords.
ಯಾಕೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಬಂದಿದೆ?
Lords, in 2019 POCSO, my lords, 2019 there was no such directions.
ಅಯ್ಯ ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು?
I'll file an IA, my lords.
ಹಾಕಿಲ್ಲ ಇನ್ನು ನೀವು?
ಗೊತ್ತಿರ್ಲಿಲ್ಲ
ಮತ್ತೆ
after
ಹಾಕ್ಬೇಕಲ್ಲ? List this matter ಹಿಂಗ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. List this matter under the caption of consideration of IA number 1 of 25 ಅಲ್ವಾ?
ಮಂಡೆಗೆ my lords.
ಮಂಡೆಗೆ ಆಗಲ್ಲ. ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಇದೆಯಲ್ಲ, ಅದ್ರ ಜೊತೆಗೆ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ರೆ ಅದು ಬರುತ್ತೆ.
ಮಂಡೆ ಅಥವಾ ಟ್ಯೂಸ್ಡೇ my lords ಹಾಕ್ಬಿಡ್ತೀವಿ.
ಆಯ್ತು. 74
50
50
ಕೇಶವಮೂರ್ತಿ CN
ಕೇಶವಮೂರ್ತಿ CN ಇಬ್ರು ಇಲ್ವಾ? ಆಫ್ಟರ್ ಸಮರ್ ವೆಕೇಶನ್
51
ಯಾವಾಗ ಬೇಕು? ಆಫ್ಟರ್ ಸಮರ್ ವೆಕೇಶನ್ ಬಿಫೋರ್ 24-4 ಕೊಟ್ಟಿರಿ ನೋಡೋಣ. ಸಂಗಮೇಶ್ ಆಫ್ಟರ್ ಸಮರ್ ವೆಕೇಶನ್ ಬಿಫೋರ್
24
24
22nd or 24th.
24-4
53 acts ಅದು refer to ಲೋಕದಾಲತ್
3 ಲೋಕ ಅದಾಲತ್ ಹೋಗಿದೆ. 54
My lords, I appear for the appellant in this matter. NOC ವಕಾಲತ್ has been filed, my lords. ನಿನ್ನೆ NOC ವಕಾಲತ್
ಯಾರ್ ಪರವಾಗಿ ಹಾಕಿದಿರಿ?
ಅಂಗದ್ ಕಾಮತ್, my lords.
ಅಪಲೆಂಟ್ ಪರವಾಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪರವಾಗ?
Appellant, my lords.
ನಿಮ್ಮ ಹೆಸರೇನು?
My lords, the wakalat has been filed in my colleague's name, Mr. Angad Kamath. Shlok Angad Kamath, my lords. Angad Kamath.
Angad, counsel Angad Kamath submits that NOC wakalat is filed on behalf of the appellant.
Please, my lords.
And hence the registry is directed to put up the same and show the name of the counsel in the cause list for appellant and delete the earlier counsel advocate name. List this matter on 22-4.
Grateful, my lords.
55
ವಿಚಾರಗೊಂದು ಹೇಳಿ ಯಾವಾಗ?
40 lakh check out.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? 22nd? ಬಿಫೋರ್ ದಟ್ ಇಲ್ಲ, ಇರೋದೇ 3-4 ದಿವಸ ಇದೆ. 22-4 56 ನಿಶಿತ್ ಕುಮಾರ್ ಶೆಟ್ಟಿ ಯಾವಾಗ? ಆಫ್ಟರ್ ಸಮರ್ ವೆಕೇಶನ್? ಆಫ್ಟರ್ ಬೋಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ ಸಮರ್ ವೆಕೇಶನ್.
57
ಮಧುಕರ್ ಆಫ್ಟರ್ ಯಾವಾಗ? ಯಾವಾಗ ಅಂದೆ? ಆಫ್ಟರ್ ಸಮರ್ ವೆಕೇಶನ್. ಮುರಳೀಧರ್ HM ಶಂಕರ್ ನಾರಾಯಣ್ ಭಟ್ ಇದರಲ್ಲಿ ಆಫ್ಟರ್ ಸಮರ್ ವೆಕೇಶನ್. 59 ಇದು 2017 ಓಲ್ಡ್ ಯಾಕೆ ಇಲ್ಲಿ ಬಂತು ಮೇಡಮ್ ಕೊನೆಗೆ? ಇದ್ರಲ್ಲ ಆಯ್ತು. RP ಹೊಸದ? ಅದು ಹಳೆದೆ ಅಲ್ಲ, ಯಾಕೆ ಈಗ ಯಾಕೆ ಬಂತು? ಆಯ್ತು 17 ಇದೆ ಕೊಡಿ. 24-4 24-4 24-4 ಮುಗಿತಾ? ಹೇಳ್ರಿ ಏನು?
43 ಅಲ್ಲಿ ಪಾರ್ಟಿ ಇಲ್ಲ. ಸೀರಿಯಲ್ ನಂಬರ್ 43 my lord.
ಏನಾಯ್ತು?
ಆ ಪಾರ್ಟಿ ಇಲ್ಲ ಸುಮ್ಮನೆ ಕಾಸ್ಟ್ ಹಾಕಿದ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದ್ದೆ.
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು? 43 ಅಲ್ಲಿ ಆಗೋಯ್ತಲ್ಲ, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ನೋಡಿ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ 22-4 ಅಂತ ಇದೆ.
ಕಾಸ್ಟ್ ಪೇಡ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ದೀನಿ,
ರೆಡಿ ಇದೆ, ಪೇ ಮಾಡಿದ್ದೀನಿ.
43 ನಲ್ಲಿ ಹಾಕೋಬಿಡಿ ಮೇಡಮ್. ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ that he has paid the cost of ₹10,000 by order dated 22/3/2020 in terms of the order dated 22/3/25. ಏನ್ ಮಾಡ್ಬೇಕು?
ಸಬ್ಮಿಷನ್ ಸ್ವಾಮಿ ಅವರು ಊರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ಎಲ್ಲಿದಾರೋ ಗೊತ್ತಿಲ್ಲ. ಸೊ ಕಾಸ್ಟ್ಗೋಸ್ಕರ ಫೋನ್ ಮಾಡಿದ್ರೆ ಹಳೆ ನಂಬರ್ಗೆ ಫೋನ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಆಗ್ತದೆ.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ಈಗ?
ಕೈಂಡ್ಲಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಫಾರ್ ಆಫ್ಟರ್ ಒಕೇಶನ್.
ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲ್ ರೀ, ಇಲ್ಲ ವಾರೆಂಟ್ ಹೋಗುತ್ತೆ ಅವತ್ತು ನೋಡೋಣ ಬಿಡಿ.
ಅವ್ರ ಕಜಿನ್
22nd ನೋಡೋಣ.
ಸ್ವಾಮಿ ಕಜಿನ್ ಭೇಟಿ ಮಾಡಿದ್ರು, ಕಜಿನ್ ಭೇಟಿ ಮಾಡಿದ್ದೆ. ಅದು ಕಾಸ್ಟ್ಗೋಸ್ಕರ ಕಾಲ್ ಮಾಡಿದ್ದೆ, ಫೋನ್ ಹತ್ಲಿಲ್ಲ, ಮನೆ ಹತ್ರ ಹೋಗಿದ್ದೆ. ಸೊ ಅವರು ಎಲ್ಲೋ ಟ್ರೀಟ್ಮೆಂಟ್
ಇಲ್ಲ ಅಂದ್ರೆ ಅವನ್ನ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡೋಣ. ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿ ಜೈಲಿಗೆ ಕಳ್ಸೋದು ಅಷ್ಟೇ.
List number 2 my lord.
ರೆಕಾರ್ಡ್ ಹಾಕೊಂಡಿದ್ದೆ
My lord, list number 2. List number 2. ಆಗ್ಬೋದು.
ಮೇಡಮ್
41 16
ಏನ್ ಬೈ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮತ್ತೆ
16 ಆಮೇಲೆ 22-4 ಸರ್ ಎಲ್ಲಾನು ಲಿಸ್ಟ್ ಬಿಫೋರ್ ಲೋಕ್ ಅದಾಲತ್ ಅಂತ ಆಗಿದೆ. ನೆಕ್ಸ್ಟ್ ಲೋಕ್ ಅದಾಲತ್ ಇದ್ದಾಗ ಅದನ್ನ ಅವರು ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ. ಅದೆಷ್ಟೆಷ್ಟು ಮಾಡ್ತಾರೆ, ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಅಂತ ನಂಗೂ ಗೊತ್ತಿಲ್ಲ ಸರ್. ಲೋಕ್ ಅದಾಲತ್ ಅಲ್ಲಿ ಕೇಳ್ಬೇಕು. ಲಿಸ್ಟ್ 2 ಎಲ್ಲಾನು ರೆಫರ್ ಟು ಲೋಕ್ ಅದಾಲತ್. ಅದ್ ಮೇಲ್ಗಡೆ ಇದೆ ನೋಡಿ ಸರ್, ಅದು ಎಲ್ಲಾನು ರೆಫರ್